B group onwards ಮಾತ್ರ. B group onwards. ಅದು ಮೈಕ್ ಆನ್ ಮಾಡಿ.
ಆನ್ ಆಗಿದೆ ಸರ್, ಮಾತಾಡಿ.
ಹಲೋ, ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್. ಸರ್ B group
Hello.
onwards. B group onwards ಸರ್. ಮೆಮೊ ಅಲ್ಲಿ. ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ B group onwards.
ಹಾ, ಬಿ ಗ್ರೂಪ್. ಓಕೆ.
ಓಕೆ ಓಕೆ. ಎಸ್. ಇವತ್ತು ಲೈವ್ ಇದೆ.
ಕೋರ್ಟ್ ಡಿಸ್ಪ್ಲೇ ಹೊಟ್ಟೋಯ್ತಲ್ಲ ಯಾಕೋ ಸರ್? ಕೋರ್ಟ್ ಡಿಸ್ಪ್ಲೇ ಹೊಟ್ಟೋಯ್ತು.
ಸರ್ ನಾನೇ ಮ್ಯೂಟ್ ಮಾಡಿದ್ದೀನಿ ಸರ್.
ಹಾ, ಥ್ಯಾಂಕ್ ಯು.
10:30ಗೆ ಆನ್ ಮಾಡ್ತೀನಿ ಸರ್.
ಅಲ್ಲ, ನಾನು ಇದೇನಪ್ಪ ಹಿಂಗಾಗೋಯ್ತಲ್ಲ ಮಾತಾಡ.
ಏನಿಲ್ಲ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಎನ್ಕ್ವೈರಿ ಮಾಡಿ ಗ್ರಾಂಟ್ ಯಾರು ಜಿನೇನು ಒಟ್ಟು 1 to 5 ಆಗ್ತಾರೆ. ಮೋಸ್ಟ್ಲಿ 1 to 5 itself is done only to ಅದಾದ್ಮೇಲೆ ಇಷ್ಟು ಜನ
ಎಕ್ಸ್ ಸರ್ವಿಸ್ ಮ್ಯಾನ್ ಪಾಪ ಹಾಸ್ಪಿಟಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದಾರೆ, ಅದಕ್ಕೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ.
ವಾಪಸ್
GML ಹಾಕ್ಬೇಡ. ಬರ್ಲಿ
ಏನಾಗಿದ್ದು ಹೌದು ಆಮೇಲೆ ನಿಖಿನಂದ ಅವ್ರದ್ದು ಎಲ್ಲಾರ್ದು ಗ್ರಾಂಟ್ ಚೆಕ್ ಮಾಡ್ಬಿಟ್ಟು ಯಾರು ಇದೆಯೋ ಅವ್ರು
ಯಾರು ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಇವರೇ ಕೊಡ್ತಾರೆ, ಅವರು ಗಲಾಟಿ.
ಆಲ್ರೆಡಿ ಇಷ್ಟು ಜನ ಅವರು ಗೊತ್ತಾದ್ರೆ ಇಷ್ಟಿದೆ, ಬಟ್ ಬರ್ತಾ ಇದೆಯಾ?
ಬರೀ ಫೈಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ ರಿಮೈಂಡ್ ಮಾಡ್ಬಿಟ್ಟು ವೆರಾಸಿಟಿ 1 to 5 ಮಾಡ್ಬಿಟ್ಟು ಯಾರಿಗೆ
ಏನಾಗಿತ್ತು?
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ತೀರಾ, ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀರಾ ಅವ್ರ ಲಿಸ್ಟ್ ಕೊಟ್ಟರೆ ಅವ್ರು ಇನ್ನೊಂದು ಪಬ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸೆಕೆಂಡ್ ಡಿನ ತಗೊಂಡು ಹೋಗ್ಬಿಡ್ತಾರೆ. ನಿಮ್ಗೆ ನೋಡೋಣ, ಕಂಟೆಸ್ಟ್ ಮಾಡೋಣ. ಮಿಸ್ಟೇಕ್ ಮಾಡ್ಕೋಬೇಡಿ, ನಾವು ರೆವೆನ್ಯೂ ಅವರಲ್ಲ. ಅಪೀಲ್ ಇನ್ನೂ ಡಿಸೈಡ್ ಆಗಿಲ್ಲ. ಡಿಸೈಡೆಡ್. ನೀವು ರೆಸ್ಪಾಂಡ್ ಮಾಡಿಲ್ಲ, ನೀವು ಅಪಿಯರ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದೀರಾ, ನಿಮ್ಮ ರಿಪ್ಲೈ ನೋಡಿನೇ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದೆ ಅಲ್ವಾ? ವೈಲೇಷನ್ ಆಫ್ ಪ್ರಿನ್ಸಿಪಲ್. ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ, 3 months is the rules. 30 days your chance ಅಲ್ವಾ? ಫಸ್ಟ್ ಗೆ ಸರ್
ಮಿಷನ್ ಮಾಡಿ ಸೀನಿಯರಿಟಿ ಅಂದ್ಬಿಟ್ಟು ಡೇಟ್ ಕೊಡ್ಬಿಡವ. ಹೇಳಿರಾ ಲೈವ್ ಇದೆ.
May please, your lordship, an urgent matter relating to aircraft stationed abroad, my lord, attachment. May list it to tomorrow, man. Much.
Tomorrow ಆಗುತ್ತಾ? Tuesday ಅಲ್ಲ, ತಗೊಳ್ಳಿ ಸಾಕು.
Please.
Old matter. Prop-
He has been granted by this another court, my lord.
ಅಲ್ಲ, end of the list ಇದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಿಯಪ್ಪ, ಇಲ್ಲದ್ರೆ ಕೊಡಿ ಮೆಮೋಸ್.
Enter the list, my lord.
One urgent.
This is third time I'm moving this memo, my lord.
ಏನ್ ಹೇಳಿ? ಆಯ್ತು, tomorrow ಮಾಡಿ ಅದು. Tax matter.
Lords, one submission, KLR matter, my lords, the petitioner is an ex-serviceman. Lords, his
It's
application.
alright ಅಪ್ಪ, ಬರುತ್ತೆ. ನೀವು ರೋಸ್ಟರ್ ಎಂಡ್ ಅಲ್ಲಿ ಈ ತರ ಮೂವ್ ಮಾಡ್ಕೊಂಡು ಕೂತ್ಕೊಂಡ್ರೆ
Property is intent to acquire.
Some urgency. my lord.
it's alright, doesn't matter.
Property is intent to acquire some, kindly to put it tomorrow.
ಹಾ?
Property is intent to acquire for industrial.
ಅದೇನಿದು acquire ಏನೋ
My lord, there
ಮಾಡ್ತೀರಾ?
is urgency in the matter, my lord. The
Word
publics are
matter, word
disposing me
matter,
from the suit certificate.
word matter.
ಕೊಡಿ,
I
ನಾಳೆ
have to- Tomorrow, my lord.
Tomorrow.
ನಾಳೆ ತಗೊಳ್ಳಿ.
ನಾಳೆಗೆ ಹಾಕ್ತೀನಿ.
ಅದು ಇವತ್ತು
Tomorrow.
ನಾಳೆ ತುಂಬಾ ಮ್ಯಾಟರ್ಸ್ ಇದೆ.
ಅಲ್ಲ,
tomorrow ಹೇಳಿದ್ದಾರೆ ನೋಡಿ.
ಅಷ್ಟೇ.
Sir, tomorrow
End of
take
the
the
list, my lord, there is a threat,
My lord.
notice has been issued
Again,
for
they are
demolition.
getting
my lord.
seniority, my lord. This is the third time I'm moving, my lord. There is a dispossession from suit settled property, my lord. They're destroying the agriculture property, my lord.
ಅಕ್ವಿಸಿಷನ್ ನಮ್ಮಂದೆ ಎಲ್ಲ
All
ಬರುತ್ತೆ.
acquisition process, acquisition alla. My application has been pending and this one court has been granted to stay, my lord.
ನಾಡದಕ್ಕೆ ಹಾಕಿ.
My lord, tomorrow, my lord, please, my lord.
ನಾಳೆ ತುಂಬಾ ಮ್ಯಾಟರ್ಸ್ ಇದೆ, ಅದಕ್ಕೋಸ್ಕರ.
My lord,
ಆಲ್ರೆಡಿ ವಿ ಆರ್ ಹ್ಯಾವಿಂಗ್ 1890 ಮ್ಯಾಟರ್ಸ್.
end of the list, my lord.
ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಇಲ್ಲ, ಸಾರಿ.
My lord, no, there is a threat of demolition, my lord, because the
ಡೆಮಾಲಿಷನ್.
property is situated in the municipal limits, my lord. The Tahsildar has issued a notice stating that there is an encroachment over Karab land. 7 days notice has been issued, my lord. We have even
End of
given
the
reply,
list.
my lord.
ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಇಲ್ಲ, ಹೇಳಿ ಮೇಡಮ್, ರೀಸನ್ ಹೇಳಿ.
ನನ್ನ ಪ್ರಾಪರ್ಟಿನ ಸ್ಮಶಾನ ಜಾಗಕ್ಕಾಗ್ಲಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ರೆಸ್ಪೆಕ್ಟ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಮೇಡಮ್.
My lord, on tomorrow, day after tomorrow, my lord.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಆಗುತ್ತೆ, ತಗೊಳ್ಳಿ.
Day after tomorrow.
ಆಯ್ತು, ಎರಡೇ ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ತಗೊಳ್ಳಿ.
Big group matters, adjournments, number 50 to 52, 50ರಿಂದ 52.
Serial number 50, my lord. I am for the
Number
respondent number
47.
3, my lord. There is settlement talk is going on, my lord. Kindly have the application for this.
After vacations, date given accurate,
Settlement
unless the other, if the other side comes and
other side ನವರೇ proposal ಕೊಟ್ಟದ್ದು ಅವರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೆ.
ನೋಡ್ರಿ, ಅವ್ರು ಬಂದು ತಕರಾರು ಮಾಡಿದ್ರೆ I will hear the matter.
Please, my lord.
Yes.
My lord, serial number 47.
47 ರೀಚ್ ಆದಾಗ ಹೇಳಿ.
53 to
Only,
58,
ರೇ 47 ರೀಚ್ ಆದಾಗ ಹೇಳ್ರಿ, ಓನ್ಲಿ ಬಿ ಗ್ರೂಪ್ ಅಂಡ್ ಆಫ್ಟರ್ವರ್ಡ್ಸ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್.
53 to 58.
58, my lord.
ಹಾ. ಆಫ್ಟರ್ ವೆಕೇಶನ್
53 lakhs. 53 lakhs.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಯಾವ್ದೇ ಮ್ಯಾಟ್ರ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡಿರೋದು ಆಮೇಲೆ ಆಪೋಸಿಟ್ ಬಂದ್ಬಿಟ್ಟು ತಕರಾರು ಮಾಡಿದ್ರೆ ಐ ಟೇಕ್ ಅಪ್ ದ ಮ್ಯಾಟರ್. ಐ ಡೋಂಟ್ ನೋ ಅನ್ಲೆಸ್ ಯು yes
53 after 59 to 64.
61, my lord. I am for the petitioner.
Madam, appear for respondent, my lords. It's,
61.
61 for respondent. Last time they have also taken time.
Problem is-
Last 3,
this person Umesh Mulimani, they have not conducted one case before me this roster, they will not conduct also.
my lord, they have
Notification.
taken time for last three occasional ಬೇಕಾರ್ ನೋಡಿ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ. This matter is of the year 1970, please, my lord. ಅವತ್ತಿಂದ ಇಲ್ಲಿವರೆಗೂ they are taking the time for
objection
unnecessary.
ಇದ್ರೆ no adjournment.
ಅಲ್ಲ, objection next week ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ. ಇಲ್ಲ ಸ್ವಾಮಿ.
Hey, objection ಇದೆ ರೀ, and this is not the first time you are asking for time. ನೀವೆಲ್ಲರೂ ನಿಮ್ ಕೊಲಿಗ್ ಬರ್ತಾರ? That lady comes usually. Not a single case you people have conducted before me this roster. I don't know what is the reason. You just keep taking time and seeking extension of interim orders. Yes,
Sir, records ಬಂದಿದೆ.
I will finish it if it reaches.
65 to 68. 69 to 75. 76 to 83. Up to 90, any adjournments? One,
Sir,
Bharat Kumar, read.
what is this, Bharat?
My lords, this is a
Valid statement of objection, my lord. What happened, my lord? We have issued after 30 days. We have issued bank attachment, my lord.
Hmm.
Since appeal period is, regular appeal period is over, my lord.
Hmm.
We have issued bank attachment and we got the amount also. It's cleared, 18 lakhs some change, my lord. Then after realizing bank attachment, my learned friend approached the first appellate authority, filed the application, then paid the 10% of the tax DD he obtained. The bank people informed our own LGSTO office only. One more duplication has issued notice. They thought mistakenly, they realized the amount. The learned friend has not made a party to the this writ proceedings. So we request, my lord, if just now if he made a party to the writ proceedings, maybe directed, we'll return back the amount, my lord.
No, there are
4
two-
lakhs some change.
There are two issues. First issue is, my lords, amount which was debited 4,83,294, which the learned AGA is saying she's ready to, the department is ready to refund it back to me, provided I make them a party. I am agreeable to that. But 18,56,742 was debited from my account in pursuance to an order dated 31/10/2023. It was done on, my lord, 6th of February. The time limit or the period which I can file an appeal is mentioned in 107, please, my lords. 107, says it is 3 months, which is expiring on 31/10/2024. And over and above, under 107(5), I am given an additional period of 30 more days. Now, that additional period of 30 more days, I have preferred the appeal, which is condonable by the first appellate authority. On 13/2/2024, I have preferred the appeal. Now, whether that period under which the extended period is also there, which is condonable, can they recover the amount or not under section 78 of the GST Act?
My lord.
Now, if I may make one second. Whether that 78, how it was interpreted has been, there is a judicial precedence, please, my lords. It has been stated that 78 must be,
Now, can't this matter be agitated before the appellate authority?
my lords, it cannot be, because only with respect to the amount, whether the legitimacy of the claim which is made or not in the adjudication can be done. But the period within which they can take that amount back cannot be adjudicated. That would be before, my lords, my lords. It was also before the coordinate bench of a high court, honorable high court, and they have held that 78 should be interpreted in a manner which should be
Yes.
before that period. If I may pass this judgment, please. Sir.
Go ahead.
Madam. The first para, please, minutes. This is a classic case of wireless overreach by the tax executive, recovering the assessed tax due just after a day of dismissal of the appeal, where there was further appeal provided in the tribunal before which such an appeal is to be filed was not constituted. It is similar, please, minutes. It was a second appeal. It stated at page number, internal page 6, please, minutes. Or para number 9, I would say, please, minutes, page 7. It is in this, the context was at next, previous this one, last 2 lines. Hence, when a proper appeal is instituted before the appellate tribunal with the payment as required for maintaining the appeal, then there is a statutory embargo from making a recovery based on the assessment order or the first appellate order. It is in this context that the provision of section 70.
Number?
So, please,
Paragraph number?
paragraph, my lords, it is, it starts at para 8 at page 5, but page 6, last 2 lines it may be seen. It says, may I read, please? Hence, when a proper appeal is instituted before the appellate tribunal with the payment as required for maintaining the appeal, then there is a statutory embargo from making any recovery based on the assessment order or the first appellate order. It is in this context that the provision to section 78 has to be looked at. Section 78 has been a nominal heading, initiation of recovery proceedings, and requires a tax person to satisfy an order passed under DGST.
A recovery order date?
Recovery order is dated 31/10/2023. It was done from the bank on 6th of February 2024.
6th of February,
2024.
what happened?
They withdrew the amount, 6th of February. Respondents.
Notice is issued, my lord. They are not contested.
One second, wait, madam. Time for filing the appeal with condonation.
It ends on 28th February 2024.
28,
February 2024.
24,
Or 2nd March, 30 days. February 28 ದಿವಸ ಇರೋದ್ರಿಂದ 2nd March.
2nd March.
2nd March 2020.
Provision of law.
107 subclause 1 and 107 subclause 107 subclause 4.
So 3 plus 1 month,
Please, 3 months plus 30 days.
then
My
11,
lord,
12,
if your
1,
lordship permitted, I will read, my lord. 4.
2.
The appellant authority may, if he is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period of 3 months or 6 months for department, as the case may be, allow it to be presented within a further period of 1 month.
Now what has happened?
It has been stayed.
Stay agidya.
Stayed.
No. Stay copy has not produced, my lord.
It is a, my lord's
Pending, my
statutory stay. My lord may see my lords may kindly see 107 subclause 7.
No, delay has to be condoned, no?
Delay has been and 107 subclause 7. It is a statutory stay. Once the appeal made, it is a statutory stay. There is no requirement of a stay.
No, not like that, Bharat.
This-
This is all right. 7 is all right, but the point is, for appeal to be admitted, has it been condoned? Delay has it been condoned?
I have been stated it has been. If my lords,
Verify it and.
it may be had to Thursday, please.
Thursday
my
I'll
lords.
have it.
Really.
See,
I'll give you the.
if
I will
it is,
also verify.
Stayed, refund is amount.
My lord.
See, if it is stayed, refund is amount. It's as simple
Much
as
obliged,
that.
my lord. I will verify, my lord.
Okay,
Much-
the criteria is have they deposited 10% of the amount.
Hmm.
10% of the dues, number one. Then second thing is, has the appellate authority stayed the recovery?
My lord, here one confusion, what happened, my lord? The 4 lakh my learned friend has took DD is realized by another office.
No, that I will make an amendment.
Whatever it is, set it right. And
that I
see, and probably both income tax and GST authorities will also now seriously look into the cyber fraud that is happening.
Yes, my lord, duplication is happening.
See,
Double,
we
double.
also are holding, not just duplication, madam, we are also holding so far service by email is sufficient. Okay. Probably the state has to have a relook at it now. Because you are not able to, or you should secure your website so well. See, it can't be a registered email ID under Gmail or Yahoo or Rediff or something like that.
Yes, ma'am.
You have to give your own, for example, with Kavach protection or something like that. What we have with regard to government,
Yes, sir.
something similar to it, you have to evolve. Otherwise, notices, everything will have to be personally served.
Yes, sir.
You say we leave a message, we call them, automated. See, with all these cyber frauds and other things happening, people are losing money, they are getting into traps by communications done electronically. And by pressing a button, they are losing in lakhs and crores.
Yes.
See, it's happening. See, what you are saying every time that you are saying it by email. We are accepting it. We are holding the notice to be sufficient. But the email is not secure enough. You can't blame them.
In the concept of digitalization, we are bound to send, my lord.
No. You may send it, but that is not sufficient service, probably. We don't know. I'm telling you, you probably need to have a relook at it.
What happen if we send manually, the address he will not be there. He will change the address, he will.
That's his lookout. That is
There is a
his lookout.
statutory,
That is his lookout. See, we had the concept of certified copy, all those things. Probably those things will have to come back now.
Yes, my
No,
lord.
there is a statutory requirement that they have a portal. They have to serve it only there, but still they are not doing it.
See, if you have a very, very secure portal, then they are registered under that. They have access to those portals because they are registered. Then probably service may be held sufficient. Yes.
Much of-
Thursday, please. My lord, sir, one sub. I may be permitted to implead the Assistant Commissioner of
To
Commercial
do what
Taxes.
you want, make applications by then.
They have agreed in their objections.
My lord,
You have to make applications.
I will.
You need to allow it.
I will. Thursday,
The request of parties call on Thursday. Date code.
published.
To VC Venkatesh.
Lord, appear for petitioner.
ಎರಡು ಬಂದಿದೆ. ಎರಡು.
Sorry. Lord, there is a mandamus direction. Lord, pursuant to the death of my lord petitioner husband, my lord, we sought for representation seeking my lord change of
Yes,
mutation entries in respect of 3 survey number.
Asking them to move the application through online before the Nadakachi. They have to mention the appropriate documents. They have to file an online application. ಅವ್ರಿಗೆ ಹೇಳಿ ಕಳಿಸಿದ್ರು ಅವ್ರು ಕೋರ್ಟಿಗೆ ಬಂದಿದ್ದಾರೆ. ನಾಡ ಕಚೇರಿಗೆ ಹೋಗಿ ಒಂದು ಅವ್ರ ರೆಲೆವೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಜೊತೆಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ
File it.
1 month ಅಲ್ಲಿ ಮುಗ್ದೇ ಹೋಗುತ್ತೆ.
Yes.
We'll file it.
The petitioner has requested respondent number 3 to mutate notice ಆಗ್ಬೇಕಾ?
ನೋಟಿಸ್
AG accept notice for respondent. ಆಮೇಲೆ judgment. The petitioners have requested respondent number 3 to mutate petitioner ಅಷ್ಟೇ. Petitioner has requested respondent number 3 to mutate her name in the revenue entries pertaining to the land which is the subject matter of the writ petition. On the ground that she has succeeded to the said estate on the death of her husband.
Please, my lord, her husband.
On the death of her husband. Full stop. As the same has not been done, the present writ petition is filed. Full stop. Next paragraph. The learned AG upon instruction submits that the petitioner is required to file necessary application online.
Yes,
Nada
online.
kacheri.
At Nada Kacheri along with necessary documents to establish the relationship.
Online file ಮಾಡ್ಬೇಕಾ?
Online.
Physically ಕೊಡಂಗಿಲ್ಲ.
ಗಣಕ ಶಾಖೆ.
Okay.
Digitalized.
Online along with all necessary particulars with the relevant Nada Kacheri, with the jurisdictional Nada Kacheri ಅಂತ ಮಾಡಿ. With the jurisdictional Nada Kacheri, and then the request of the petitioner will be considered on seniority basis.
Yes.
Full stop. Next one, the petitioner is agreeable for the same. Full stop. Hence the following order. Petitioner is permitted to file necessary application along with all necessary particulars online with the jurisdictional Nada Kacheri, and if the same is done, respondent number 3 is directed to consider the application of the petitioner in accordance with law and pass appropriate orders
3 months.
on seniority basis, but not later than 3 months from the date of such filing.
Please, Machu.
Writ petition is accordingly disposed of.
ನರೇಂದ್ರ
Fine.
ಕೂಡ.
Machu.
Petitioner fulfill, my lord.
Hmm.
Writ of mandamus,
Hmm.
seeking to conduct OD, my lord.
Yes, madam,
OD and trust, my lord. Will be considered.
will be considered. Application ಹಾಕಿದಾರಾ?
ಹಾಕಿದ್ದಾರೆ.
As
Yes,
per
AG
the-
accept notice for respondents. Order. The petitioner has requested respondent number 3 to conduct podi and durasti of the land, which is the subject matter of the writ petition, which according to him belong, which is the subject matter of the writ petition. As the same has not been considered, the present writ petition has been filed. Full stop. Next para. The learned AG upon instruction submits so that petitioner is required to file necessary application along with all the necessary particulars to respondent number 3
Please.
and also the jurisdictional ADLR,
ADLR.
Assistant Director of Land Records. And if the petitioner were to do the same, the podi durasti as requested by the petitioner will be done. Full stop. Next para. The petitioner is agreeable for the same. ನೀವು ADLR ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರ ನಾ ಪಾರ್ಟಿನೂ ಮಾಡಿಲ್ಲ.
ADLR party ಮಾಡಿಲ್ಲ.
Hence the following order. Petitioner is permitted to submit the necessary application along with all the particulars to respondent number 3 and the jurisdictional Assistant Director of Land Records. Full stop. If the same is done, the same shall be considered in accordance with law on seniority basis, but not later than 6 months
6 months.
from the date of such application. Writ petition is accordingly disposed.
4.
Appear for the application for cancellation of PADA and restoration of Kata is made.
Yes.
My lord, in this case, the application for PADA, the government will call for me. At that time, prescribed period has been.
ಅವ್ರ ಜಮೀನು ಏನ ಕಟ್ಟಕ್ ಮುಂದೆ ಬಂದಿದಾರ
ದುಡ್ಡು ಕಟ್ಟಕ್ ನಾವು ತಯಾರಾಗಿದ್ದೀವಿ. ಅದು ಏನಿದೆ ಅದೆಲ್ಲದನ್ನು ಕಟ್ತೀವಿ.
Will be considered in accordance with law. If he filed within.
No, not like
prescribed period.
that. See, ಸರ್ಕಾರಿ ಪಡ ಎಲ್ಲ ನೀವು ಆ ಟೈಮಲ್ಲೇ ಹಾಕ್ಬೇಕು ಈ ಟೈಮಲ್ಲೇ ಹಾಕ್ಬೇಕು ಅಂತ ಮಾಡಕ್ಕಾಗಲ್ಲ.
There is no such restriction also.
ಬೇಕಾದ್ರೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್
But judgment ಆಗಿದೆ. Judgment ಆಗಿದೆ ಇವರು ಲಾಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಸುಮಾರು ಆಗಿದೆ.
ಏನಂತ
ಆದ್ರೂ ಮಾಡ್ಬೋದು ಆತರ ಮಾಡಕ್ ಆಗಲ್ಲ ರೀಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ
ಅದೇನೇ ಹೇಳ್ತಾ ಇರೋದು. ಏನಾಗೋದು ಗೊತ್ತಾ, ಯಾವ್ದೋ ರಾಯನ್ ಕಾಲದಲ್ಲಿ ಅವ್ರಿಗೆ ಗ್ರಾಂಟ್ ಆಗಿರೋದು ಜಮೀನ್ ಅದು. ಅವಾಗಿನ ಪರಿಸ್ಥಿತಿನಲ್ಲಿ ಅವ್ರು ಹಣ ಕಟ್ಟಿರಲ್ಲಪ್ಪ, ಯಾವ್ದೋ ಕಾರಣಕ್ಕೆ ಕಟ್ಟಿರಲ್ಲ. ನೀವು ಸರ್ಕಾರಿ ಪಡ ಅಂತ ಮಾಡಿರ್ತೀರಾ, ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಸರ್ಕಾರಿ ಪಡ ಬಿಟ್ರೆ ಬೇರೆ ಏನು ವಾಸ್ತವದಲ್ಲಿ ಏನು ಚೇಂಜ್ ಆಗಿರಲ್ಲ.
ಏನೂ ಆಗಿಲ್ಲ.
ಅವರೇ ಪೊಸಿಷನ್ ಇರ್ತಾರೆ, ಅವರೇ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಿರ್ತಾರೆ. RTC ನಲ್ಲಿ ಮಾತ್ರ ಸರ್ಕಾರಿ ಪಡ ಅಂತ ಬರ್ತಿರುತ್ತೆ. ಒನ್ ಟೈಮ್ ದೇ ವಿಲ್ ರಿಯಲೈಸ್ ಇದು ಸರ್ಕಾರಿ ಪಡ ಅಂತ ಆಗ್ಬಿಟ್ಟಿದೆ, ಈಗ ನಮ್ ಜಮೀನ್
ಏನಾದ್ರೂ ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡಕ್ ಹೋಗಿ ಬ್ಯಾಂಕಿಗೆ ಹೋದ್ರೆ ಅಥವಾ ಫೈನಾನ್ಷಿಯಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಹೋದ್ರೆ
So then they want to regain their land. At the end of the day, it is their land, sir. ಅದೇನಿದೆ ನಿಮ್ದು ಡ್ಯೂಸು, ಅದ್ರ ಮೇಲೆ ಇಂಟ್ರೆಸ್ಟ್, ಅದ್ರ ಮೇಲೆ ಪೆನಾಲ್ಟಿ ಇನ್ನ ಬೇಕಾದ್ರೆ ಕೊಡಕ್ಕೂ ರೆಡಿ ಇರ್ತಾರ ಅವರು. ಏನೋ ಅದಕ್ಕೆ ನೀವು ಇಲ್ಲ ನಾವು 1 ವರ್ಷಕ್ಕೊಂದ್ಸಲ 2 ವರ್ಷಕ್ಕೊಂದ್ಸಲ ನಾವು 1 ತಿಂಗಳು ಗಡುವು ಕೊಡ್ತೀವಿ, ಆ ಟೈಮಲ್ಲಿ ನೀವು ಕಟ್ಬೇಕಂದ್ರೆ ದಟ್ ಬಿಕಮ್ಸ್ ಅನ್ರೀಸನಬಲ್.
ಪ್ಲೀಸ್
ಯು ಹ್ಯಾವ್ ಟು ಕೀಪ್ ಇಟ್ ಓಪನ್. ನಿಮ್ದೇನಾದ್ರೂ ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ, ಅಕಸ್ಮಾತ್ ಸರ್ಕಾರಿ ಪಡ ಅಂತ ಆಗಿ ಆ ಲ್ಯಾಂಡ್ ಬೇರೆಯವ್ರಿಗೆ
ಏನಾದ್ರು
ನೀವು
ಅದು ವಿಲ್
ಅಲಾಟ್ ಮಾಡಿದ್ರೆ, ಬೇರೆಯವ್ರು ಬಂದಲ್ಲಿ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದ್ರೆ, ಇವಾಗ ಇವರು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕೊಂಡು ಬಂದಿದ್ರೆ, then things are different. Okay, get instructions with
I'll get the instruction.
okay,
Please.
but instruct your officers. ಕರೆದ್ಬಿಟ್ಟು ಹೇಳ್ರಿ
Yes,
ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿಗೆಲ್ಲ,
ಹೌದು.
ಬೇಕಾದ್ರೆ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್ ಆಲ್ಸೋ.
Yes. ಅಲ್ಲ ಅದಂತ
ಥರ್ಡ್ ಪಾರ್ಟಿ ರೈಟ್ಸ್ ಕ್ರಿಯೇಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ, ಇಫ್ ದೇ ಆರ್ ಸ್ಟಿಲ್ ಇನ್ ಪೊಸಿಷನ್ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ, just allow them to.
Please, I'll get the instruction and.
I have produced one judgment of this honorable court.
ಸರಿ, ಈಗ ನಾನು ಹೇಳಿದ್ದಕ್ಕಿನ್ನ ರಿಲೀಫ್ ಬೇಕಾ? ಕರೆಕ್ಟ್ ತಾನೇ ಅದು?
ಸರಿ ಸರಿ.
ಹಾ ಸರಿ, ಅದಕ್ಕೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅವಶ್ಯಕತೆ ಏನಿಲ್ಲ. ಅವ್ರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡ್ ಬರ್ಲಿ.
ಸರಿ ಆಗ್ಬೋದು.
ಓಕೆ, ಯಾವ ಡೇಟ್? ಫಿನಿಶ್ ಇಟ್ ನೆಕ್ಸ್ಟ್
Thursday or Friday.
18th.
18th ಅಂತೆ ಅವ್ರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡ್ ಬರ್ತಾರೆ. AG accepts notice for respondents, call on 18th.
Please,
ಮುಗಿಸ್ರಿ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
please.
This case, paper petitioner, the writ of mandamus, annexure C, please, Lord. The property land bearing number survey number 24, 1 acre 20 guntas. This was granted in the name of the petitioner, please, Your Honor. till 2004 to 3 to 4, the RTC was standing in her name. And subsequently, her name was deleted without any appropriate order.
His
I'll get
instructions
the
idea?
instruction. Get these.
Okay. AJ accepts notice for respondent.
6, Vasant Kumar, it's.
It may be.
ಏನ್ ಇಂಟರ್ಮೋಟರ್ ಕೇಳು ಇಲ್ಲ ನೀವು
ಇಲ್ಲ ಕೇಳಿ.
ಮತ್ತೆ ಲೆಟರ್ ಬಿ ಅಂದ್ರ
ಅಲ್ಲಲ್ಲ ನಾನಲ್ಲ. Date may be fixed.
ಏನ್ ಬೇಡ ಸರ್ ಬರುತ್ತೆ.
6,
Gratefully.
HT Vasant Kumar.
I'm the petitioner in this case, my lord. The petition is for the cultivation of the
AJ
land.
accepts notice for respondent.
Interim order may be granted, my lord.
ಏನ್ರಿ ಇದು?
During the pendency of the
Farmer-
contempt, my lord, they
Already
issued the,
rejected, madam.
ಹಾ?
Forum number 57 has been already rejected.
ಹ್ಮ್.
Endorsement
During the-
also given. They have an alternative remedy before the assistant commissioner.
ಅಪೀಲ್ ಇದೆಯಲ್ಲಪ್ಪ.
this lordship has directed to the assistant commissioner to fresh consideration, my lord. So many matters, in many connected matters, the lordship has given direction to
ಅಲ್ಲಪ್ಪ
reconsideration.
ಹಿಂಬರಹ ಕೊಟ್ಟಿರೋದು ತಹಸೀಲ್ದಾರು.
please, madam.
The Bagar Hukum committee has rejected, no?
No,
They are
sir.
pledged,
They are
yes.
not, they are not conducted any inquiry, my lord. Even without conducting any inquiry, they have not conducted any, prepare any sketch, my lord. They have falsely issued the endorsement stating that the petitioner is in unauthorized occupation of 1670.
15-16 ಇಂದ ಇದರ ಅಂತ ಹೇಳಿ.
ಇದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. Kindly see my photographs, my lord. Annexure,
See, whatever it is, there is an alternative efficacious remedy, you go there, give me the provision of law, ಯಾವ್ದು ಹೇಳಿ ಅದು?
My lord,
Rule?
under section 1, 49. madam.
49 ಬರುತ್ತಾ?
ಹೌದು, 49.
ಹಾ?
49. appeal.
49 ಬರುತ್ತೇನ್ರಿ?
Yes, my lord. Revenue
Ah,
officer
super.
subordinate to the assistant commissioner. Whether or not,
No, see, this land grant rules ಅಲ್ಲಿ ಬರುತ್ತಲ್ವಾ ಇದು?
ಇಲ್ಲ ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ರೂಲ್ಸ್ ಅಲ್ಲಿ 108 ಕೆ ಇದ್ರೆ ಮಾತ್ರ ಮಲ್ಲ. ಇದರಲ್ಲಿ 49 ಅಲ್ಲೇ ಅಪೀಲ್ ಆಗ್ಬೇಕು ಬಿಫೋರ್ ದಿ ಅಸಿಸ್ಟೆಂಟ್.
Whatever, the petitioner has challenged the endorsement issued by, the petitioner has challenged ಬೇಡ, ಈ ರೀತಿ ಮಾಡ್ಕೊಳ್ಳಿ. AJ accepts notice for respondent, the judgment. The petitioner made an application for regularization of his unauthorized occupation and cultivation of the land, which is the subject matter of the writ petition. Full stop. Next para. The request of the petitioner has been rejected by the respondent number 4. And the same has been communicated to the petitioner by respondent number 3, which is challenged in the instant writ petition. Full stop. Next para. The learned AG upon instruction submits that the petitioner is having an alternative and efficacious remedy to challenge the impugned endorsement. Full stop. The petitioner is not in a position to deny the same. Full stop. Next para. As the petitioner is having an alternative and efficacious remedy, section 49,
Please, ma'am.
under section 49 of the Karnataka Land Revenue Act, the writ petition is hereby dismissed, reserving the liberty to the petitioner to approach the appropriate authority in the manner known to law.
till date not to disperse the petitioner from the land in question.
If the petitioner, no sir, no stay order.
Prasanna, we are 7.
Without-
October ಹಾಕಿರೋದಲ್ಲ writ. Right. If the petitioner were to approach the appellate authority, he would be entitled for benefit of condemnation of delay. So he would be entitled to benefit of sections 14 of Limitation Act and the Act that carry. Yes.
Not the petitioner, lords, without receipt of notice, not the tribunal will not granted occupancy right. The knowledge of the petitioner will not only on 6/5/2024, annexure J, when the assistant commissioner issues notice in an appeal filed by the third respondent challenging mutation, seeking mutation, saying that his name has to
Any
be.
instructions on delay and latches?
I'll get the instruction. 81.
No,
Annexure J, my lords, is the notice received by the petitioner.
These matters, unless delay and latches is satisfactorily explained, it is dangerous to issue notice also.
Yes.
Okay, not
Yes.
just granting interim, forget granting interim orders. Even issuing notice will become dangerous. Because this is a 1981 order.
Kindly have it day after tomorrow, my lord, I'll do.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನೋಡಿ,
Yes, ma'am.
ಈಗ RTC ಅಥವಾ ಮ್ಯುಟೇಷನ್ ಅಲ್ಲಿ ಇವ್ರ ಹೆಸರು ಬಂದಿಲ್ಲ ಅಂದ್ರೆ, ಅಥವಾ RTC ಹಾಕಿದಾರಲ್ಲ ನೋಡಿ ಹೇಳಿ,
ಇಲ್ಲ ಇದೆ, ನಮ್ಮ ಹೆಸರು ಇದೆ.
ನಿಮ್ಮ ಹೆಸರು ಎಲ್ಲಿ ತನಕ ಇದೆ?
ಇದೆ, ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್ 86 ನೋಡ್ಸ್.
Day after tomorrow, ma'am.
ನಾಳೆ ನಾಡಿದ್ದು ಹಾಕ್ತೀನಿ.
Nalle ಹಾಕ್ತೀನಿ.
Concentrate only on delay and
Yes,
laxes.
ma'am, yes, ma'am.
There won't be any entry modus, forget it. Okay, to issue notice also, you get back.
Yes, ma'am.
Anything to show they had the knowledge of the order, we are going to dismiss it.
Please.
Yes. AGA accepts notice for respondent number 1 and 2. To call on not date to
11.
hear on
11-12.
the question of delay and laxes in
Delay.
filing the writ petition. Yes.
8, Satisha DJ.
The impugned order, page number 28, annexure F, my lord.
Hmm.
The assistant commissioner, second respondent has passed a order on review. That's set aside the own order. It is a previous, my lord, page number 21, which is I filed a petition challenging the MR in favor of the sixth respondent. That has been came to be allowed earlier. And thereafter, my lord, the assistant commissioner has passed an order under review, the review without jurisdiction. The quasi judicial has no power to review its own order
Yes.
without there being any notice
I'll
of.
get the
Stay.
first time.
That is a covered by judgment, my lord.
Punctus officio, but
ಅದನ್ನೇ ಹೇಳಿದ್ದು. Let there be an interim order.
Interim order is also.
ಕೊಡ್ತೀನ್ರಿ.
Please, please.
AGA accepts notice for respondents 1, 2 and 3 issue emergency notice to other ಅಲ್ಲ 1, 2, 3, 5 ಗೆ AGA, 4 and 6 ಗೆ issue emergency notice. The petitioner has filed the incident writ petition on the ground that the impugned order, the petitioner has challenged the impugned order on the ground that the same has been passed by respondent number
6, my lord.
2 re,
Respondent number 2, please.
respondent number 2 after he has become functus officio. Full stop. For the said reason, there shall be stay of further proceedings pursuant to the interim order dated so and so. Earlier order allida?
Earlier order, page number 21. 21. My petition came to be allowed is earlier.
ಆಮೇಲೆ
ಆಮೇಲೆ is a review has been, time the review petition without there being any notice, without jurisdiction. Quasi judicial has no power to review its own order.
ಸರಿ.
ಪುನಃ ಪರಿಶೀಲನಾ ಅರ್ಜಿ.
ಹಾ, dated so ಏನಿದು? ಯಾವ ಡೇಟ್ ಇದು? annexure E. annexure E date ಏನ್ರಿ?
Let's annexure E dated, a date ಇಲ್ಲ ಅದ್ರಲ್ಲಿ, ಅವ್ರ ಡೇಟಾ ಹಾಕಿಲ್ಲ.
Date ಇರ್ಬೇಕಲ್ಲಪ್ಪ.
Subsequent,
29/10/2024.
ಹಾ?
29/10/2024.
ಅಲ್ಲ next date.
Next date ಅದು
Next
29.
date, next date.
Notice, just notice, my lord. Reviewed and
ಅಲ್ಲ notice ಆಗಿಲ್ಲ.
has been issued. ಈ ಸಂಬಂಧ ಮೇಲ್ವಿಧಾನಗಳು.
Impugned order passed in so and so would annexure E to the writ petition till next date of hearing.
Yes, ma'am. Annexure E.
Date ಇಲ್ಲ.
9, Prakash MH.
Please. Purchase of the granted land. Lord, I have purchased in 2016. When I have been to, the request the respondent authorities for change of revenue entries. But there I come to know that in 2011, this same land was subjected for sale by the very same grantee. This was subjected for sale previously by in 2011. My lord, concealing this fact, my lord, the original grantee has sold it to me. Then I filed an appeal before the assistant commissioner. Lord, the contention is that within non-alienation period, the land was subjected for sale. However, no action was initiated. But in the appeal, what the assistant commissioner did, Lord, he has directed the Tahsildar to initiate proceedings invoking 108K, which mandate for when securing the grant by playing fraud. But I have questioned it before the deputy commissioner in the revision petition. Lord, he has, totally deviated the context and directed the authorities to initiate action invoking Rule 25 of the land grant rules. Lord, the land is granted under unauthorized cultivation. But both the authorities, and even to take into the consideration, my lord,
Land grant date, and sir. Original
2000,
grantee ke?
it was in 2000, year 2000, I will,
Non-alienation period,
15 years, sir.
okay, permission ಬೇಕಲ್ವಾ ಆಮೇಲೆ?
How?
Permission, my lord, right, after amendment in 2020, it says with the concerned prior approval of the authority, it says,
ಅದನ್ನ ಹೇಳ್ತೀನಿ,
Please.
permission ಬೇಕು.
the permission is not required even as on the date of my purchase after 15 years.
You have to take permission from the state government, no?
Yes.
It doesn't say, sir. My lord, if not,
Granted
here
it.
used to be
But it was alienated by him when 2011.
2011 by the original grantee. Now, in my revision petition after 13 years, the deputy commissioner has directed the authorities to initiate action. Though it is under the context of, sale without permission.
It's come to our knowledge, only they approached the AC. Then the AC has.
After 13 years.
passed the order saying that. the
ನಿಮ್
consider
ಕ್ಲೈಂಟ್
direct-
ಕೇಳಕ್ಕಿಲ್ವಾ? ನಿಮ್ಮನ್ನ ಇವಾಗ ಅಪ್ರೋಚ್
you
ಮಾಡೋ
will
ಬದಲು ಕೊಂಡ್ಕೊಳಕ್ಕೆ
purchaser beware, they have to aware while purchasing the property. Within the
If you had told the
prohibited time.
petitioner to approach you before purchasing the property rather than after purchasing
Lie.
the property, you would have
Lie.
told her not to purchase.
So what happened in 2016? So after 15 years that he has purchased, I'm not thinking he is a bona fide purchaser. In 2011, by fraudulent method, the original grantee has, sold it in favor of some third party. Not what is it? The subsequent to come to know about all these issues, but in 2020, he has, with the, involvement of the earlier purchaser, the sale deed was also cancelled. This was brought to the notice of the respondent number 2. But however, invoking Rule 25, the Deputy Commissioner has directed the respondent number, the Assistant Commissioner and the Tahsildar to initiate action. So which specifies only for, securing the grant by playing any act of fraud. Even 108K also runs in the same parameters.
136(3) appeal. DC. both
27/1/20 ಏನದು? What was the order passed?
Pardon, my lords?
27/1/2020, what was the order passed?
Please. This is the order passed by the Assistant Commissioner. Lord, I would like to. Page 45, Annexure M. Because challenging the endorsement issued to me by the Tahsildar. In this order, the Assistant Commissioner has directed the Tahsildar to initiate action under 108K. ಆದೇಶ at page 47, my lords. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ವಾದಿಯ ಮೇಲ್ಮನವಿಯನ್ನು ವಜಾಗೊಳಿಸಿದೆ. ಕನಕಪುರ ತಾಲೂಕು ಮರಳವಾಡಿ ಹೋಬಳಿ ಸೋರ್ಸ್.
AGA accepts notice for respondents 1 to 4, issue emergency notice to other respondents. Respondents 1 to 4 are directed not to precipitate the matter against the petitioner till next date of hearing. Petitioner is directed not to alienate or create any third party rights in respect to the property which is the subject matter of the petition till next date of hearing.
Oh, please, please.
Then, E. Balakrishna Shastri.
That the petitioners are the purchasor of the two sites, my lord, of 116 and 117 in the year 2019. My vendor has purchased the same, my lord, in the year 2005. The sites are in a private layout, my lord, formed by the owner. Now, Tahsildar, my lord, as per Annexure A, has directed the eviction and demolition of the constructions agreed by which, my lord, as per Annexure A, petition has come up. No notice, my lord, to the petitioners. The properties are within, my lord, BBMP limits. From 2008, 2009, taxes are paid, my lord, to the.
Revenue side, sir.
Please, my lord.
Revenue side.
Revenue sites, my lord, revenue sites, obviously, my lord, revenue sites. But your lordship says.
Then notice will go only to the owner, sir. Owner of
Yes, ma'am.
the acre of the land.
I am the owner, my lord, I am the owner. I have purchased, my lord, the property.
Oh, you purchased 1 gunta or something like that.
Please, my lord.
I purchased 1 gunta or something like that.
30-40 sites are purchased, my lord. But, my lord, your lordship says, within the BBMP limits, Tahsildar has no powers at all, my lord, under the act. Now, he seeks to power, my lord, under section 192A. The order is under section 192A, table 5. 192A, my lord, is only regarding criminal cases, not, my lord, powers of eviction or demolition. Powers of eviction are not vested, my lord, In number of judgments this court has held, within BBMP limits, he has no jurisdiction at all.
Without conversion, my lord, the land has been
But
developed.
he has
for
no
purpose-
jurisdiction, my lord. ILR 2012 Karnataka 3428, followed, my lord, by this court again in writ petition 10,783 of 2023, the judgment dated 3/1/2024. Again and again, my lord, this court has said,
Notice to the
within
original
BBMP
owner.
limits, my lord, Tahsildar has no jurisdiction. In the connected case, my lord, also, my lord, your lordship has directed maintenance of status quo.
Okay.
In another
I've said
request.
it first.
Annexure C, my lord, your lordship, is
This is
purchased
the
by me,
10
annexure
months of
C
the
and
20
annexure D at page, my lord,
First sale deed ತೋರಿಸಿ sir.
please, my lord.
First sale deed ಯಾವುದು?
Annexure B is the earlier sale deed of my bandar in the year 2005, my lord. My sale deed is annexure C and annexure D.
B is the first sale deed.
One site 116 and one on page 27, my lord, is my sale deed. At my lord, the schedule shows. My lord, site number 116.
You'll have to go to the, have you filed a civil suit?
Suit.
No, I have not filed civil suit. My lord,
AG access notice
my
to
lord,
respondents 1 and 2, issue emergency notice to respondent number 3 and 4. Respondent 1 and 2 are directed not to precipitate the matter against the petitioner in respect to the land which is the subject matter of the writ petition till next date of hearing. Petitioner is also restrained from creating any third party rights over the property consent till next date of hearing.
please. But state, my lord, in this matter, sir, dual rule to the big. One side they register the sale deed,
Sir,
another side they collect the taxes.
doctrine of
Third, my lord, again they
Sir,
harass the.
doctrine of KO temptor applies to you also. Who asked you to go and buy on a revenue site? Yeah, ಬಂದಿದ್ದೀರಾ ಅಂತ ಒಂದು
But there is no law for the state, my lord. There is no law for them.
They have taken action against you, no? That's what they have done. They are doing their duty. Yeah, ದುಡ್ಡು ಕೊಟ್ಟು ಸೈಟ್ ಖರೀದಿ ಮಾಡಿರ್ತೀರಾ.
Sir,
And state
25 ವರ್ಷನೇ taxes collect ಮಾಡ್ತಾರೆ. Corporation ದವರು.
ನೀವು ದುಡ್ಡು ತಗೊಂಡೋಗ್ ಕೊಟ್ರೆ ಅವ್ರು ತಗೊಂತಾರಪ್ಪ. ನಿಮ್ಮನ್ನ ಯಾರು ದುಡ್ಡು ತಗೊಂಡೋಗ್ ಕೊಡು ಅಂತ ಹೇಳೋದು? ನೀವು ತಗೊಂಡೋಗಿಲ್ಲ ನಾನು ದುಡ್ಡು ಕೊಡ್ತೀನಿ ತಗೊಳ್ಳಿ ಅಂದ್ರೆ ಆಯ್ತು ಏನೋ ನೀವು ಕಟ್ಟಬೇಕನ್ನೋ ಅಂತ ದುಡ್ಡು ತಗೊಂತಾರ ಅಷ್ಟೇ ಅವರು.
25 ವರ್ಷ ತಗೊಂಡು ಸರ್ ಎಲ್ಲ ಇಲ್ಲಿಟ್ರೇಟ್ ಪೀಪಲ್ ನಂಬೇ ಬಿಡೋದಲ್ಲ, ನಾವಾದ್ರೂ ನಂಬಿಡ್ತೀವಿ. ಇದಕ್ಕೇನ್ ತೊಂದರೆ ಇಲ್ಲ.
ನೀವು ಕಾನೂನು ಪರಿಪಾಲಿಸಿ.
Petitioner is the owner of survey number 49/3 measuring 3 acre 37 guntas. It is an ancestral property. Father and grandfather died. Thereafter, the MR 6 of 86-87 has been certified in the name of. There is no document at all. I approached the Assistant Commissioner. Assistant Commissioner allowed the revision.
136(3). Filed by the.
There is no document at all.
The rivalry claimant, my lord, it's a family, interest a family.
Finally, take page 47. Deputy Commissioner record that there is no document at all. In spite of it, revision petition has been allowed. And order to restore the extent, entire extent in their favor, two guntas in my favor. Kindly take page 47. ರಿವಿಷನ್ ಅರ್ಜಿದಾರರು ಮುಖ್ಯವಾಗಿ ವಿವಾದಿತ ಜಮೀನು ತಮ್ಮ ಪಿತ್ರಾರ್ಜಿತ ಸೊತ್ತೆಂದು ವಾದಿಸಿರುತ್ತಾರೆ. ಹಳೆಯ ಕೈಬರ ಪ್ರಾಣಿಗಳಲ್ಲಿ ನಂಜುಂಡೆಯ ಹೆಸರು ನಮೂದಾಗಿದೆ. ರಿಜಿಸ್ಟರ್ ನಂಬರ್ ನಂಜುಂಡೆ.
Accept notice for respondents 1 to 4, issue emergency notice to other respondents. Respondents 1 to 4 are directed to maintain status quo regarding the revenue entries which are the subject matter of the writ petition. Regarding the lands which are the subject matter of the writ petition till next date of hearing. Yes.
Well, M. Shiv Prakash.
The petitioner from the village of Anneshwara and Devanalli Taluk, he made an application for grant of land in the year 1999. The application, my lord, will find at page number 22. My lord, after the due inquiry, the grant has been made in favor of this petitioner by conducting spot inspection, and also the authorities issued him a sketch also. Sketch for to show his position. But afterwards, this sixth respondent, she made an application that she has also made an application in the same village of Anneshwara. Her village is altogether different. She is from different village. Then the authorities are taking that application again. They have set aside and then sent the matter for remanded. Again, the authorities issued the Sagudi chit to me, confirmed me by conducting mahazar. In the Mahazar, one page that they have written, and I would like to take my lord to that page number is 54. 51, my lord, 51. By Tahsildar who conducted way back in the year 2007. A typed copy is at annex page number 51. My lord, Kundana Obli, Rajeshwar Nirikshaka Rubu Ditto Obli, Badrali Gramada, ಗ್ರಾಮಸ್ಥರು ಹೇಳಿ ಬರೆಸಿದ ಮಹಜರ್ ಕ್ರಮ ಅಂದರೆ ಕುಂದಾಣ ಹೋಬಳಿ ನಾಡ ಕಚೇರಿ ಉಪ ತಹಸೀಲ್ದಾರ್ ಅವರಿಂದ ಸದರಾದ ಸೋನ್ಸೋರಲ್ಲಿ ಮತ್ತು ರಾಜೇಶ್ ನಿರೀಕ್ಷಕ ಸದರಾದ ವಿಚಾರವನ್ನು ಸಮ್ಮತ್ತು ರಾಜ ನಿರೀಕ್ಷಕರಿಂದ ಓದಿ ತಿಳಿದುಕೊಂಡು ಈ ವಿಚಾರ ನಾವು ಹೇಳಿ ಬರೆಸುವುದು ಏನಂದ್ರೆ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಅಣ್ಣೇಶ್ವರ ಗ್ರಾಮದಲ್ಲಿ ವಾಸವಾಗಿರುವ ಸುಶೀಲಮ್ಮ ಬಿನ್ ರಾಮಣ್ಣ ಇಟ್ ಇಸ್ ಅಣ್ಣೇಶ್ವರ ಎಂಬುವರು ಬ್ಯಾಡ್ರಳ್ಳಿ ಗ್ರಾಮದ 18 ಗೋಮಾಳ ಜಮೀನಿನಲ್ಲಿ ದಿನಾಂಕ 8/1/99 ನಮೂನೆ 53 ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತೆ ಎಂದು ಸದರಿ ಜಮೀನಿನಲ್ಲಿ ದರ್ಖಾಸ್ತು ಮೂಲಕ ಮಂಜೂರು ಮಾಡಿಕೊಡುವ ಕೋರುವ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವ ಬಗ್ಗೆ ಗ್ರಾಮದಲ್ಲಿ ತಿಳಿಸಲಾಗಿ ಸದರಿ ಅರ್ಜಿದಾರರು ಬ್ಯಾಡರಹಳ್ಳಿ ಗ್ರಾಮದ ನಂಬರ್ 18ರಲ್ಲಿ ವ್ಯವಸಾಯ ಮಾಡುತ್ತಿರುವುದಿಲ್ಲ ಮತ್ತು ಸದರಿ ಸುಶೀಲಮ್ಮ ಯಾರು ಎಂಬುದು ಸಹ ನಮಗೆ ಸರಿಯಾಗಿ ತಿಳಿದು ಬಂದಿರುವುದಿಲ್ಲ ಮತ್ತು ಇದರ ಸರ್ವೆ ನಂಬರ್ನಲ್ಲಿ ವ್ಯವಸಾಯ ಮಾಡುತ್ತಿರುವುದಿಲ್ಲವೆಂದು ದಿನಾಂಕ 9/1/7ರಂದು ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ಕಾರ್ಯದಿಂದ ಬ್ಯಾಡರಹಳ್ಳಿ ಗ್ರಾಮ ಗೋಮಾಳ ನಂಬರಲ್ಲಿ 53 ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದೆಂದು ಎಂಬರಹ ನೀಡುತ್ತಾರೆ. ಇವರು ಕೋರುವ ಬಗ್ಗೆ ಮಂಜೂರಾತಿ ಮಾಡೋದಕ್ಕೆ ರಹ ಇರುವುದಿಲ್ಲವೆಂದು ಹೇಳಿ ಬರೆಸಿದ ಮಹಜರ್ ಓದಿ ಬರೆಸಿದ್ದಾರೆ. So after grant of this land, I started to cultivate and even Krushi Honda, all those things, photographs also produced, page number 50 and onwards. These are all things in existing. Now the appeal is preferred before the Assistant Commissioner. When appeal is preferred, one letter has been addressed. May I kindly take my lord to page number 54 specifically. Well, this is addressed by the then member of Legislative Assembly is A.M. Mariappa. This is 29/1/2007. My lord, Vishya Srimati Sushilamma Kom A. Mariappa ಅವರಿಗೆ ಸಾಗುವಳಿ ಪತ್ರ ಮಂಜೂರು ಮಾಡುವ ಕುರಿತಾಗಿ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ನನ್ನ ಪತ್ನಿಯಾದ ಶ್ರೀಮತಿ ಸುಶೀಲಮ್ಮ ಕೋಮ್ ಎ ಮರಿಯಪ್ಪರ ಅವರಿಗೆ ಕುಂದಾಣ ಹೋಬಳಿ ಬ್ಯಾಡ್ರಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸಲ್ಲಿ 2 ಎಕರೆ ಜಮೀನು ಇದ್ದು ಸುಮಾರು 25 ಬಗರುಕಂ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿದ್ದು ಸಕ್ರಮಗೊಳಿಸಲು 8/1/99 ಫಾರಂ ನಮೂನೆ 53 ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಆದರೆ ಈಗ ಅವರ ವಿರುದ್ಧ ವೆಂಕಟೇಶ್ ಅವರು ಈ ಅಕ್ರಮವಾಗಿ ಭೂ ಮಂಜೂರಾತಿ ಮಾಡಿಸಿಕೊಂಡಿರ್ತಾರೆ. ಅವರಿಗೆ ಸಾಗುವಳಿ ಪತ್ರ ನೀಡಿದ್ದಾರೆ. ಈ ಮಂಜೂರಾತಿಯನ್ನು ವಜಾ ಮಾಡಿ ಸುಶೀಲಮ್ಮ ಕೋಮ್ ಎ ಮರಿಯಪ್ಪ ಅವರಿಗೆ ಮಂಜೂರಾತಿ ಅನುಮತಿ ನೀಡುವಂತೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಆದೇಶ ನೀಡುತ್ತಾರೆ. This was addressed to the Assistant Commissioner at the time, to the Chief Minister. Then from there it is to the Assistant Commissioner. This Assistant Commissioner and Deputy Commissioner, without considering the merits of the case and also the records, mahazar and the sketch drawn, cultivation and also the position, they have cancelled my grant. Also before the KT, also same thing without application of mine. They have passed it to say cyclostone copy and the same repetition they made. So I agreed by these orders. Now I am before the sample court. 1999, he being a scheduled caste person and he being a deserved person. When the authorities factually on the spot when they have conducted grant 99. That's on 1/3/2004. My application is dated. It is 26/2/1999.
Grant ಆಗಿದ್ದು order.
Grant is 1/3/2004.
Yes.
And
For
the improvement made and the Krushi Honda, all those
So
things.
whatever.
Please, my lord.
I prefer it tomorrow. It may be taken up tomorrow, my lord. KVG Kumar is not in station, only for day's accommodation.
You have it after vacation, I said.
My only submission is this is just a remand order. There is a finding before the Assistant Commissioner itself that the name of the petitioner was inserted and the matter has been remanded. And
Oh,
the
Hey,
same
the
has
revenue
been
interest, let there be status quo.
My only
One
submission-
letter is enough. How they influence these authorities. The wife of MLA, whether she is entitled for such a grant.
Sir, that is different.
Please, my lord.
Okay, what we'll do is we'll go into records, sir, see government.
Please, my lord.
My only
Let them
submission
secure
is
it.
that their interim order, their interim prayer is regarding stay of the impugned order.
I will simply say, let the revenue, there will be status quo regarding revenue interest,
Yes.
that's all, nothing else.
Position also, because the page number.
Saying about
No,
position.
why am I know my lord will say, my lord, page number 58 onwards, may I kindly take my.
Sir, position probably will have to go to civil court.
Three courts have confirmed the
Position
order.
with my dwelling house and I have taken Bescom connection and also my
Go to the civil courts.
civil court is there. Now, because the background of this lady and the background is MLA and the present,
That
the,
doesn't mean that.
the
it will
only
come
thing
to this
is
court
men-
bypassing the civil
only
court
thing
first.
is manpower, muscle power, money power.
SAJ accepts notice for respondents 1 to 5 issue, so and so accepts notice for respondent number 6. There shall be, respondents 1 to 5 are directed to maintain status quo regarding the revenue entries in respect to the land, which is the subject matter of the writ petition till next date of hearing.
If status quo regarding position also, because
Position now,
there are have-nots.
Sir, I am not giving,
I can understand.
sir, it's the jurisdiction of the civil court, sir.
Overnight, they can, even civil court also permanent injunction, I got it and it has been granted with a decree. It is there.
Keep it, sir. Yes.
Highly obliged, madam.
My lords, here, my lords, so the case of the, my lords, say representation is made to the authorities. My lords, say an illegal construction is taken place in a Goma, the Gunduto. My lords, without there being any records of grant in favor of those persons. My lords, have made a representation to the authorities to consider, my lords, to prevent the illegal.
Ken
act.
Ray, you're
No locus to question all those things.
who is he?
He is not the aggrieved party.
Meddlesome mental opera,
Can file at the most public interest.
huh? What Ramesh?
My lords, only thing is, my
You
lords,
are a
I
busy
want to,
bee.
my lords, only I want to protect the government land. My lords, now the government themselves says that I have no locus standing. My lords, if I approach the authorities to consider, my lords, prevent the illegal acts committed by a third party in a Guntop, my lords, where he has not been
AJ
granted.
accepts notice for respondents. The case of the petitioner is that there have been illegal constructions being put up in survey number 120 of Bagaluru village, Jala Hobli, Yelhanka Taluk, Bengaluru rural district, which is a Gundutopu land, Full stop. In spite of giving necessary representation to the respondents, they have not initiated any action. Against the said illegal encroachers. Full stop. Hence, the present writ petition is filed. Full stop. Next para. The learned AGA upon instruction submits that the respondent has not included the parties whom he alleges to have trespassed into government property. Full stop. She further submits that no right of the petitioner has been violated by any of the respondents. And admittedly, he has no right over the land concerned. Full stop. She further submits, irrespective of the representation of the petitioner, government government will always take necessary steps to have the government property safeguarded. Full stop. Hence the following order. Next para. Admittedly, the petitioner has no right over the property consent and this is not a public interest writ petition. Full stop. For the aforementioned reasons, the writ petition is hereby dismissed. Full stop. However, it is needless to state that dismissal of the writ petition shall not come in the way of the state preserving its property in accordance with law.
14, Ravi Kumar, GH.
Petitioner is seeking direction against the respondent number 2, Tashildar Beltangadi, to implement the order passed by the Assistant Commissioner Beltangadi. That is page number 13, 11 portion, page number 15, orders. Respondent number 3, has obstructed the existing road, which is used to reach the petitioner's land.
Again, what is wrong in the order, sir?
Implement ಮಾಡ್ತಾ ಇಲ್ಲ.
Secure
Assistant
instruction,
Commissioner
because they're claiming that there is a
You
road.
want this order to be implemented?
implement. Assistant Commissioner, Tashildar direction ಕೊಟ್ಟಿದ್ದಾರೆ. If the respondent number 3 is continued to obstruct.
SJ accept notice for respondent number 1 and 2. Issue emergency notice to respondent number 3.
8 may be given. because he's
ಬರುತ್ತೆ ಬಿಡ್ರಿ.
Badrinath. 15.
Paper petition. Earlier I had made an application got Podi Turastu, where the Dishonorable Court directed to make an application to consider online application. Now the online application has been stated, the application is not considered. I issued an annexure endorsement. In respect of T surveillance, it cannot be considered. Page number 20,
I'll get instructions, madam.
where the similar matters has been disposed of.
It can't be disposed of, sir. Yes, you accept notice for respondents.
1 to 7.
ನೀವೇ ಎಲ್ರಿಗೂನು.
1 to 7. Okay.
Date
Basavanna came 16.
Any date may be sustained next week, any date.
No urgency, sir. It will come.
paper the petition.
They rejected it on the ground that it's a government property, government land. What is the question of granting to you?
And matter pertaining to 17 and AB. The impugned order, my lord, annex D, page number 16. Gifted is attracted 79A.
Yes, Dylan latches.
2008 matter, man.
My lord, based on the gift deed is not attracted.
Did you accept notice for response? ನೋಡಿ ಅದು ಏನಂತ.
Shocked.
17. Vandana. 17.
Let to appear, my lord, for the petition. Lord, the respondent, for my lord, not changing the kata, we have given a representation, my lord. Our prayer is to consider the representation at annexure A, B, and C.
Yes, you accept notice for response.
I have been told, my lord, I have secured instruction in this very particular case, my lord, survey number 122 consisting of 20 acres and 29 guntas. Out of which 4 acres have been coded and durasta have been fixed, my lord. Only remaining extent, all the occupants have been shown in the RTC's name. Somehow petitioner's name is not found in the RTC's. So 1 to 5 has to be conducted by the Tahsildar to test the genuinity of the grant. Only after verifying the genuinity of the grant, his request can be considered.
You do it.
Yes, ma'am. Only upon considering.
My lord,
the
from
genuinity of-
1967 till 2000, my father's name is there.
You go before them and say.
Yeah, my lord, that is why, my lord, after my father's death, we gave a representation saying that, my lord, my father is expired on such and such a day, please include my name. They don't do it.
If they pass an adverse order, you challenge it.
Yes, let them consider, that is my prayer. Do not know what. my
Yes,
lord.
you accept notice for respondents.
File submissions may be recorded saying
the
that 1 to
judgment.
5 after verifying the.
The
grant
case of the
of-
petitioner is that he is the owner of the property, which is the subject matter of the writ petition. And that the name of his father found a place in the revenue entries. Handwritten revenue entries in the matter. So handwritten revenue entries, correct in rare.
Correct.
Full stop. After computerization, the said revenue entries are not continued. Full stop. On the said ground, for on said ground, but for the said reason, he gave a representation to the respondent number
Formal.
4 to include his name.
As my father expired, my lord, on 1990.
Name, full stop, as the same has not been considered so far, the present writ petition is filed, full stop. Next para. The learned DJ upon instruction submits that respondent number 4 doubts the genuineness of the grant said to have been made in favor of the father of the petitioner. And thus, after conducting the necessary inquiry, appropriate action will be taken. Full stop. Our submission is placed on record. Hence, the following order. Respondent number 4 is directed to consider the representation of the petitioner in accordance with law and conduct necessary inquiries with regard to genuineness of the grant if required and pass appropriate orders thereafter. Full stop. If the petitioner is aggrieved by any action of the respondent to be taken, it is needless to state, he is always at liberty to challenge the same in the manner known to law.
But one submission, my lord. As for the inquiry, my lord, as to the genuinity of the grant, Tahsildar has no power to do it.
He'll refer.
My
to
lord,
the
they can,
petition.
he
ಏನ್
can,
ಬಂತ್ ಹೇಳಿ?
because, my lord, your law.
Representation of the petitioner, and if required, the authorities concerned can initiate appropriate inquiry in accordance with law. And the authorities concerned in respect of the alleged grant said to have been made in favor of the father of the petitioner. And it is needless to state if any of their if the petitioner is aggrieved by any of their action, he is always at liberty to challenge the same. Full stop. However, it is hereby directed, however, but keeping open the actions to be initiated, respondent number 4 is hereby directed to consider the request of the petitioner and pass appropriate orders within a period of 6 months from the date of
6 months. Kendra, if it is, Tahsildar has to refer to the special DC to test the genuinity of the grant.
Lord, my
So it-
representation.
don't know.
ಮಾಡಿ
6 months ಅಲ್ಲಿ ಮಾಡಕ್ಕಾಗಲ್ಲ. Because notice has to go.
ಅದನ್ನ ಇನಿಷಿಯೇಟ್ ಮಾಡಿ
Initiate ಮಾಡ್ತೀವಿ, but we cannot conclude within 6 months.
ನಾಟ್
Because
ನೆಸರಿ.
number of RTC holders are more.
ಏನ್ ಬಂತ ಹೇಳಿ? To be initiated by the respondent. To be initiated by the authorities concerned. By the authorities concerned, 3 is directed to respond, is hereby directed to respond to the representation of the petitioner within a period of 3 months from the date of receipt of certified copy of this order. Respond ಮಾಡಿ ಅಷ್ಟ.
Yes.
Respond.
18, Narasimharaju. Petitioner.
After lapse of 60 years, the respond number 6 and 7 approached the challenge my revenue entries before the assistant commissioner. Assistant commissioner, I purchased the property by virtue of the registered sale. But the respond number 6 and 7, they only approach the civil court for declaration. The suit is pending. After lapse of 60 years, they challenge my revenue entry before the assistant commissioner. Assistant commissioner, without considering my sale deed, my vendor sale deed, my vendor sale deed, has allowed the petition without condoning the delay, even for application to condonation
Should
application.
you not be approaching deputy commissioner, sir?
We approach the deputy commissioner, with kindly see the produce the order sheet. Kindly see deputy commissioner order sheet, kindly see page number 126 for a moment. In all the date 2 years there is no sitting. Kindly see page number 130.
Revenue interest ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಇದೆಯಾ?
ನನ್ನ ಹೆಸರಲ್ಲಿದೆ.
Now, the assistant commissioner as well as deputy commissioner has remanded back to the Tahsildar saying that there is a discrepancy in the survey number as well as ISSA. You have to inquire and get the document
It is-
with the private
ಎಲ್ಲಿ
party.
ಎಲ್ಲಿದೆ ಹೇಳಿ?
My lord, annexure A, my lord. 22, page number 22. ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಉಪವಿಭಾಗಗಳು ಮೂಲ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಸರ್ವೆ ನಂಬರ್ಗಳನ್ನು ಮತ್ತು ಇಸಾ ನಂಬರ್ಗಳನ್ನು ತಾಳೆ ಮಾಡಿಕೊಂಡು ಸದರಿಯವರ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿಕೊಂಡು ದಾಖಲೆಗಳ ಆಧಾರದ ಮೇಲೆ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಅಧಿನಿಯಮ
ಇದು ತಿರಸ್ಕರಿಸಿದ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆ.
ಅಸಿಸ್ಟೆಂಟ್
page
ಬಿ
number,
ಮೇಲೆ
annexure 20 page, annexure B page
26.
24 Kindly see ಆದೇಶ.
6 ಆದೇಶ.
My revenue and my mutations are set aside. Page number 26 correct moment. ಮೇಲೆ ವಿವರಿಸಿದ ಕಾರಣದಿಂದ ಮೇಲ್ಮೇಲೆ ಭಾಗಶಃ ಅಂಕರಿಸಿದೆ. MR number 3/1718 dated so and so, MR number 9/11 and 12 dated so and so, MR number 39/10 and 11 dated so and so, MR number 13/11 and 12 so and so ದಾಖಲೆ ಆದೇಶಗಳು ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರಶ್ನಿತವಾಗಿರುವ ಸರ್ವೆ ನಂಬರ್ಗಳನ್ನು ಅನ್ವಯವಾಗಂತೆ ರದ್ದುಪಡಿಸಿದೆ. My revenue entries are all set aside after lapse of 60 years. They are saying that grant was made in 1960. I purchased the property by virtue of the registered sale deed.
How can you do it?
Civil suit is pending. They only approach the civil court. Declaration suit is pending without awaiting the order of the civil
With
court.
respect to this, my lord, your lordship may direct the maintenance status with regard to this and inquire the
AJ accepts notice for respondents 1 to 5, issue another notice to other respondents. Respondents 1 to 5 are directed to maintain status quo regarding the revenue entries in respect to the lands which are the subject matter of the writ petition till the
Please.
date of hearing. ನೀವು alienate ಮಾಡಬೇಡಿ.
No, madam, we don't, madam. I will undertake, madam. Will not, because suit is
Shall
pending
not create
already.
any third party rights in respect to the property which is the subject matter of the writ petition till next date of hearing.
Please.
Petitioner. Matter pertaining to 79 AB,
2020.
79 AB. Order is 2020, my lord,
Notice
annexure.
ಆಗಿದೆಯೇನ್ರಿ?
17/3/2020.
ಅವ್ರಿಗೆ ಕೇಳೋದು.
17/3/2020 ಆರ್ಡರ್ ಮೇಲೆ.
Annexure.
Notice has not been served ಅಂತ ಇಲ್ಲಿ ನೋಟಿಸ್ ಸರ್ವ್ಡ್ ಅಂತ ಇದೆ. But 17/3/2020 ನಮ್ದು implement ಆಗಿದ್ದು 70
Covered by decision, my lord.
ನಿಮಿಷ ರೀ.
31/5/2020. Your lordship made.
AJ accepts notice for respondents. The petitioner has challenged the order passed as the impugned order dated so and so passed by so and so, wherein it has been ordered to forfeit the land purchased by the petitioner on the ground that it is in violation of section 79A and section 79B of so and so act. The case of the petitioner is that the impugned order has been passed without service of notice to him. Expert ಆಗಿದಾರೇನ್ರಿ?
Expert.
Huh?
Expert.
The learned AG upon instruction expert, the learned AG upon instruction submits that though notice has been issued to the petitioner, there is no evidence in record. To show, there is no evidence to show that the notice was indeed served on the petitioner.
Please.
Full stop. He further submits that petitioner has not participated in the proceedings. Full stop. Next for admittedly, there is no proof of service of notice against the petitioner. To the petitioner by the authorities concerned in the proceedings before respondent number 2. Correct, Andre?
Yes, man.
Respondent number 2. Full stop. Under the said circumstances and also taking into consideration the fact that section 797A and section and B have been subsequently deleted, in the interest of justice, this court is of the opinion that it would be appropriate to remand the matter back to respondent number 2 to reconsider, TO2, reconsider the case of the petitioner in accordance with law by taking into consideration the fact of repeal of section 79A and B of Karnataka Land Reforms Act. ಇದು ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡಿ. 79AB dispose ಅಂದ್ರೆ ಇದೇ ತರ ಬಂದ್ಬಿಡ್ಲಿ ಎಲ್ಲ. Full stop. Hence the following order. ಆ ಲಿಸ್ಟ್ ಯಾವತ್ತು ಹಾಕಿಸ್ತೀರಾ? 79AB.
11ನೇ ತಾರೀಕು.
Okay. Hence the following order. The impugned order dated so and so bearing number so and so passed by
Second.
respondent number 2 is hereby set aside. The matter stands remanded back to respondent number 2 for fresh consideration. And he is hereby directed to take into consideration the repeal of section 79A and B of Karnataka Land Reforms Act and pass appropriate orders in accordance with law. Petitioner is directed to appear before respondent number 2 on 3 weeks bit date.
Needed. This month end needed.
3 weeks bit on date
26
Please.
December.
without further notice.
Obliged.
Yes. ಎಲ್ಲ 3 weeks ಬಿಟ್ಟು ಡೇಟ್ ಕೊಡ್ತಾ ಹೋಗಿ.
Yes.
ಯಾವ್ದಕ್ಕೆ 79AB ಡಿಸ್ಪೋಸ್ಡ್ ಅಂತ ಹೇಳ್ಬಿಡ್ತೀನಿ ಅಷ್ಟೇ. ಇದೇ ತರ ಮಕ್ಕಿ ಕಾಮಕ್ಕಿ ಬರ್ಲಿ.
Not petitioner, my lord.
Hmm.
It is pertaining to Padda.
Pertaining to
Padda land, my lord.
Padda
Bill number
land.
4 is 18.
ನಿಮಿಷ
Adjourn
ಏನ್ ಮೇಡಮ್
proceeding.
ಇದು?
Similar matter is serial number 4. Gangadharappa has appeared on
ಇದರಲ್ಲಿ ಮಾರಿದಾರ
AJ accept notice for respondents.
1 to
10/11/18.
ಮಾರಿದಾರ ಅವರು ಒರಿಜಿನಲ್ ಓನರ್ ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
ಮಾರಿದಾರಂತಲ್ಲ ಸರ್.
My lord, after purchasing the land, we are filing an application for.
Original-
Listen, when the government has held that it's a Pada land, you are not the owner of the property,
No, my
how
lord,
can you sell it?
before purchasing, there is no Padda land.
ಆಯ್ತು ನೋಟಿಸ್ ಆಗ್ಲಿ, ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಳ್ಳಿ ಅಷ್ಟ
10/11/18.
ಬರುತ್ತೆ.
21 Sharan.
Here is my lord, writ of mandamus to consider the representation is annexure H.
ಏನ್ ಅನಕ್ಷರೇಷನ್ ಗೋಳು.
Representation. Land was granted in the year 1998, my lord.
RTC.
Hmm.
Artisan ಹೆಸರು ಬಂದಿಲ್ಲ ಅಂತ, that was my representation. my lord.
But
Consider ಮಾಡ್ತೀರಾ?
return
Objection
RTC
ಆಗ್ತಾರೆ.
ಇಲ್ಲ.
ಇಲ್ಲ,
There is no return RTCs. Return RTC
Instructions ತಗೊಂತೀರಾ?
from the date of this, my lord, grant.
ಆಯ್ತ್ರಿ, ನಿಮ್ಮನ್ನೇನೋ ಕಳ್ಳ ಸುಳ್ಳ ಅಂತಿದಾರ ಅವರು. ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡು ಏನೋ ಆಪಾದನೆಗಳು ಮಾಡ್ತಾರಂತ.
ಅಲ್ಲ, ಕಮಿಟಿನೇ ಫಾರ್ಮ್ ಆಗಿದೆ. Headed by MLA, my lord.
Advocate have a say, sir. They access notice for us.
A date may be fixed, my lord, date may be. Next.
ಬರುತ್ತೆ ಬಿಡಿ ಸರ್.
22 G Manivannan.
Appear for the fifth
Settlement.
respondent. That's a joint memo has been filed.
Hmm.
That's the petitioner and the respondent and other family members are all compromised in the suit. That's compromise petition has been filed in the suit. This property is allotted to the share of the petitioner.
ಅಲ್ಲ,
Let's-
dismiss as withdrawn ಮಾಡ್ಬೋದಾ?
Alla, this property millets with regard to revenue entries are concerned, continued in the name of the petitioner. Because that is the compromise recorded in the suit and millets there is a.
ಯಾರ ಹೆಸರಲ್ಲಿತ್ತು?
I am for the petitioner.
1 second, sir. In whose name the revenue?
That earlier it was put in the name of this petitioner. Subsequently, millets, the suit came to be filed for partition and separate possession. We have challenged the revenue entries and millets, the assistant commissioner is dismissed and then millets, the deputy commissioner has allowed the revision. That order has been questioned before this court, by the petitioner. Now, millets, the suit was, the suit, all family members were compromised.
What is Annexure C, sir? Where is it? Annexure C?
Because this property has been allotted to the share of the petitioner, my lords.
Yes, sir. So now KT,
KT Anjanappa.
1 second, sir. See, KT Ramaya name has to be replaced by KT Anjanappa, is it?
Yes, my lords. In fact, upon the orders of the assistant commissioner, his name has been entered. But this, since there is an order of the
That's okay.
deputy commissioner,
KT Ramaya's, that's with regard to 1 acre of land.
yes,
Yes,
my
sir.
lords,
That's sufficient.
that has to go.
Okay, where is the joint memo?
It's
Joint memo is also filed, my lord.
along with the.
412, along with the compromise petition and the order sheet, my lords.
Yes, one. The petitioner in the instant writ petition has challenged the order by which
Second respondent.
the name of respondent number
5.
5 has been directed to be shown as the owner of 1 acre of land,
Survey number 141.
survey number
141.
141 of
Kolattur village.
ಯಾವ್ದು?
Kolattur.
Kolattur village.
ಪುತ್ತೂರು ವಿಲೇಜ್,
Kasba Hobli.
ಕಸ್ಬಾ ಹೋಬಳಿ,
Hoskote ತಾಲೂಕು.
ಹೊಸಕೋಟೆ ತಾಲೂಕು. In
Yes.
the relevant RTC. Full stop. During the course of the writ petition, petitioner and respondent number 5 have entered into a compromise and they have filed a joint memo. Have you kept them present?
ಇಲ್ಲ. Parties have. ಬಂದಿಲ್ಲ.
These are not present.
Okay, ನಿಮ್ಮಿಬ್ರು ಸಿಗ್ನೇಚರ್ ತಗೊಳ್ತೀವಿ ಆರ್ಡರ್ ಶೀಟ್.
The compromise petition. along
Compromise
with this
petition
joint
is
memo,
before the
that's
civil
the
court.
ಆಯ್ತು, whatever.
Compromise petition has already been filed and
ಆಯ್ತು, ನೀವಿಬ್ರು ಸೈನ್
now definitely.
We accept.
And filed a joint memo dated 4/12/2024. The council, full stop, the council for petitioner as well as respondent number 5 together submit that they have also entered into a compromise in
In the suit.
that they are brothers.
Family.
They are brothers. And they have entered into a compromise. ಯಾಕೋಟ್ ಮುಂದ?
In the
In
court of the
OS
senior civil judge and JMF set Hoskote.
In OS 3015 of 2022.
They have entered into a compromise in
Suit in white.
OS number 3015 of 2022.
which was
Uh,
earlier
before,
2013 of
Senior
2005. my
Civil
lords,
Judge BBMP Hoskote, wherein it has been agreed that the said 1 acre of property has to come to the share of the petitioner herein. And they together pray that a suitable direction be issued to respondents, respondent number 4, to remove.
Remove,
name of-
continue the name of the petitioner because petitioner's name is continued now.
To show the name of the petitioner in respect of the land concern.
And by setting aside the order of the deputy commissioner. The order of the deputy commissioner has to be set aside, my lords.
By setting aside the order of,
Second respondent. Second
by
respondent.
setting aside the impugned order
Please, my lords.
passed by respondent number 2.
RP number 29/2008,
Correct.
Full stop. The learned AG has no objection for the same. Endre, next parada. Learned AG has no objection for the same. Hence the following order. Respondent number 4, the impugned order dated so and so passed by respondent number 2 insofar as it relates to 1 acre of land. Subject matter 1 acre ado.
1 acre.
ಮತ್ತೆ ಹೇಳಿ ಸರಿ ಬರಲ್ಲ.
RTC is also produced.
Passed by so and so in respect of the 1 acre of land in survey number so and so village is hereby set aside. Respondent number 4 is directed to show the name of the petitioner as the one in column number
9 and 12 to
9 and 12
2
plus 2 of
RTC.
RTC of the relevant RTC. Lion muscle 12 of RTC in respect of 1 acre of land in so and so. Yes, and remove the name of respondent number 5.
DCR.
Remove
the name of
ಸರಿ ಅಲ್ಲ
signature.
Removal of the name would not arise because name of the
ಹಾಕಿರೋ
petitioner
RTC ಆ ತರ ಇದೆ ಸರ್.
is considered, it's continued, madam.
ನಮ್ಮ RTC ನಲ್ಲಿ ನೀವು ಕೊಟ್ಟಿರೋ RTC ನಲ್ಲಿ ಆ
As
ತರ
per
ಇದೆ
the
ನೋಡಿ.
compromise ಅಂದ್ರೆ sir, as per the compromise recorded in the
ಆಗ್ಬೋದು.
suit.
ಆಯ್ತು ಇರ್ಲಿ ಬಿಡಿ ಸರ್.
23,
Please.
number 23, KV Narasimhan.
For respondents 2A to 2E. Matter of, I don't know why an early hearing application was filed because last week also it was before this. It did not reach. As they had told me, but the matter did not reach. Could it be heard on Friday? Because it's land reforms matter.
Both of you are ready, we will hear.
ಅಲ್ಲ
it.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ land has been purchased after it vested with the government by the other side. That on May 74, 1374 was the date of vesting.
Okay.
And this is the third round before this one will go out.
Where is the petitioner, sir? Okay, none appears to the petitioner. Advocate for the learned AG is present. Advocate for contesting respondent is present. To hear the petitioner, finally call on.
Friday 2:30, please. It's convenient for the court.
Right? Friday at 2:30.
Oblige.
Friday, 13. 24, Gururaj Kulkarni.
I am for the petitioner, brother. In this case, 4 guntas of land that 4 guntas of land has been mutated in the name of government. You have challenged it before Assistant Commissioner and Deputy Commissioner. Both have rejected our.
Where is the contesting respondent, sir? Contesting respondent, state ready na?
My lord, yes, my lord. Ready, my lord.
ಹೇಳಿ.
That the property in question was purchased.
My lord. But objection has to be filed. Objection. filed.
Objection.
IA, my lord.
Objection.
On IA,
Our
I
IA
have
act-
produced some document
ಆಯ್ತು ನೋಡಿ ಹೇಳ್ತಾರಂತೆ ವಕೀಲರು.
File my objection.
and notice may be ordered meanwhile, because
To
it is a
whom?
21 matter. 21 matter.
ಯಾರಿಗೆ ನೋಟಿಸ್ ಹಾಕ್ಬೇಕು?
ಯಾರಿಗಾದ್ರೂ
ಇಲ್ಲ, ನಾವೇ.
ಆಯ್ತು ಆಯ್ತು.
I'll file my
ತೊಂದ್ರೆ ಇಲ್ಲ.
objection. ನಾವೇ ಇರೋದು.
ನೋಟಿಸ್ ಎಲ್ಲ ಆಗಿದೆ ಅಲ್ಲಪ್ಪ. ನೋಟಿಸ್ ಆಗಿಲ್ವಾ ಇದ್ರು ನೋಡಿ?
ಆಗಿಲ್ಲ
ಅಷ್ಟೇ ಅಲ್ಲ.
ಆಗಿಲ್ಲ
ಎಷ್ಟಾಗಿದೆ?
ಹ?
ನೋಟಿಸ್ ಎಲ್ಲ ಆಗಿದೆ.
ಆಗಿದೆ.
There is no private respondent. You are not sought to impede any private respondent.
Yes, ma'am.
It is
Please.
here.
Please, I go through office objection, kindly have it tomorrow, madam.
Forget about office objections. You have sought to produce additional documents. They will reply to it.
Yes,
We'll
ma'am.
consider it at the time of
Yes.
final hearing.
Please.
Go for final hearing once and for all. ಯಾವಾಗ ಹರೀಶ್, after vacation or before vacation?
ಬಿಫೋರ್ ವೆಕೇಶನ್ ಯಾವಾಗ ಒಂದು ಡೇಟ್?
ಇಷ್ಟ ಆ ಡೇಟ್ ಬೇಡ,
ಬೇಡ.
ಬರುತ್ತೆ.
ಆಯ್ತು.
ಇರೋ ಮಾಟಸ್ ಮುಗಿಸಿದ್ರೆ ಸಾಕಾಗಿದೆ.
ಹಾ.
At the request of AGA, post the matter immediately after vacation. Immediately after vacation.
25, Kashyap N. Nayak.
For the petitioner in this case, my lords.
Yes, sir.
Lord, for respondents.
Yes. Ready both sides?
Respectfully, my lord, parties had been discussing settlement and parties have arrived at the settlement terms also. Because of
Okay.
non-availability of all the parties to sign the joint memo, we were not able to
So when
place
do you
the
want?
same on 17th or 18th of this month if it's convenient to me.
Yes, sir. Is it okay for you? The other side?
Yes, yes, my lord.
18th. We'll have it on 18th.
Please, my lord.
You want it at 2:30, I can keep it at 2:30 also.
Please, my lord.
If you are settling it.
Yes, my lord.
Please.
We have already arrived at the settlement terms. We just
Okay.
need to
At the
iron out
request
the
of
fine.
contesting parties, call on 18th at 2:30
12.
for reporting settlement of the NAC.
Great, my
Great.
lord.
26, Siddharth Suman.
Lord, in this case, my lord, the first case, 21,583.
IPF for respondents 1 and 2, the matter is posted today for hearing on my
lord,
application
they
to
have-
vacate
they
the
have-
interim order.
They have
Then
served
go
the
on to
IA, not given the documents, my lord.
You are ready to go on with the
I
matter?
am, I am.
Final hearing itself.
My lord,
Please.
my lord, here, they have not given the documents.
No, these
They
are
have
documents-
enclosed 3 documents. Without giving documents, I can't meet their.
the documents that are already in their possession. Your
No,
Honor.
it is not in our, then you would not have
Okay.
produced.
It's not in the court's possession.
When do you want, sir?
My lord, the parties are in a village near Shimoga.
You
Next
want
Monday,
the-
my lord.
Parties aren't required for the hearing, my lord.
No,
It's just
I
that
have
they have
taken-
the interim order since.
No, we have to file objections, no? I can't file.
Lord, but
affidavit.
I filed the application on 22nd
Question of
August.
Objections to a vacating stay application not required.
Okay, we will take instructions and make
Okay,
submission.
no question of instructions also. Your writ petition itself is an objection for her.
No, they have
vacating
filed
stay.
certain documents now. We will just go through, take instructions.
You want it on Monday,
Monday, ma'am.
100%?
Please, my lord.
No further adjournments?
No further adjournment.
Oh. At the request of petitioner, finally call on Monday, date put.
Interim order may kindly be extended.
Order if any is extended till next date of hearing. Yes.
27, V. Anand.
Appearing for the petitioner in this matter, lords.
Yes,
Brief fact,
non-compliance of office objections. Yeah, the office objections, sir.
a small objection on this, kindly overrule that objection.
ಬೇಕಾದ್ರೆ ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತೀನಿ, ಕಂಪ್ಲೈ ಮಾಡಿ.
ಆಗ್ಬೋದು sir. ಅದು ಅದರಲ್ಲಿ ಡೇಟ್ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ ಅಂತ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್.
Whatever it is, you just comply with it, pass over. 27 pass over.
28, R. Chidanand Murthy.
Lordship, I'm a proxy counsel, Your Lordship. The counsel is held up in other court hall.
Government
Pass over the,
pass over, pass over.
pass over.
11 officer.
Office objection is
No, Your Lordship, that's a different matter.
also a different matter.
Pass over.
There are office objection, you need to comply with it. I
I'm
don't
proxy
think,
counsel, Your Lordship.
I am for
Client
respondent
has
516, my lord. I am for 516.
you will not be able to comply. 1 week to comply, do the needful on the money.
Please, my lord.
29, Pratham. For 29.
But in this case,
Without notice to the petitioner.
Seek for a pass-over, my lord. May seek for a pass-over. Senior counsel is in another court.
They want a pass-over, sir. Pass-over.
30, V. Srinivas.
Lord, kindly grant a week's time.
Don't wait
We'll
to do the
comply with the officer.
31. Dagmar.
My lord.
This
Survey
case,
number
please,
eight.
Lordship.
Sir, observation is a sir.
But
There is-
Yeah, observations.
of FP subjection annexure E and H, my lord, it's a visible and typed copy in the, I made a submission.
You're not relying on it, huh?
Yes, my lord.
Huh?
Annexure, yes, my lord. It's not in challengeable order. And
Regard to fifth respondent is concerned, your lordship. PM Sadbalappa is filing a power.
Sir, he is ineligible, and it's not legible. Are you relying on it or not?
no, my lord, I'm not relying on them because only the make of submission because that's only the Vibhaga Patra and annexure C, annexure H is the assistant commissioner order itself visible. And we lordship the deputy commissioner order I have challenged here and assistant commissioner also.
ಅಲ್ಲ, ಹೆಚ್ಚುನು rely ಆಗಲ್ವಾ?
H annexure H is assistant commissioner order, which is referred to the civil court. To approach the civil court, that's the order is passed by the assistant commissioner fourth respondent.
No, H you are relying on it, no, sir.
But H is assistant commissioner order.
Fine, you want assistant commissioner order to be upheld.
Yeah, no, it is referred to the civil court. Parties are referred to civil court in the annexure, that one annexure E. And annexure A is the deputy commissioner order.
Sir, listen, annexure, you want upholding of annexure E. And setting aside of annexure H, right?
Annexure A.
I mean, sorry, annexure A.
Annexure A is the deputy commissioner.
You want to uphold annexure H and to set aside annexure A.
Annexure H is only in respect of, because I am not, it is referred to the.
See,
civil-
whatever it is,
Yes, right.
we need to read annexure H. The copy that you have produced, we cannot read it, sir. ಇಲ್ಲೆಲ್ಲ blackout ಆಗಿದೆ, ಅದ್ರ ಇಲ್ಲಿ type ಇದೆ. You comply with it, sir.
My lord, submission,
If they concede, I don't mind.
is a respond number 5, they are a party in.
If they justify annexure H, I mean, sorry, if they dispute annexure H,
It is not disputed because there also both the parties are referred to the civil court. That's only the order is operated. That's the operation portion is there. It's not disputed.
are you ready?
Illa, they have not served copy and today I have instructed to file wakalat for fifth respondent, please, Lord.
1 week for compliance. Yes, sir.
My lord, they are undertaking to filing wakalat fifth respondent.
I will file in the registry,
Do
please.
it, sir. You comply with observation and get it. posted.
Alla.
Yes,
Lordship, date may be fixed, my lord. I'll just file it.
yes, the request of petitioner call on Monday date ಕೊಡಿ, needful by then.
16, 9,
Wait.
16, 12. 32 PM Sidmalappa.
Previous particular. Subject to compliance by serial number 30.
ಸರ್ ನಾನೇ ಡಿಸ್ಮಿಸ್ ಮಾಡಿಲ್ಲ ಅದನ್ನ.
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು ಅಲ್ಲ ನೋಟಿಸ್ ಇದು ಇಂಟ್ರಿ ಮಾಡಬೇಕಿತ್ತು ಎಮರ್ಜೆನ್ಸಿ ಅದಕ್ಕೋಸ್ಕರ
ಸರ್ ತುಂಬಾ ಕಂಪ್ಲೈನ್ಸ್ ಇದೆ ಸರ್. I can't help it. Yeah, that's the reason. Yes. If you want, I can give a passover. You can't comply with those observations now. Correct?
Yes.
That's the reason I adjourned it. Yes.
In this case, Your Honor,
32 other part.
office note,
Then all parties-
they are not necessary parties, please, Lordship. I am not claiming any relief against that persons.
Petitioner submits that all the parties who are not made, the parties who are found in the impugned order, who are not made parties herein.
This is a
are
mandamus
not,
direction, please, Lordship.
Just and necessary parties as petitioner is not claiming any relief against them. Full stop. For the said reason, observations are kept open.
Mandamus direction. I filed the writ petition before this honorable court, please, Lordship, in WP number 26,521 by
They
23.
accept notice for response.
The direction was given by this honorable court, Your Honor. After giving the direction, the respondent number 2 has not considered. I issued a legal notice through annexure in page number 33, please, Your Honor. After issuing the legal notice also, he has not comply the order of this honorable court. Enough that I filed the present writ petition, please, Your Honor. They have not bothered about the order passed by this honorable court. They have not considered. In page number 30, please, Your Honor, annexure F is the writ petition order.
ಇನ್ನೇನ್ರಿ ನಿಮ್ ಆರ್ಡರ್ ನೀವೇ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ತಿಲ್ಲ ಅಂತ.
Implement ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. But they have the coordinator bench of the Honorable Court has directed to implement the same. Once again, they have filed this.
And I issued the legal notice also. In that legal notice,
ಪೀರಿಯಡ್ ಆಗೋಗಿದೆ, ಏನ್ ಮಾಡ್ತಾರೆ ಪಾಪ?
Consider in accordance with the.
with the specific direction other. Otherwise impose the cost, please, Your Honor, if they are not considered within the stipulated time.
ಬನ್ನಿ, ಜಜ್ಮೆಂಟ್ ಇದು. ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್. Passed an order on 16/8/2023, which reads as under. ಇದು ಆದೇಶ, ಪೇಜ್ ನಂಬರ್ 29 ಇರೋದು, ಕನ್ನಡದಲ್ಲಿ ಇರೋದು, ಹಾಗೆ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ. ಆದೇಶ ಪೋಷಣೆ. Full stop. Next line. As the said order was not implemented, petitioner was constrained to file WP number 26521 of 2023, wherein the following order has been passed. Order extract made. Full judgment, 31 and 32. Full stop. Next para. In spite of the order of this court in WP number 26521 of 2023, the authorities concerned have not implemented. Authorities concerned, but respondent number 2 has not implemented the order of the assistant commissioner. Who passed this annexure E order?
The annexure A passed by the
Assistant commissioner order. His own order has not implemented.
Tahsildar, second respondent.
His own
Annexure E.
order. Who has to implement it?
Tahsildar has to be implemented. He entered my name in the mutation and RTC. As per that order.
ಪ್ರಕಾರ ಇವರ ಹೆಸರುಗಳನ್ನು ಸರ್ಕಾರದ ಮಂಜೂರಾತಿ ನಿಯಮಗಳಿಗೆ 15 ವರ್ಷ ಪರಭಾರ ನಿಷೇಧದ ಷರತ್ತುಗೊಳಪಟ್ಟು ಜಂಟಿ ಖಾತೆ ಪಹಣಿ ಮಾಡಿ ಆದೇಶಿಸಿದೆ.
His own order dated 16/8/2023. Hence, the petitioner is constrained to file the presented petition with the following prayers. Extract made. Next para. The learned AGA submits that immediate steps will be taken to implement the order of respondent number 2, and the name of the petitioner shall be entered in the relevant revenue records. Correct, Andre?
Yes, ma'am.
Please.
Yes, ma'am.
Huh?
Yes, ma'am.
Relevant revenue records. Full stop. Hence the following order. Respondent number 2 is directed to implement his own order dated 16/8/2023 and mutate the name of the petitioner in the relevant revenue records within a period of 10 days. 10 days. Yes, 10 days. Huh? From the
15 days.
15 days from the date of receipt of certified copy of this.
Please.
Follow my
But
contempt ಹಾಕಿ. I'm leaving.
otherwise, if
Letter ಬರೀರಿ.
ನಾನು ಇವತ್ತು.
ಅಲ್ಲಲ್ಲ, you have to telephonically inform him
Yes.
that court was about to impose cost on him.
Yes.
Huh? However, on the ground that ಹೊಸದಾಗಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿ ಬಂದೇನೆ ಅದು ಇದು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ನೀವು ಪ್ಲೀಡ್ ಮಾಡಿ
Yes, ma'am.
see to it no cost has been imposed ಅಂತ ಹೇಳ್ಬಿಟ್ಟು see to it that order is implemented.
Yes, ma'am.
ನೀವು ಫಾಲೋ ಅಪ್ ಮಾಡ್ಬೇಕಪ್ಪ.
ಮಾಡ್ತೀವಿ sir. God bless you.
33 V Srinivas. A week's time. I pray for a week's time.
Yes, 1 week to do the needful.
34 Nagaraj.
Order of the assistant commissioner.
Non-compliance ಇದೆ ಸರ್, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನಿದೆ ನೋಡಿ
Annexure D.
ಸರ್. Objections ನೋಡಿ ಸರ್.
Meanwhile,
1 week to
ಅಲ್ಲ,
do the needful.
meanwhile status ಅಂತ.
No, sir. ನಾನು read petition ಸರಿಯಾಗಿ ಹಾಕ್ದಲ್ಲ ಇದ್ರೆ ನಾನು I'm not entertaining it, sir. I cannot make an exception for you. Yes, sir.
35 Saravana, yes. 35.
This objection is that one of the parties is not made. Page 288, your lordships may kindly see me notes. Lords, Karibai Basvaya has died without any LRs. He has executed a will in favor of Jaiswami. Pleadings to that effect, my lords, is forthcoming at paragraph number 2.
R6 is not alive.
R6 is not alive. He has no first class one
The
heirs.
advocate for the petitioner, what about other legal heirs?
Lords, this is the only objection, my lords. This is the only
Allah, what about other legal heirs, sir?
Lords, amongst class 2 heirs, she has executed a will in favor of one of the class 2 heirs, which is made a mention at page number 7 of the writ petition.
Correct, that person has to be made a party, na?
He's a party. He's already a petitioner, second petitioner.
Okay. It is submitted that respondent number 6 has died. And respondent number, petitioner number 2
Two,
has
he's-
succeeded to her estate.
Yes,
Her or his or?
her estate,
Her estate. Full stop. For that reason, office objections are kept open.
please. But,
Next, one ನಿಮಿಷ. AJ accept notice for
1 to 4.
respondents 1 to 4. Issue emergency notice to respondent number 5. Yes.
Lords, page number 32, your lords may kindly take the notes. Page 32. Lords, just to put it in one sentence, my lords. A person claims that he has entered into an agreement of sale in respect of certain properties. Files a suit for injunction. Injunction suit is dismissed. RSA is pending, no interim order. On the basis of that agreement, they have entered the names of that person, my lords, in the revenue entries. This is the case. On the basis of an agreement of sale, the suit for injunction having been dismissed. Lords, may kindly take, my lords, the orders in RA at page number.
What is annexure W?
Lords, that is the orders passed, my lords, by the deputy commissioner at page number 223, 228.
He has just said that avoid the RSA order.
Await RSA order andre suit ವಜಾ ಆದಾಗ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಎಂಟ್ರಿ ಸೂಟ್ ಅವೈಟ್ ಅಂತ ಯಾರಾದ್ರೂ ಬರೀತಾರ? Lords, as a matter of fact, this honorable court has already dealt with this issue. This is the second round of litigation. The coordinate bench had set aside this, the setting aside of the mutation entry was upheld by this honorable court. Remanded the matter back to the assistant commissioner to decide on the MR number 1 of 2000-2001, which is based on an agreement. It's based on an agreement. Making a mutation entry is unheard of. It doesn't come within the purview of section.
Put of the plaintiff is decreed with cost ಅಂತ ಹೇಳ್ತಾರೆ.
Next RA. Page number 126. I'm sorry, page number 125. OS number 363 is challenged. At page 144 is the order. Appeal is allowed with costs.
So the RA judgment,
Lords, at page number 144, the ARIA judgment commences at page 125. 28th February 2023.
now acquired property.
Lords, no, it is not acquired. Lords, may I just give a
One
brief?
second, one second.
Sorry, my lords.
None. The case of the petitioners is that they are the owners of the property concerned. And respondent number 6, based on a concocted agreement, correct, Andre?
Please, my lords.
Obtained a decree in OS number
363
363
of 1999.
of 1999, from the city civil court, civil court,
Lords, on the file of the Principal Civil Judge, Bangalore Rural District.
from principal civil judge, Bangalore Rural District. And the same was reversed in RA number
38 of 2021
38 of 2021 in
by
favor
the fourth additional Senior Civil Judge, Bangalore Rural District.
in favor of by so and so, in favor of the petitioners here, full stop. However, it has been ordered that the revenue entries should be changed in the name of respondent number 6 by way of impugned order. Respondent number 6, Andre,
Respondent number 6, my lords.
did it stand in?
Respondent number 5. Respondent number 5.
Who is the respondent number 5?
Lords, respondent number 5 is the person who claims to be an agreement holder.
The respondent number 5.
Please.
Respondent number 5. Early the impugned order lathara elver there.
Lords, kindly have a look at the impugned order, my lords, at page 234. Lords, Assistant Commissioner has set aside MR number 1 of 2001, by virtue of which his name was entered. Deputy Commissioner has set aside the entries, my lords, set aside the orders passed by the Assistant Commissioner. The Assistant Commissioner's order, my lords, is at page number 227.
Full stop. For that reason, there shall be, for that reason, respondents 1 to
4. 1 to 4, my lords,
are directed to maintain status quo
regarding revenue entries.
regarding the revenue entries, respect of the lands which are the subject matter of the writ petition till next date of hearing.
Please, my lords.
Full stop. However, it is hereby, yes.
Please.
36, G1.
Allowed, two office objections. One is with regard to court fee, my lord, which has been paid. Others is, my lord, page numbers are not legible. My lord, I'm not relying upon those page, my lords, because it is an admitted fact. My lord, the only limited question is,
Yes.
Assessment-
All submissions kept open. Who accepts notice? Commissioner of Income Tax.
my lord, Raviraj takes notice.
So and so accepts notice for response. Interim order beka?
Mouse,
Yen be?
no precipitative action in pursuance of
Why,
annexed.
on what ground?
My lord, that is non-est order, my lord, passed beyond the period of limitation. That's one ground. Second is that, my lord, the assessing officer who initiates and the assessment proceedings. And my lord, on the verge of completion of the assessment proceedings, he gets transferred. The new incumbent takes my lord, charge. He doesn't intimate as per the provisions of the act under section 129. And he passes an order.
Impugned order lida.
My lord, annexure P is the impugned order. Page number. My lord's 364. Last date is, my lord, 31/3/2024. Now order is passed on 25/10/24.
No. Assessment year 22-23 alva.
Yes, ma'am. Last date to pass an order is on 31st March 24, my lord.
Where do you get it?
That is under the proviso to section 153.
Put it.
Lords, can you take this, my lord?
Income Tax Act.
For assessment year 22-23. My lords, can you take, my lord, page number 1.1039 on top, my lords. 1.1039, my lords, 153 section. Third proviso,
Section yadu.
153. Now page number ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
Okay.
Section 153, 1.1039. My lord, sir. My lord, sir. Provided also that, my lord, on the right side. 1.1039 on page, my lord, sir. Provided also that, fourth proviso, that in respect of an order of assessment relating to the assessment year commencing on or after the first day of April 22, the provisions of this subsection shall have effect as if the words 21 months, the words 12 months had been substituted. So, my lord, 22-23. 22-23, 12 months from the end of the assessment year will be 31st March 24. Lordship, smell.
So this is a 153C proceedings, sir. 153 proceedings, sir.
Yes, 143 proceedings. 153, my lords, prescribes the time limit for completion of assessment, my lords. Under any circumstances, my lord, any exceptions are also, my lord, considered. The assessment is beyond the period of, my lord, limitation prescribed under the act.
Where is,
Prima facie, my lord, is barred by limitation. That's
Raviraj,
all.
have you served it on him?
No, I don't notice is that to be ordered.
You
Last-
serve it on him, I'll call it tomorrow.
Please, please.
Yes, so and so is directed to accept notice for.
Respondent 1 and 2.
I call her. For consideration of interim prayer, call on, not a date put.
Please.
RP Somsekharya.
Only minor subjections, but not stitched properly. I am seeking for writ of mandamus to dispose of the appeal filed in the year 2022, my lord. Till today, my lord, not even a single sitting was there, my lord. Therefore, my lord, the necessary direction to dispose of the appeal as early as possible.
Source of the. Notice.
ಅದೇ ಒಂದು ಟೈಪ್ಡ್ ಕಾಪಿ ರೆಡಿ ಇದೆ ನಾಟ್
Sir, ಮಾಡಿ, sir.
ಅಲ್ಲ ರಿಟ್ ಆಫ್ mandamus.
Sir, you have not made all the parties to the proceeding.
ಅಲ್ಲ ಅವರು ನೆಸರಿ ಪಾರ್ಟೀಸ್ ಇಲ್ಲ ಅಂತ ಫಾರ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ದಿ ಅಪೀಲ್ ಮೇಲೆ ಫಾರ್ ಡಿಸ್ಪೋಸಲ್ ಆಫ್ ದಿ ಅಪೀಲ್ ದೇ ಆರ್ ಆಲ್ ನಾಟ್ ನೆಸರಿ ಪಾರ್ಟೀಸ್ ದೇರ್ ಫಾರ್ಮಲ್ ಫಾರ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ದಿ ಅಪೀಲ್ ಮೇಲೆ
Speed is disposal they are seeking, man.
ಸ್ಪೀಡ್ ಇಸ್ ಡಿಸ್ಪೋಸಲ್ ಅಷ್ಟೇನೆ.
ಅವ್ರ ಪಾರ್ಟಿಗಳನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
ಅವರು
ಪಾರ್ಟಿ
That's it.
ಮತ್ತೆ ಇಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು ಫೈನಲ್ ಆರ್ಡರ್ ಶೀಟ್ ಏನಿದೆ ಅಂತಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು.
till today, my lord, not even a single this thing has been done.
I'll call it next week.
Yes,
We'll just see.
I'll get the
I'll say compliance by then.
Please, my lord.
Yes, at the request of AGA. Accept notice for respondents. Call on next week date today, compliance of all
Please.
section by then. Yes.
38, VB Sidramaya. Number 38,
1 week to do the needful.
39. Yes, Mallikarjunaya.
Week's time may be granted.
Yes, same order.
40, Allah Baksha.
For the petition, my lord, private parties are not made, maybe not necessary, and the keeping the objection, my lord, the extreme urgency, my lord. My property measures 500 square feet, my lord, illegally demolish agide, impugned order agad 4 ದಿವಸ ಹಿಂದೆ ಸ್ವಾಮಿ. Impugned order is passed on 24.
4 observations notice. Sir.
My lord.
If you want, I'll give you a passover.
Please, my
complaint
lord,
letter.
pass over. I'll pass
Pass
over. Please.
41, KV Narsimhan.
Of mandamus.
Number 41,
My lord, an office objection with regard to IA.
Earlier matter, why you didn't attend? Serial number 23. Serial number 23 is from you. You only appear, na?
No, my lord.
20.
Senior, they were held up in another portal.
Whatever. Friday, no, agida.
My lord.
13,
Yes, what is the serial number 41? Put it.
41.
My lord, an office objection has been made in IA, my lord. With regard to mention of annexure J, there is no annexure J, my lord. Same may be overruled.
Writ of mandamus, my lord, it is under process. Their application is under process. 53 application.
No action has been taken since 2021.
Observation overruled. Then regularization,
It is under process, it will be completed in another 3 months.
6 months already dispose ಮಾಡ್ತೀರಾ?
Yes,
Huh?
yes.
We'll allow it.
Yes, my lord.
KJ accepts notice for respondents. Observation overruled. KJ accepts notice for respondents. Next judgment. The petitioner has made a representation to respond number 3 and 4. Made the necessary application. Made the necessary application to respond number 3 and 4 for grant of for regularization of
Unauthorized cultivation.
unauthorized occupation
Conflict.
and cultivation of land which is the subject matter of the petition in his favor. Full stop. As the same has not been considered so far, the present petition is filed with the following prayer. Prayer is done. Interim prayer, bari prayer. Full stop. Next para. The learned AG upon instruction submits that the request to the petitioner is being considered by the authorities concerned, and suitable orders will be passed as expeditiously as possible. Full stop. Submission is placed on record. Respondent number 3 and 4, hence the following order. Respondent number 3 and 4 are directed. Consider the application of the petitioner and pass appropriate orders within a period of 6 months.
Yes.
Within a period of 6 months from the date of receipt of certified copy of this order.
That's all, lord.
42, Sumana Naganan.
The delay, my lord, Supreme Court's order, my lord, is at page 85. Question of limitation, my lord, is something which had to be considered.
For 2 days accommodation for this, verify the law.
It will have it after vacation, no hurry in this one.
Please.
Delay may
We'll
be,
have it immediately after.
delay may be condoned, my lord, because specific question was framed by the.
All right, we will.
Posted for
take it
others
after.
after vacation. Date may be fixed, I will argue on that.
The provision of law.
Please, whether it is
Article 82 or
not
130.
argued before this court
Please, it's argued.
by any of the counsel. But in Supreme Court, it was mentioned that in disregard of that provision, order has been passed. Okay, you show the provision of law now itself.
Please.
Okay, that's how it is. Anyway, we'll have it after vacation. At the request of petitioner, call on
Respondent.
Respondent, my request.
respondent, call on date quarter after vacation.
8/1/25.
Publish.
Yes.
43 Rajendra MS. Serial number 43.
Last occasion, my lords, government advocate was directed to procure records in these matters, also to file objections.
Yes, comment.
Secure,
Ready na?
ready.
Go on.
Objection. Objections already. Objection.
Section Akila.
My lords,
Go on with the matter. Ready?
kindly it may be passed over, my lords. We are ready with the matter. Passed.
Pass over.
Please, please. Pass over.
Pass over.
Server by
You want the pass over? You want time or what?
Not like that, but in fact, record ಬಂದ್ರೆ ಅವರೊಂದು if you put on some statement.
Sir, if both parties are ready, I will hear the matter.
Yes.
You want time, I will grant you time. What do you want? Tell me.
Yes, it will pass over. Pass over.
Pass over.
Please.
Check ಮಾಡಿ government records ಇಬ್ರುನು argue the matter. Yes.
54 Shruti C. Chagandi. 44
What I pay for respond number 8.
My Lord, I appeal for the petitioner in this matter, 44. Lord, Mr. Senior Advocate, Mr. Udayhol has engaged in the matter. He's on his legs in another court.
What do you want? You want a pass
short-
over or adjourn?
A short accommodation if my Lord would
My
permit.
lord, there's some urgency for us, my lord. There's a
ಬಂದ್ರಲ್ಲ,
interim
senior
stay
ಬಂದ್ರು.
ready.
There is third matters in the afternoon. My problem is that immediately after vacation,
When do you want?
immediately after the vacation, ಹಾಕೊಂಬೇಡಿ ಮಾಡ್ಬಿಡೋಣ.
My lord, it's a short matter, my lord. You were-
ಇಲ್ಲ, I'll tell you lot is why.
ಹೇಳಿ,
Sir,
It is
ಹೇಳಿ,
ಪೋಡಿ,
Both of you,
ಹೇಳಿ.
ನಮ್ಗಳು
ಪೋಡಿ
ನನಗೆ
ಅಂತಿದೆಯಲ್ಲ,
ಗುರುಗಳಿದ್ದಂಗೆ.
ಸಿಕ್ಕಾಪಟ್ಟೆ.
ಅಲ್ಲ ನನಗೆ ಗುರುಗಳಿದ್ದಂಗೆ ನೀವು ಈ ವಿಚಾರದಲ್ಲಿ
ಇದೆ, ಇಲ್ಲ,
ಕಿತ್ತಾಡಬಾರದು.
ಸುಮಾರು ಹೊತ್ತಾಗುತ್ತೆ.
There has to be consensus.
Too much of this thing is there because of
ಬರೀ ಇದು
ಪೋಡಿ revenue records ಅದು all that my lord. So immediately after the vacation ಹಾಕೊಳ್ಳಿ. First week ಅಲ್ಲಿ ಯಾವಾಗ ಬೇಕಾದ್ರೆ ಹಾಕೊಳ್ಳಿ ಅವ್ರಿಗೆ. ಅವ್ರ ಡೇಟ್ ಕೇಳ್ಬಿಟ್ಟು ಹಾಕೊಳ್ಳಿ. Whenever my learned friend wants, let's have it. ಯಾಕಂದ್ರೆ ಎಲ್ಲ ಪಾರ್ಟ್
ಡೇಟಿಗೆ ನೀವಿಬ್ರು ಈ ತರ
No, I understand. But what has happened is, third matters are too many, my lord.
Yes.
ಅದು ಏನಾಗುತ್ತೆ, ರಜಾಕ್ ಬರ್ಬೇಕಾದ್ರೆ ಮುಂಚೆ, all those matters, my lord, we will have to, judges also, my lord, don't know whether they'll be here, they'll go to Dharwad or Gulbarga, so ಹಾಗಾಗ್ಬಿಟ್ಟು, ಯಾವತ್ತು ಹೇಳಿ? ನಿಮಗೆ, ನೀವ್ ಹೇಳಿ.
ನೀವು ಹೇಳಿ sir, ನೀವು
ಕರ್ನಾಟಕ.
ಪುಸ್ತಕರು.
I am asking for time now, therefore.
No, it's okay. You are, I cede my,
ಆಯ್ತು, 13, 14, 15 ಯಾವತ್ತಾದ್ರು ಹೇಳಿ.
ಅದಕ್ಕೆ ಮುಂಚೆ ಆಯ್ತಾ?
8 ಅಂದ್ರೆ ರಿಓಪನಿಂಗ್ ಹಂಗೆ ಆಗುತ್ತೆ ರೀ ಅದು. 6ನೇ ತಾರೀಕು ಕೋರ್ಟ್ ರಿಓಪನಿಂಗ್.
ಏನೋ ಅದಕ್ಕೆ
ಇಲ್ಲ. ಯಾಕೆ ಎಲ್ಲಿ ಇರೋದಿಲ್ವ ನೀವು ಆಮೇಲೆ?
ಇಲ್ಲ, ಇರ್ತೀನಿ.
14, 15 ಯಾವತ್ತು ಹೇಳಿ ನೋಡಿ.
13th ಆಗುತ್ತಾ?
ಆಯ್ತು ಮಾಡು.
13th.
Monday.
The request of parties call on 13.
13/1/25.
Grateful.
45 HT Natraj.
ಖಾತಾ ಚೇಂಜ್ ಮಾಡಿದ ಮ್ಯಾಂಡಮಸ್ ಹಾಕೊಂಡಿದ್ದೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತು.
We'll consider in accordance with them. By securing the record,
Representation made in the year 2018.
go through the documents and I'll consider.
They will consider.
ನಾನು ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ.
Because documents ಇದೆಯಾ ನೋಡ್ಬೇಕಂತ ಅದಕ್ಕಾಗಿ. We'll
ಗ್ರಾಂಟ್
consider
ಆಗಿದೆ,
in
ಕನ್ಫರ್ಮ್ ಆಗಿದೆ, ಗ್ರಾಂಟ್ ಆಗಿರೋದು. Annexure D, my lord, is grant order is confirmed by this on the court.
Yes, the petitioner. Petitioners on the matter. Have requested respondent number 2 to change the kata in respect to the lands which are the subject matter of the writ petition in their name, full stop. As the same has not been done so far, the present writ petition is filed with the following prayer, extract mark. The next learned AG upon instruction submits that the request of the petitioner shall be considered in accordance with law and appropriate orders shall be passed. Full stop. This submission is placed on record. Hence the following order. Respondent number 2 is directed to consider the request of the petitioner and pass appropriate order within a period of 3 months from the date of receipt of certified copy of this order. Yes.
46, read on. 46, waiting for the respondent, my lords. My lords, matter may be taken up at 2:30 PM, my lords.
Yes, so the
Senior is
request-
on his legs, my lords.
ಇದರಲ್ಲಿ I have been directed to secure records. Records ಎಲ್ಲ KT ಇಲ್ಲಿ held up ಆಗಿದೆ. ನಾವು ಲೆಟರ್ ಬರ್ದಿದೀವಿ. but
ಇದ್ರಲ್ಲೂ ಇದರ
ಅಲ್ಲ ಅದರಲ್ಲಿ
3 months.
ಪ್ಲೀಸ್
KT
You want to secure record? Yes.
have been directed.
It may
to
be
secure
taken after
affected
vacation,
records,
madam.
but it's
At the
KT
request
or-
of respondents, call after vacations.
My lord, interim order may be continued.
Interim order, if any, is extended till next date of hearing. 46.
47, B
Right.
R Vishwanath. 47,
5 to 7. Kindly adjournment, please, after vacation.
At the request of respondents, call after vacations.
48. Ajay, JN.
Lords, I appear for the petitioner, my lords. My lords, it's a matter, my lords, where notice for attachment was issued without hearing. My lords were inclined to remand the
Even
matter
our-
back, asking them to give a copy of all the documents. Respondents 3 and 4 also would have to be heard because they are, we were allotted the plots by the Bombay.
Let it come out of vacations.
Yes.
Yes, sir. None appears for respondent, the contesting respondents.
Interim order may kindly be extended.
Call after vacations, interim order, if any, is extended. till
ಯಾಕೆ
next
ಸುಮ್ಮನೆ
date of
ಹೋಗ್ತಾ
hearing.
ಇದೆ ಅದರ್ವೈಸ್ ಇಟ್ ಮೇ
ಏನ್ ಮಾಡೋದಪ್ಪ ಬರ್ಬೇಕಲ್ವಾ?
ಕೊಟ್ಟಿದ್ರು ಕನ್ಸೆಂಟ್ ಕೊಟ್ಟಿದ್ರು
ಅದ yes, call after vacations. Yes. Interim order extend ಮಾಡಿ ಅಷ್ಟೇ.
48, 49, Radha Nandan, BS.
Hmm.
The lands were allotted in my favor
Hmm.
in the year 1979.
Hmm.
The very same land has been allotted
Hmm.
in favor of the State Intelligence Department.
Hmm.
And the claims were decided by the Deputy Commissioner in pursuance of the
Come.
order that was passed by this honorable.
Comment.
I have to file my objection. File my objection.
Short date,
Start date ಕೊಡಿ.
ಯಾವಾಗ?
ಕೊಡಿ, any date ಮೇಲೆ.
Next week, Friday,
ಯಾವಾಗ?
this Friday or
Any date ಮೇಲೆ fix ಮಾಡೋಣ.
ಇನ್ನು ಯಾರು ಇಷ್ಟೊಂದು ಜನ ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದಾರಲ್ರಿ?
Swami, ಅದರಲ್ಲಿ the claim and counter claim only belongs to the petitioner and the State Intelligence Department.
ಸೇಮ್ ಪ್ರಾಪರ್ಟಿಗೆ ಇದು ಮಾಡಿ.
ರೆಸ್ಪಾನ್ಸ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ ಸ್ವಾಮಿ.
Expense
ಯಾವಾಗ
ಆಗಿದೆ.
ಹಾಕ್ತೀರಾ?
16, 17 ಯಾವಾಗ ಒಂದು ಡೇಟ್.
ಆಯ್ತು.
13 ಕೊಟ್ಟಿದೆ ಸ್ವಾಮಿ.
16 ಹಾಕ್ಲಾ? ಹಾ?
ಕರ್ಸ್ತೀನಿ, ಫೋನ್ ಮಾಡಿದ್ದೀನಿ.
ಅದೇನಿದೆ ಅದ್ ಮಾಡಿ ಅಷ್ಟ. ಗ್ರಾಂಟ್ ಆಗಿದೆಯೋ ಇಲ್ವೋ?
I'll file my objection and
Yes, so the request of.
During the pendency of the writ petition that was granted, that's also finds a place in the grant order pass.
16
The request of AGA colon 16.
Hello.
Ajjan, 51. Subramania, yes. Murgeshwi Charat.
Appearing for petitioner, my lord.
Respondent.
We pray for time, my lord.
After vacations. He wants time after vacations.
Your lordship kindly pass over to senior.
Madam, she wants time. What's the?
ನನ್ಗೇನು ಅಭ್ಯಂತರ ಇಲ್ಲ. ಬೆಳಿಗ್ಗೆ ಹೇಳಿದ್ರು ಅವರು ಟೈಮ್ ತಗೊಳ್ತೀನಿ ಅಂತ. ಸೊ ಅದಕ್ಕೆ ನಾನು
ಆಯ್ತು, after vacations ಬರ್ಲಿ ಬಿಡಿ.
ವೆರಿ
52, MG Kumar.
I am for the respondent number 5 in this matter.
ಇದು 51 at the request of petitioner ಅಂತ.
The petitioner has challenged the order passed by special deputy commissioner.
Yes, where is petitioner, sir?
MG Kumar.
All that the DC has said is
52.
go to civil court and prove your identity of the property.
Because
That is
sir-
the simple matter.
Let him come, he is absent. If the none appears to the petitioner, call after vacation.
Date may kindly be fixed, my lord. Otherwise,
No, date ಕೊಡಿ.
9. 9/1/25. Fifty-three, Ajjan, 54. Arnav A. Bagalwadi, Nitin Prasad.
For respond number 8 in this government.
54. Arnav A. Bagalwadi.
What do you do, sir?
My lord, the petitioner is claiming
Will
To be
pass
the-
over.
Sir, 54.
Senior counsel is on his way.
Will pass over. Pass over, sir.
very well.
Bandrula.
Counsel, sir.
Bandru.
Lords, we have filed a rejoinder so far as their response is concerned. No. The order under challenge is a 4D exercise, my lords, under 56. Where the state government suddenly says that my land is a forest land. Now, how they come into this being, we do not know. But they say, I have not made any claim against them. But they get implicated and to say now that I have no title itself. If they say that I have no title, they have to establish that in a civil court. Since I am not claiming any title against them, if my pleadings are seen. The order under challenge is under.
Comment, are you ready? Your role becomes important.
And now suddenly government files a counter to say, this is an inarms land, so I have lost my right long back. For the first time in a counter, they bring about that.
My lord, Pattandura
Matter has to
Alkahara
be
village
heard
was
now.
entirely in arm land.
Himself, let me complete. Let me complete. Now it is a dispute between me and the government. It's a matter which was remanded, matter which is being considered. It's an order passed under 56. Now they get themselves implemented. And in fact, they have produced their sketch which shows that I have my land. Their own document shows that my land is intact. Today, their attempt is to throw me away so that they can get an access to the main road. That's the, but I have not claimed any aspect. How they come into the picture, my lords, it's something.
Today.
The order under challenge. You will not see the Kurapa. Give the petition. Title. Source of title. Copy. Lords, we are just prepared on flow of title. May I just pass it on, my lords? How I
What
claim
is the
title.
challenge I want to see? Putting?
My lords, the order under challenge is, my lords, annexure R at page 121.
Annexure yes ಅಂತ ಹೇಳಿದಿರ ಇಲ್ಲಿ ಯಾವ್ದು?
R and R1, my lords.
No.
ಅಲ್ಲ ಇಲ್ಲಿ yes
Annexure
ಅಂತ-
Yeah, S is only a subsequent thing. What is under challenge?
Petition ಹಾಕಿದ್ದೀರಾ?
ಎಲ್ಲ ರಿಮಾಂಡ್ ಆಗ್ಬಿಟ್ಟು ಎಸ್ ಇಸ್ ದಿ ಫೈನಲ್ ಆರ್ಡರ್. Annexure yes.
ನೋಡಿ ಪೊಟಿಷನ್ ಆಗಿರಲ್ಲ.
Lords, I have the only the amended written.
ಅಲ್ಲ ಅಮೆಂಡೆಡ್ ಪಿಟಿಷನ್ ಇದೆಯಾ?
Amended, my instructions are, it is only cost title was amended, where implemented dams.
ನೋಡಿಯಪ್ಪ ಬನ್ನಿ ಇಲ್ಲಿ ಕೋರ್ಟ್ ಆಫೀಸರ್.
Page 15 of the writ petition, your lordship may kindly see
Perfect.
main prayer.
ತೋರಿಸಿ
Them only start.
ನೀವು amendment
ಮಣಿಂದ್ರ ಅವ್ರಿಗೆ
ಕೊಡ್ತಾ ಇದ್ದೀನ್ರಿ.
ಗೊತ್ತಾಯ್ತು, ನನ್ನ ಹತ್ರ
ಸ್ಟಾರ್ಟ್ ಮಾಡಿಲ್ಲ ನಾನು. ಕೋರ್ಟ್ ಅವ್ರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಪ್ರೇಯರ್ ತೋರಿಸಿ ಅವರು. ನೋಡಿ ಇಫ್ ಯು ಕ್ಯಾನ್ ಟು ಡೂ ಸಮಥಿಂಗ್. ಅಲ್ಲ ನೋಡಿ ಪಣಿಂದ್ರ ಇದು.
Sorry.
What has been amended is
ಸರ್ ಐ ಲುಕ್
challenge is annexure, yes. No, my learned friend got irritated because I
Because
tried
they
to
seem
show
to be
your
more-
lordship.
ಇಟ್ಸ್ ಆಲ್ ರೈಟ್. ಇಟ್ ಹ್ಯಾಪನ್ಸ್.
Yeah, we will have to bear.
ಇಲ್ಲೊಂದಿದೆ, ಅಲ್ಲೊಂದಿದೆ.
ನಾಡದ್ ಹಾಕೊಳ್ಳ ನೋಡ್ಕೊಂಡ್ ಬರ್ತೀರಾ?
Lords, have it on 13th. Lords.
My lord,
ನಂದ್ರಲ್ಲಿ
my
R
lord,
and
there is
R1.
some urgency for me, my lord. I will tell your lordship what it is. My lord, the plot number 6 in Kadgodi plantation is an industrial area. Entire Kadgodi plantation number 1 earlier by mistake, the forest department declared as a forest land.
ನಿಮಿಷ ರಿಟ್ ಪಿಟಿಷನ್ ಕೊಡಿ.
And this honorable court held it was not a forest land.
No, but you should tell me. what
It was
is
about
this?
711 acres of land in Kadgodi plantation.
What is this now? Is the year 18?
The then government of the British government declared it as a plantation, as a forest land and a reserve forest subsequently. But this honorable court,
My lords,
ಕಮ್ ಟು ಪೇಜ್ ನಂಬರ್ 130.
1,
ಹತ್ತನೇ ಕ್ಲಾರಿಫೈ.
Yes, my lords. annexure S. 130, subject to correction, my lords. 130 is 129 annexure S. your lordships mentioned 130, my lords.
ಇಲ್ಲಿ 130 ಅಂತ ಇದೆಯಪ್ಪ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ.
So. my lords,
ಆಯ್ತು, ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್, ಇದು
that's
ಭೂ
impugn-
ದಾಖಲೆಗಳ ಜಂಟಿ ನಿರ್ದೇಶಕರ
Correct, my lords.
ಜಂಟಿ
28/9/2018 order.
28/9/2018. ಹಾ,
Yes, my lords.
ಇದೊಂದೇ ತಾನೇ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು, ಇನ್ನೇನಾದ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಾ?
It appears the amend ಮಾಡಿ ಅವರು ಅಲ್ಲಿ ಕಾಸ್ಟ್ ನಂದ್ರಲ್ಲಿ R&R1 ಅಂತಿದೆ. ಇಲ್ಲಿ ನೋಡಿದ್ರೆ ಅಲ್ಲಿ ರಿಟ್ಟಲ್ಲಿ ಹಾಕಿರೋದು ಎಸ್. I have concentrated on R&R1. Unfortunately, yes ಅಂತ ಇಲ್ಲಿ ಬಂದಿದೆ.
They're all the same orders, man. Repeatedly.
ಆಯ್ತು, I'll do one thing. I'll call it on 11th. Is it okay? To do the repairs, ಅವ್ರಿಗೇನೋ urgency.
11th. ಆಯ್ತು. I'll just go through this annexure.
You go through it, ಬೇಕಾದ್ರೆ ಇವಾಗಲೇ ಈ ಫೈಲ್ ತಗೊಂಡು ನೋಡ್ಕೊಳ್ಳಿ, ನೋಡಂಗಿದ್ರೆ.
ಎಲ್ಲಿದೆ case?
ನೀವೇನ್ ರಿಪೇರಿ ಮಾಡ್ಬೇಕು ಮಾಡಿ, ವಿಲ್ ಟೇಕ್ ಇಟ್ ಅಪ್.
Civil court, 11th. Malad. 12th is.
ಆಯ್ತು, 12th ಹಾಕುವ.
12th, I mean, Dharwad in a part 3rd. 13th is okay.
13th nice matter ಗಳಿದಾವೆ.
ಆಯ್ತು, ನೀವ್ ಹೆಂಗಿದ್ರು ಇರ್ತೀರಾ ಇದೊಂದು ಜೊತೆ.
Very well, Malad, let it be there on the 13th.
13th ಹಾಕು.
Malad, I will explain my difficulty on that day because Malad, 1974, 78 acres has been given to me. That is an industrial area. This survey number.
Hear it on
You
13th.
very well, Malad.
There are 90 matters listed today. Even I don't have much time.
Sorry, my lords.
It's all right.
Unfortunately, I have been only on that. ಅದ್ ನೋಡಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ if your lordships are not.
That's the reason.
That I was only trying to help you by saying it's an answer, yes.
I'm sorry.
ನಿಮ್ಮ ಹತ್ರ ಒಂದು ಕಾಪಿ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ.
ಅವ್ರಿಗೆ I don't know what's happening in this.
55. Vasant
The request
Kumar,
of parties call on 13th.
13th.
13. HT Vasant Kumar, DS Manjegowda.
Challenging the impugned order passed by the second head to the respondent deputy commissioner. But annexure. Page 30, my lord. The petitioner father on Chelvaya had succeeded the property bearing survey number 11/37, measuring 12 guntas with foot karab of acre of 22 guntas, totally 39 guntas, my lord.
One
Who's-
second, sir. Wait.
Through his family partition. But he said the foot karab was not reserved for any public purpose. The petitioner was cultivating entire.
Sir.
Fine.
Yes, are you ready, Mr.
Yes.
Government? Ready.
The petition was cultivating the entire 13 guntas of land on the past 40 years, may not say. For which he made representation before the fourth respondent Tahsildar to claiming the rights of the 22 guntas and regularize the 22 guntas for agriculture purpose. After he referred the matter to the revenue inspector to conducting survey, and he conducted survey and submitted the report, my lord, before the third respondent, fourth respondent Tahsildar. He referred the matter to the assistant commissioner to classify the for agriculture purpose and regularize the 22 guntas of A foot karab. After considering the applications and the facts and circumstances, the assistant commission passed in an order. Kindly annex the may kindly be seen, my lord. The operative portion of the page 15. Adesha Sankhya LND DCR 48 number 9899, dated 16/8/1999. ಈ ಪ್ರಸ್ತಾವನೆ ಮೇಲಿನ ಅಂಶ ಮತ್ತಿತರ ವಾಸ್ತವಾಂಶಗಳನ್ನು ಗಮನದಲ್ಲಿಟ್ಟುಕೊಂಡು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿದ ನಂತರ ಕರ್ನಾಟಕ ಭೂಖಂಡ ಅಧಿನಿಯಮ 1984 ಕಲಂ 7(3) ಅಡಿಯಲ್ಲಿ ದತ್ತವಾದ ಅಧಿಕಾರದಂತೆ ರಾಮನಗರ ಜಿಲ್ಲೆ ಬಿಡದಿ ಹೋಬಳಿ ವಾಜಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 11/37 ಪೈಕಿ 22 ಗುಂಟೆ ಫೂಟ್ ಏಕರಾಬ್ ಜಮೀನನ್ನು ಕಾಯಮಿಟ್ಟು ಹಾಲಿ ಜಮೀನಿಂದ ಫೂಟ್ ಕರಾಬನ್ನು ಸಾಗುವಳಿ ಕಲಂನಲ್ಲಿ ತಂದು ಆಕಾರ್ ಬಂಧುವನ್ನು ನಿಯಮಾನುಸಾರ ದರಖಾಸ್ತು ಮಾಡಲು ಆದೇಶ.
Second, sir. Wait. Where is the RTC, sir?
In RTC, in my name only, in respect of 39 guntas, after passing the order by the assistant commissioner.
One second. Government, as per your records, what is the extent of survey number 11/37?
11/37.
Hmm.
One acre 22 guntas.
ಖರಾಬ್ ಎಷ್ಟು?
Karab, Karab is,
22 ಗುಂಟೆ.
22 ಗುಂಟೆ.
A karabo, B karabo, sir. It doesn't look like 22 guntas. It looks like 25 guntas. That's the reason I'm asking.
25 guntas is a B Karab, 22 guntas is a A Karab, which was followed to share my share. I am filed the application for classification of agriculture.
Karab or not, B Karab, it has not been classified as A Karab or B Karab, man. It's a Karab land.
You can't say like that. See, A karab is owned by
Owner.
the private individual. B karab is owned by the government.
Yes, ma'am. Therefore,
No,
my lord,
you have to necessarily get instructions regarding
therefore, my
how
lord,
much is
the
A karab,
deputy
how much is B
commissioner- my lord,
karab.
one submission. Therefore, the deputy commissioner has ordered to be remanded back to the Tahsildar, saying that go through with the document, whether it is a Karab land, it's classified as a B Karab or A Karab, and then secure the records from the both the parties, then inquire about the Karab land, then you pass a necessary order like this. The deputy commissioner has been passed order, my lord, and remanded back to the Tahsildar, my lord.
When not remembered.
That order I'll Adesh I'll read, man. ಮುಂದುವರೆದು
Question commission ಮಾಡಿದ್ದಾರೆ ಸರ್. ತಹಸೀಲ್ದಾರ್
ನಿರ್ದೇಶಕರು wait.
ತಹಸೀಲ್ದಾರ್ ಗಲ್ಲ ಅಥವಾ
ತಹಸೀಲ್ದಾರ್ ಬೇಡ,
ನೀವು ಹೇಳ್ತಾ ತಹಸೀಲ್ದಾರ್ ರಿಮೈಂಡ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಕೇಸ್ ಮೇಲೆ ದಿನಾಂಕ 13/6/2019 ಸಲ್ಲಿಸಿರುವ ವರದಿ
See, ಆದೇಶ 33ನೇ ಪೇಜ್ ಅಲ್ವಾ?
ಪ್ಲೀಸ್ ಮೇಲೆ
ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳನ್ನು
ಅದಾದ ತಕ್ಷಣ ಮತ್ತೆ ಮುಂದೆ ಮೇಲೆ ಮುಂದುವರೆದು ಭೂ ದಾಖಲೆಗಳ 2ನೇ ಪ್ಯಾರಾ. ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ದಿನಾಂಕ 13/6/2019 ಸಲ್ಲಿಸಿರುವ ವರದಿಯಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 11/37 ಖರಾಬು ಜಮೀನು 2ನೇ ರೀಕ್ಲಾಸಿಫಿಕೇಶನ್ ಪತ್ರದ ಪ್ರತಿ ಪುಸ್ತಕದಂತೆ ಹಳ್ಳದ ಬಗ್ಗೆ ಇರುವುದಾಗಿ ತಿಳಿಸಿರುವುದರಿಂದ ಹಾಗೂ ದಿನಾಂಕ 16/8/1999 ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ಆದೇಶದಂತೆ 22 ಗುಂಟೆ ಖರಾಬು ವಿಸ್ತೀರ್ಣವು ಪಹಣಿ ಮತ್ತು ಆಕಾರ ಬಂದ್ನಲ್ಲಿ ಕಾಲೋಚಿತಗೊಂಡಿಲ್ಲದೆ ಇರುವುದರಿಂದ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ಸಾಗುವಳಿಗೆ ತಂದು ಆಕಾರ ಬಂದು ದುರಸ್ತಿಪಡಿಸಲು ದಿನಾಂಕ 16/8/1999 ಹೊರಡಿಸಿರುವ ಆದೇಶವು ಸಮಂಜಸವಾಗಿದೆಯೇ ಎಂಬುದನ್ನು ಮತ್ತೊಮ್ಮೆ ಪರಿಶೀಲಿಸಿ ಖಚಿತಪಡಿಸಿಕೊಂಡು ಸಮಂಜಸವಾಗಿದೆ ಎಂದು ಕಂಡು ಬಂದಲ್ಲಿ 22 ಗುಂಟೆ ಖರಾಬು ಜಮೀನು ಕಂದಾಯ ಮತ್ತು ಮೋಜಣಿ ಇಲಾಖೆಗಳ ಎ ಖರಾಬ್ ಕಾಲೋಚಿತಗೊಳಿಸಲು ಅಥವಾ ಸಮಂಜಸವಾಗಿಲ್ಲವೆಂದು ಕಂಡು ಬಂದಲ್ಲಿ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ದಿನಾಂಕ 16/8/1999 ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸಲು ಈ ಕಚೇರಿಗೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುವಂತೆ ತಹಸೀಲ್ದಾರ್ ರಾಮನಗರ ತಾಲೂಕುರವರಿಗೆ ನಿರ್ದೇಶಿಸಿದೆ. 22 ಗುಂಟೆ ಎ ಖರಾಬ್ ವಿಸ್ತೀರ್ಣ ಸಾಗುವಳಿ ವಿಸ್ತೀರ್ಣವಾಗಿ
ಕಾಲೋಚಿತಗೊಂಡ ಅಂದ್ರೆ ಏನರ್ಥ? ಕಾಲೋಚಿತಗೊಂಡ ಅಂದ್ರೆ ಏನರ್ಥ? ನಂಗಂತೂ ಗೊತ್ತಿಲ್ಲಪ್ಪ.
ಕಾಲೋಚಿತಗೊಳಿಸಲು ಕಾಲೋಚಿತ ಅಂದ್ರೆ ಅದನ್ನ ರೀಕ್ಲಾಸಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಅದ್ರಲ್ಲಿ
ಕನ್ನಡ ಡಿಕ್ಷನರಿ ತಗೊಳ್ಳಿ.
ಅದೇ
ಕಾಲೋಚಿತಗೊಂಡ ತೆಗೀರಿ. ಏನ್ ಕಾಲೋಚಿತಗೊಂಡ? ನಂಗಂತೂ ಅರ್ಥ ಆಗಿಲ್ಲ.
ಕಾಲೋಚಿತಗೊಳಿಸಲು
ಕನ್ನಡ ಡಿಕ್ಷನರಿ ತೆಗೀರಿ. ಕಾಲೋಚಿತಗೊಂಡ ತೆಗೀರಿ. ಅದು ಏನಿದೆ ಅದು?
ಮೈಲೋಡ್
ಏನ್ರಿ ಕಾಲೋಚಿತಗೊಂಡ ಅಂದ್ರೆ?
ಸರ್ ಮೈಲೋಡ್ ಇದರಲ್ಲಿ ಏನಂತ ಅಂದ್ರೆ ಮೈಲೋಡ್ ಖರಾಬ್ ಜಮೀನ್ ಇದೆಯಲ್ಲ ಮೈಲೋಡ್, ಅದು ರೆಸ್ಪಾಂಡೆಂಟ್ 5 ಅವ್ರ ಜಮೀನ ಪಕ್ಕದಲ್ಲಿದೆ. ಪಕ್ಕದಲ್ಲಿರುವಂತಹ ಜಮೀನು ಇವರು R5 ಮೀನ್ಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್ 5 ಸ್ವಾಧೀನದಲ್ಲಿ ಇಟ್ಕೊಂಡು ಅದರಲ್ಲಿ ಕೃಷಿ ಎಲ್ಲ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
See, the question is the entire dispute resolves around the 22 guntas now.
Yes,
Yes, ma'am.
yes.
22 ಗುಂಟಾಸ್ ಅಲ್ಲಿ
Already which is
ಮತ್ತೆ
classified for
ADLR ಗೆ
agriculture
ಇದ್ ಮಾಡಿದಾರೆ. ಮೈಲಾರ್ಡ್ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾ ಇದಾರೆ ಅಂದ್ರೆ ತಹಶೀಲ್ದಾರ್ ಅವ್ರಿಗೆ ಮತ್ತೆ ಸರ್ವೆ ಮಾಡಿಸಿ ನೀವು ಅದರಲ್ಲಿ ಒಂದನ್ನ ಮಿಸ್ ಮಾಡಿದಿರಾ, ಇಲ್ಲಿ ಹಳ್ಳ ಬಂದಿದೆ ಅನ್ನೋದನ್ನ ನೀವು 1998 ನೀವು ಇದ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅದನ್ನ ನೀವು ಕನ್ಸಿಡರ್
See, that was classified as A Karab throughout.
ಸರ್.
He is claiming a right on that 22 guntas as A Karab.
ಎ ಖರಾಬ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ ಅರ್ಲಿಯರ್ ಮಲಾಡ್ ಇಲ್ಲಿ
which is already classified for agriculture purpose.
declassification
As per the order of testing commissioner,
ಹಳ್ಳದ ಬಗ್ಗೆ
unless
ಇರುವುದಾಗಿ
the A order may kindly be seen, my lord. Thereafter, my lord, the Tahsildar has regularized the 20 guntas of land, including the 39 guntas.
ಯಾರಾದ್ರೂ ಗೊತ್ತೇನ್ರಿ? ಯಾರಾದ್ರೂ ಬೇಕಾದ್ರೂ ಹೇಳಿ. If somebody can help the court. ಕಾಲೋಚಿತಗೊಂಡ ಅಂದ್ರೆ ಏನ್ ಅರ್ಥ? ನನಗಂತೂ ಗೊತ್ತಿಲ್ಲ.
Which is classified for agriculture purpose.
ಕಾಲೋಚಿತಗೊಂಡ
ಮೈಲಾರ್ಡ್ ಇದು
ಅಲ್ಲ, ಕನ್ನಡ ಟು ಕನ್ನಡ ಇರ್ಬೇಕಲ್ರಿ. ಕನ್ನಡ ಇಂಗ್ಲಿಷ್ ಡಿಕ್ಷನರಿ ಇದೆಯಲ್ರಿ? ಅದು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಇದು ತೆಗೀರಿ.
After verification, the assistant commissioner and the order came to be passed. Again,
ಅಲ್ಲಿ ನೋಡಿ ಇದು ಮುಂದುವರೆದು ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ದಿನಾಂಕ 13/6/19 ಸಲ್ಲಿಸಿರುವ ವರದಿಯಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 11/37 ಖರಾಬು ಜಮೀನು ಎರಡನೇ ರೀಕ್ಲಾಸಿಫಿಕೇಶನ್ ಪತ್ರದ ಪ್ರತಿ ಪುಸ್ತಕದಂತೆ ಹಳ್ಳದ ಬಗ್ಗೆ ಇರುವುದಾಗಿ ತಿಳಿಸಿರುವುದರಿಂದ ಹಾಗೂ ದಿನಾಂಕ 16/8/99 ಉಪ ವಿಭಾಗಾಧಿಕಾರಿಗಳ ಆದೇಶದಂತೆ 22 ಗುಂಟೆ ಖರಾಬು ವಿಸ್ತೀರ್ಣವು ಪಹಣಿ ಮತ್ತು ಆಕಾರ ಬಂದ್ನಲ್ಲಿ ಕಾಲೋಚಿತಗೊಂಡಿಲ್ಲದೆ ಇರುವುದರಿಂದ. See, that is the main reason he is giving.
Yes, it is
mention
not, it is not in the entered in the RTC, but as a mutation is affected. Can annexer B may kindly.
Not able to make out what he means by it actually.
ಅಲ್ಲ ಪಾಣಿಲ್ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ, ಬಟ್ ಅದು MR ಆಗಿದೆ. As per the order of the assistant commissioner, the land has been
See, guess
mutated.
ಮಾಡೋದಕ್ಕೂ what he means ಅನ್ನೋದಕ್ಕೂ ಅರ್ಥ ಬೇರೆ ಬರುತ್ತಾ.
ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ. ಪಿರಿಯಾಡಿಕಲ್ ಅದು ಬೇರೆ, ಕಾಲೋಚಿತ ಪಿರಿಯಾಡಿಕಲ್ ಅಂತ ಬರ್ತದೆ ಇಲ್ಲಿ ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ.
ಇಲ್ಲ. The periodical, it is not entered in the name of the RTC. After passing the order by the assistant.
Dictionary ನಲ್ಲಿ I am not finding that word.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಸ್ಪರ್ಧಿ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಅಪ್ರಾಪ್ರಿಯೇಟ್ ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ತಾಳೆ ಬರುತ್ತಾ ಇಲ್ವಾ ಅಂತ ನೋಡಿ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಏನಾದ್ರು ಹೇಳಿ.
Even read the full order, probably it may make sense.
Yes, once again I'll read man.
ಅರ್ಜಿದಾರರು ರಾಮನಗರ ತಾಲೂಕು ಪ್ರತಿಯೊಳ್ಳು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 11/37 1 ಎಕರೆ 22 ಗುಂಟೆ ಜಮೀನಿನ ಖಾತೆದಾರರಾಗಿದ್ದು ಶಾಂತಿ ಸದರಿ ಜಮೀನು ಮೂಲತಃ ಚೆನ್ನೈ ಎಂಬುವರಿಗೆ ಸೇರಿದ್ದು ಸದರಿಯವರಿಗೆ ವಿವಾದ ನಂತರ ಕಾರ್ಡ್ ಹನುಮಂತೇಗೌಡ. ಅದಕ್ಕೆ ಕೇಳಿದ್ ನಿಮ್ಗೆ ಸರ್ವೆ ನಂಬರ್ 11/37 ಟೋಟಲ್ ವಿಸ್ತೀರ್ಣ ಎಷ್ಟು ಅಂತ ಫಸ್ಟ್.
1 ಎಕರೆ 22 ಗುಂಟೆ ಪ್ಲಸ್ 22 ಗುಂಟೆ ಖರಾಬ್
ಪ್ಲಸ್
22 ಗುಂಟಾಸ್ ಖರಾಬ್.
ಹೇಳಲಿಲ್ಲ.
Total 2 acres 24 guntas.
1 ಎಕರ್ ಅದರಲ್ಲಿ 17 ಗುಂಟಾಸ್ ಆಲ್ರೆಡಿ ಖರಾಬ್ ಇದೆ, ಇನ್ನೂ ಒಂದು ಖರಾಬ್ ಇದೆ. ಅಗೇನ್
ಫುಲ್ ವಿಸ್ತೀರ್ಣ ಹೇಳ್ರಿ.
Total
A ಖರಾಬ್ ಇರ್ಬೋದು, B ಖರಾಬ್ ಇರ್ಬೋದು.
ಸಾರಿ ಮೇಡಮ್, ಟೋಟಲಿ ಮೇಡಮ್ 1 ಎಕರ್ 22 ಗುಂಟಾಸ್ ಪ್ಲಸ್ 22 ಗುಂಟಾಸ್ ಖರಾಬ್.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ ಮೇಡಮ್.
Comes to 102 guntas then.
Yes ma'am.
Huh?
Yes ma'am.
That's why I'm trying to understand the exact ಏನ್ ಬಳಸಿ. 102 ಅಂತ ಹೇಳಿದ್ರೆ 2 ಎಕರೆ
4 ಗುಂಟೆ ಬರುತ್ತೆ.
ಇಲ್ಲ 90 ಗುಂಟೆ ಅಂದ್ರೆ 2 ಎಕರೆ
22 ಪ್ಲಸ್ 40
2 ಎಕರೆ 22 ಗುಂಟೆ ಬರುತ್ತಾ?
2 ಎಕರೆ 24 ಗುಂಟೆ ಇರೋ ಸ್ವಾಮಿ, ದಯವಿಟ್ಟು ಅನಿಗ್ಸಿ ಪಾಣಿ ನೋಡಿ ಸ್ವಾಮಿ ಹಾಕಿದೀನಿ.
First let us get it right, how much it is.
ತಗೊಳ್ತೀನಿ. ಅದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂಡು ನಾನು ಇದನ್ನೇ ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
Get the details of that survey number, then we'll review the order.
Yes ma'am.
Not matching, that's the reason.
I placed the RTC before the lot, so annexure C kindly me.
That annexure C is not proper, it's improper.
2 ಎಕರೆ 24.
ಇದರಲ್ಲಿ ನಾನು ರೆಕಾರ್ಡ್ಸ್
That annexure C is improper. It's improper.
2 acre, totally 2 acre.
Sir, it is improper, sir. ಹೊಡೆದಾಕಿದ್ದಾರೆ ಅದ್ರಲ್ಲಿ.
It is wrong, totally it's wrong. That's why my lord, the deputy commissioner has directed the
The request of AG ಬೇಕಾದ್ರೆ ಡೇಟ್ ತಗೊಳ್ಳಿ, ಒಂದು 18.
18.
Get the records. AG is directed to procure the records.
P6 NS but
Hearing for petitioner. In this case, your lordship, the last occasion directed to secure the government record.
ಏನ್ರಿ ಗವರ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಂತ? ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದ್ಯಾ? Request of AG clarification.
ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಪ್ಲೀಸ್. ಎಂಟ್ರಿ ಮಾಡಿ ತಗೊಂಡಿದ್ಮೇಲೆ ಡೇಟ್ ಫಿಕ್ಸ್ ಪ್ಲೀಸ್.
ಆಯ್ತು, ಒಂದು ಡೇಟ್ ಕೊಡ್ರಿ, ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ರಿಓಪನ್.
ಇಮಿಡಿಯೇಟ್ಲಿ ಅಪ್ರೋಚ್.
8/1/25. 57 B Vachan PM Narayana Swami.
Correspondence 6 to 10, my lords. Correspondence 6 to 10.
ರೆಡಿನಾ? ರೆಡಿ.
My lords, if a short accommodation may be granted.
We are ready, madam. The request to respond is to 2 to 10. No, 6 to 10.
6 to 10, my lord.
10.
Date ಬೇಕಾ?
ಹಾ ಸರ್.
Call on, date ಕೊಡಿ after vacation.
ಇಲ್ಲ ಬಿಫೋರ್
9/1.
ವೆಕೇಶನ್.
ಆಗಲ್ಲ ವಚನ್. ತೀರಾ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಹೇಳಿ ತಗೊಂತೀನಿ.
ಅಲ್ಲ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ.
Matters have been started up.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ ಸುಮ್ಮನೆ ಅರ್ಜೆಂಟ್ ಆಗುತ್ತೆ.
Right, interim order if any is extended till next date of hearing.
9/1/25.
Please, ma'am.
59, Sivraju, MK.
This is husband and wife settlement.
Settle ಆಗಲ್ವಾ?
ಎಲ್ಲ ಆಗುತ್ತೆ ಅನ್ನೋದು ನೋಡೋಣ ಸ್ವಾಮಿ ಅವ್ರು
ಇಲ್ಲ, ಇದು
10 ಗುಂಟಾಸ್ they are claiming.
ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫ್ ಗೆ ಕೋರ್ಟ್ ಮುಂದೆ ಸೆಟ್ಲ್ ಆಗೋಗಿದೆ.
ಈಗ ಮರಿ ಮಗ ಅಲ್ಲ ಮೊಮ್ಮಗ.
ಇಲ್ಲ
Compromise
ಮಗ ಅಲ್ಲ,
ಆಗಿದೆ ಅಂತ ಹೇಳಿ.
ಸ್ಟೆಪ್ ಎರಡನೇ ಹೆಂಡತಿ ಮಗ. ಎರಡನೇ ಹೆಂಡತಿ ಮಗ.
ಆಗಿದೆ, but because they have not transfer every record, they have subsequently they have filed execution petition.
Just go on with the matters. Go on with the matter. ಹೇಳಿ arguments ಹೇಳಿ.
10 ಗುಂಟಾಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
The sixth respondent filed a petition before the
10 ಗುಂಟಾಸ್ ಕೊಡ್ತೀರಾ?
10 ಗುಂಟಾಸ್ ಅಂತ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡು ಮತ್ತೆ again 50,000 rupees are received amount from the panchayat dars. That's what my case, my lord.
ಅಲ್ಲ ಏನಾದ್ರೂ ಮೆಟೀರಿಯಲ್ ಇದೆ ತಮ್ಮ ಮುಂದೆ.
ಮೆಟೀರಿಯಲ್ ಪಂಚಾಯತ್
500 ರೂಪಾಯಿ
ತಗೊಂಡಿದ್ದಾರೆ ಅವರು.
300 ರೂಪಾಯಿ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ತಾ ಇಲ್ಲ, 50,000 ಕೊಡ್ತಾರೆ.
ನಿಜ ಏನಾಗಿದೆ ಅಂತ ನಿಮಗೆ ಗೊತ್ತು, ಅವ್ರಿಗೆ ಗೊತ್ತು.
ಹೌದು.
She is a old lady. Don't harass her. Don't harass her.
300 ರೂಪಾಯಿ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ತಾ ಇಲ್ಲ ತಿಂಗಳು.
See,
ಸುಮ್ನೆ 50,000 ಕೊಟ್ರೆ.
now husband has filed this petition through you. What you will do? Tell me.
Please, madam.
What you will do?
ಏನಿದೆ ಒಂದ್ ಸೆಟಲ್ಮೆಂಟ್ ಇದ್ ಮಾಡಿದ್ರೆ ಏನಾದ್ರು ಆಗುತ್ತೇನೋ ಅಂತ ಅಷ್ಟೇ.
ತಮ್ಮ ಮುಂದೆನೆ ನಾನು ಪ್ರೆಸೆಂಟ್ ಮಾಡಿಸ್ತೀನಿ ಅಂತ.
ಕರ್ಕೊಂಡು ಬನ್ನಿ ಪಾರ್ಟಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ
ಯಾವಾಗ ಇಡ್ತೀರಾ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎನಿ ಡೇಟ್.
ಎದುರಿಸ್ಬಿಟ್ಟು ಕರ್ಕೊಂಡು ಬನ್ನಿ. Shall I call it on 12th ಬರ್ತಾರಾ?
12th ಬೇಡ ಸರ್, 16th or 17th.
16th ಬರ್ಲಿ, 2:30 ಕರಿತೀನಿ ಬರ್ಲಿ.
ಬರ್ಲಿ.
ಆಯ್ತು ಸರ್.
ಏನೋ
ಪ್ಲೀಸ್
ಆಟ ಆಡಿದ್ರೆ ನೆಟ್ಗಿರಲ್ಲ ಅಂತ ಹೇಳಿ ಅವ್ರಿಗೆ.
ಆಯ್ತು
ಹಾ,
ಆಯ್ತು ಕರ್ಸನ್.
see, these are matters to be settled. There should be an element of live and let live amongst family members.
ಹಸ್ಬೆಂಡ್ ಮಗ ಇಬ್ರು ಕರ್ಸಿ ಸರ್, ನಮ್ಮವ್ರನ್ನು ಕರೆಸ್ತೀನಿ. ಸಾಹೇಬ್ರೆ
Get both husband and son. Get both husband and son, okay? Yes. The request of parties call on 16th. 2:30.
2:30. 60. Gowda Reddy. Gagan, yes.
Happy for respondent.
Petition this.
Ready?
Yes.
My lord, the petition is the
ನಾನು ಇನ್ಸ್ಟೆನ್ಸ್ ತಗೋಬೇಕು ಶಾರ್ಟ್ ಡೇಟ್. ಇದ್ರಲ್ಲಿ ನಾನು ಕಳ್ಸಿದೀನಿ ತಹಸೀಲ್ದಾರ್ಗೆ. Whether
earlier writ petition
Mandam
filed
is-
by the respondent number 4, wherein the Tahsil.
Government is not ready, sir. That's
Please.
the whole problem.
ಮ್ಯಾಂಡಮಸ್ ಇದೆ ಹಾಗಾಗಿ.
Direction has to be issued to the government. That's the reason.
Led, already, my lord, in the earlier writ petition, this honorable court has issued a direction. Led, this respondent for, my lord,
Now,
filed
AGA is asking for time. What shall I do? The request of AGA,
ಖಾತಾ ಮಲಡ್
ಯಾವಾಗ ಬೇಕಪ್ಪ?
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಎನಿ ಡೇಟ್ ಮಲಡ್ ಐ ಆಲ್ರೆಡಿ ಸೆಂಟ್ ಎ ರೆಕಾರ್ಡ್.
ಯಾವಾಗ ಬೇಕು?
16 ಅಥವಾ 17 ಯಾವಾಗಾದ್ರು.
16.
ಅಲ್ಲ 13ಕ್ಕೆ
13 ಆಯ್ತು.
13 ಬೇಡ.
13 ಬೇಡ ಅಂತ,
ಬೇಡ.
16. 16th.
Please, man.
61, Umesh Mulimani.
ಒಂದು 500 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಕಟ್ಸನ್ ಮಾಡಿ ನಡೆಸಲ್ಲ ಕೇಸು.
Sorry, my lord. Senior is not feeling well, my lord.
Every time when the matter comes up,
He's throat interruption, my lord.
your senior is not.
Well,
for the third respondent.
He's the last chance, my lord.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡೋ ವೆಕೆಟ್ ಮಾಡ್ಬಿಡಿ ಸುಮ್ಮನೆ ಟೈಮ್ ತಗೊಂಡು
Infection ಇದೆ ಹಂಗಾಗಿ. For inconvenience.
ಫೋರ್ ಟೈಮ್ ಮುಂದೆ ಬಂದಿದೆ.
ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. The request of petitioner finally call on 18th with no adjournment.
62 Kishan GS. 2 Shankar SK.
Respondent number 5.
Order sheet ಕೊಡಿ. Pass over, ಮಧ್ಯಾಹ್ನ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ I'll dismiss it for non-prosecution.
Much please.
Pass over. Yes, government.
63. Government. Anjaneya.
ಇದು 53 ಇಂದ for one or the other reason court ಅಲ್ಲೇ ಇದೆ
The learned AGA submits that additional advocate general is instructed to appear in the matter. At her request, finally call on immediately after vacations. They won't do it before me.
ಡೇಟ್.
Date ಕೊಡಿ.
9/1/25.
Yes.
64 Shivraj N. Arari.
The respondent has filed the present.
Pass over, sir. ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ.
Please.
ಬಂದಿಲ್ಲ petitioner.
65 Saravana.
Not a weak accommodation, not in this case.
Who has moved the court on?
Not see.
Right.
The other side is more.
It's 30-35 years grant.
Huh?
30-35 years in litigations. Though a genuine grant, one of the Jilla Panchayat member and his wife is a senior officer in the state government. They got cancelled my grant. They got it. That's the issue.
136.
And important issue is all the records, if my learned friend secures it, so that how they have played fraud one by one, I can demonstrate.
Alternative remedy ಇದೆಯಾ?
My lord,
136(2) ನೋ 136(3)
136(2)
One
act.
thirty-
ಅಲ್ಲೇ 136(3) after hearing both the parties, the deputy commissioner has remanded back to the assistant commissioner to re-enquiry under section 108K. Hence, my lord, this matter may be go before the assistant commissioner and say produce all the relevant documents and.
On that order itself, I was challenging. We have not the judgment of this honorable court where it says in an exercise of power under section 136(2), the deputy commissioner cannot exercise the other powers, not go into the question of cancelling the grant. That is the issue, Minos. It's covered by the judgment.
He has not cancelled your grant.
Not-
He has directed the assistant commissioner
Not-
to do it.
Yes, that is the issue, Minos.
Hmm.
That he can't go, Minos. That is the judgments, Minos.
no, no, as it is, their lordship, Dadan Shailen Kumar, in his judgment and also notification by the government, where case officer cannot hold the post of the special deputy commissioner. Now, before such deputy commissioner, they got this order. My humble and respectful submission is,
He has not cancelled their grant.
he has not cancelled.
Simply as.
He has remanded. Now for the inquiry also, day to day, I am prepared to, because
Purpose, he has
even
done.
my husband passed away. I am now with 2 daughters. I belongs to scheduled caste. And my plight is God only should alone, he should hear. That's the plight from 1970. I have also filed synopsis, my lord.
Thereafter, my lord, annexure J, notice has been issued.
The lordship, Justice Sunil Dutt Yadav has elaborate order observed and he has remanded the matter, the lordship. Then that remand order is now under question. It cannot be. So writ petition itself is not maintainable.
Annexure G is the deputy commissioner's order, my lord. Annexure J is notice under section 104, 108K for enquiry. That's stand before this another. Page 55 here. ಮೂರನೇ ಎದುರುದಾರರಿಗೆ ಶೇಷಗಿರಿಹಳ್ಳಿ ಸರ್ವೆ ನಂಬರ್ ಗ್ರಾಮದ ಸೋನ್ಸೋ ರಲ್ಲಿ ಸೋನ್ಸೋ ಜಮೀನನ್ನು ಮಂಜೂರು ಮಾಡಿರುವ ಮಂಜೂರಾತಿಯನ್ನು ಪುನರ್ ಪರಿಶೀಲಿಸಿ ಮೂರನೇ ಪ್ರತಿವಾದಿಗಳು ಸರ್ಕಾರಕ್ಕೆ ಸುಳ್ಳು ಮಾಹಿತಿಯನ್ನು ನೀಡಿ ಮಂಜೂರಾತಿಯನ್ನು ಪಡೆದುಕೊಂಡು ದೃಢಪಟ್ಟಲ್ಲಿ ಕರ್ನಾಟಕ ಭೂ ಮಂಜೂರಾತಿ ನಿಯಮ 1969 ನಿಯಮ 25 ಹಾಗೂ ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಅಧಿನಿಯಮ so-and-so, Noor.
Where is the deputy commissioner's order?
It's at page number 49, annexure G, my lord.
49.
Its lordship is considering notes my request for passover minutes.
It is purely under section 136(3) between the two parties, third parties. Thereafter, my lord, it has remanded back to the assistant commissioner to regitate the matter. Under section 1, under rule 108K. ಐವತ್ನಾಲ್ಕನೇ page 54 ಅಲ್ಲಿ. Order has been passed in the year 2020, my lord.
1 second, Appa. See, come to 136(3).
Please. The deputy commissioner may, on his own motion or on
Corona,
application.
come to 136(3). Go there. The deputy commissioner may, on his own motion or on application of a party, call for and examine any records made under section 127 and 129 and pass such orders as he may deem fit. So, scope of DC inquiry under revision is limited to 127 and 129. Okay, now come to 129 clause 4. First heading OD. 129 pertains to registration of mutations and register of disputed cases. Okay. So what does it say? One is mutations, another one is register of disputed
36.
cases. Huh?
Yes.
4. The objections entered in the register of disputed cases and such other objections as may be made during the inquiry shall be inquired into and disposed of by such officer and in such manner as may be prescribed. Orders disposing of such objections shall be recorded in the register of mutations or by such officers. Here, such officers refer to those officers who are competent to inquire into any aspect as contemplated under the act and the rules made therein.
Please.
Now you come to the rules.
108.
Your rules
108 case.
of land grant rules.
Cancellation of grant.
ಎಲ್ಲಿದೆ?
108 came. 108 K rule. Any grant of land made under this chapter shall be liable to be.
Rule, my lord.
ತೆಗಿತಾ ಇದ್ದೀನಿ, one second.
Please, sir.
Any grant of land made under this chapter shall be liable to be cancelled and the land resumed by the assistant commissioner where the grant has been obtained by making false or fraudulent
Yes,
representation or contrary to these rules.
yes,
Now, the question to be interpreted is whether this particular order under 108K is part of 129 clause 4.
yes, my lord. There is an objection here.
If it is yes, writ petition will be dismissed.
Yes, my lord. There is an objection by the some.
If it is no, then writ petition will have to be allowed.
Yes,
Correct?
Correct, my lord.
correct, my lord. There is an
Okay.
objection.
Now show
Please, my lords.
from a bare reading of the section, according to me, the answer is yes. So onus is on you. Show how it is excluded from 127, 128 and 129. Though there is no reference to 128, 129 takes into consideration the acts to be done under 128.
9.
129 takes into consideration the acts to be done under 128 also.
Yes.
Correct, my lord.
Because read 129, you will realize it.
Please.
The prescribed officer shall enter in the register of mutations every report made to him under subsection 1 of 128 or received by him under subsection 2 or subsection 3 of the said section.
128. Yes, ma'am. Is there.
Okay.
Yes,
Now, reading of 129 clause 4,
is,
in my opinion,
yes,
this order can be issued. Show it. Really?
Possible.
230.
Please, my lords.
Possible. No adjournment.
Please, my lords. ಅಲ್ಲ ಸೀನಿಯರ್ ಬರ್ತಾರೆ ಸೀನಿಯರ್
ಆಯ್ತು, ಬರ್ಲಿ.
MB Chandrachuda.
And application for early hearing, maybe allowed but not the date of hearing.
Hmm?
They have filed the application for early hearing.
If both of you ready, go on with the matter.
Posted for hearing. my lord,
What has
any date.
happened is, in the, Lord, what the order here Lord, is pursuant to, my lord, order under the PTCL Act where the property is resumed to me. Now the 2017 order, now they have challenged in WP number 12691, my lord, of 2020. After this matter was admitted.
Hmm.
Now, obviously, that matter has to be decided first. Because ultimately, if my grant,
The request of parties call after vacations. After vacation, Ray.
ಆಗ್ಲಿ ಸ್ವಾಮಿ.
ಶ್ರೀಮತಿ ಏನೋ
ಅಲ್ಲ, ಒಂದ್ ಯಾವ್ದೋ ಡೇಟ್ ಕೊಟ್ಟು.
ರೇ ಡಿಸೈಡ್ ಆಗಿ ಬರ್ಲಿ. ನೀವೇ
Moving that matter, my lord. We have filed our objection.
ಆಯ್ತು, ಅದ್ ಏನ್ ಮಾಡ್ತೀರಾ ಮಾಡ್ಕೊಳ್ಳಿ, ಆಮೇಲೆ ಬರ್ಲಿ ಇದು. ಅಡ್ಜರ್ಮೆಂಟ್ಸ್ ಕರ್ದ್ಬಿಡಿ ಆಯ್ತು.
Any adjournments? Adjournments?
Bill number 43. Kindly it may be taken up after vacation, my lords.
ಅಲ್ಲಪ್ಪ ತಾರನಾಥ್ ಪೂಜಾರಿ
ಇದು
ಇದ್ರು.
ಅವರೇ ಇದ್ರು, ಅವ್ರಿಗೂ ಹೇಳಿದೀನಿ, ಅವ್ರಿಗೂ ಬೇಕು ಅಂತ ರೆಕಾರ್ಡ್ಸ್ ನೋಡ್ಬಿಟ್ಟು.
After vacation, both of you agree, it's all right.
Entry order may be extended.
43, at the request of parties call after vacation, interim order if any is extended till next date of hearing.
Any adjournments?
Serial number 68, my lords.
68.
Interim order may be changed.
Mahesh, yes and Mahesh,
Inform ಮಾಡ್ತೀನಿ ನಾನು.
the request of, one second, 68. 68, I'm adjourning, nobody has objections, right? Yes, 68 after vacation, interim order ಇದ್ರೆ extend ಮಾಡಿ, at the request of petitioner ಅಂತ ಹಾಕೊಳ್ಳಿ. 67 ಏನೋ ಹೇಳ್ತಿದ್ರಿ.
67, you are challenging 1981 order for a mandamus, my lord.
ಹಾ.
We need instructions that
67 at the request of AGA call after vacations, yes.
Before vacation, my lord, seniors.
It's all right appa, immediately after vacation, one date ಕೊಟ್ರಿ vacation ಆದ್ಮೇಲೆ. Call on. 81.
Due date in that instruction ಅಂತ.
ಆಯ್ತು, 81, yes.
Any adjournments?
ಆಯ್ತು ನೋಡ್ರಿ.
Serial number 75.
ಹಾ,
Appearing for respond number 4.
I'm for the petitioner, my lord, in this case.
ಕೊಡ್ಬೋದಾ?
ಕೊಡ್ಬೋದು.
75 after vacations,
Much obliged.
at the request of R4.
Yeah.
Court officer. Sir. Sir, 74, serial number 74 ನೋಡಿ sir.
68, my lord. It was urgent after vacation. We have for the respond number 5 to 12. It may be posted for tomorrow. 68,
ಯಾರು ತಗೊಂಡ್ರಪ್ಪ ಇದು?
68, my lord.
130, I made a mention, my lord, serial number 68.
I am for
Ah.
the respondent. At least
Who took time? ನೀವು ತಗೊಂಡ್ರಾ?
ನಾನು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೆ.
ಮತ್ತೆ ಅವ್ರಿಗೇನೋ ಬೇಕಂತ.
tomorrow, it may be tomorrow.
ಇವತ್ತು ಹೇಳಿ ಇಬ್ರು ರೆಡಿ ಇದ್ರ?
Senior, ನಾಳೆ
ನಾಳೆ ಇಲ್ಲ. ನಾಳೆ ಇಟ್ಸ್ ನಾಟ್ ಪಾಸಿಬಲ್.
date may be fixed.
ಒಂದು ಡೇಟ್ ಕೊಡ್ರಿ. ನಾಡದ್ದು ಆಚೆ ನಾಡದ್ದು ಯಾವಾದ್ರು ಕೊಡಿ. ಫ್ರೈಡೆ ಕೊಟ್ಬಿಡಿ ಬೆಸ್ಟ್.
Friday, 13,
Much of-
13, 12.
ಅದು ಹೇಳಿ ಅದು ಯಾರಿಗೆ ಅಂತ. ಪಾರ್ಟಿ ಆದ್ರಿ? we have to take it up. ಪಾಸ್ವರ್ಡ್ ಕರೆದ್ಬಿಡಿ. ಪಾಸ್ವರ್ಡ್ ಆದ್ಮೇಲೆ 8990 ತಗೋಣ. ಪಾಸ್ವರ್ಡ್ 8990, then we come to 230.
First passover, ಆಮೇಲೆ 89, 90, ಆಮೇಲೆ 230.
ಹಾ.
Passover, number 27. 27, V Anand.
Office subsections cure ಮಾಡಿದ್ರು.
ಮಾಡಿದಾರಾ? Who are you? What is your right over the property? Who are you? What is your right over the property?
Some survey number 55, extent of 4 acres was granted in favor of petitioner. Situated at
ಎಲ್ಲಿದೆ ಗ್ರಾಂಟ್ ಆರ್ಡರ್?
grant certificate annex A some. Page number 12.
As per the annexure AML, the petitioner claiming that he has granted with the GMF Gromor Food scheme. Thereafter, my lord, there is an non-alienation clause of 15 years. Before 15 years, he sold the property. Now, he is seeking revoking the said cancel by cancellation of sale deed, revoking the Sagoli cheat in favor of the original grantee. This has to be given a representation to the deputy commissioner.
ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ. Petitioner's father was granted the land.
Granted the land. He sold the property to the some other else, someone. That too, non-alienation clause was inserted in the Sagoli cheat. 15 years. Before 15 years, he has sold the property to someone, some third party. Now his son is claiming that ಆ non-alienation class ಅಲ್ಲಿ ಮಾರಿರೋದ್ರಿಂದ ಈ ಪ್ರಾಪರ್ಟಿ ನನಗೆ ವಾಪಸ್ ರಿವೋಕ್ ಮಾಡ್ಕೊಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಒಂದು ಬಂದಿದ್ದಾರೆ ಇಲ್ಲಿ ಆಸ್ ಪರ್ ದಿ annexure A ಅಂತ.
Under what provision of law you can claim that?
ಬರೋದಿಲ್ಲ. Cannot.
Under what provision of law you can claim it?
Kindly pass over.
No password, sir. Tell me. Under what provision of law you can claim it?
If you want to claim any relief, we have a remedy.
No occasion of relief ಇದನ್ನ SC/ST ಗ್ರಾಂಟ್ ಲ್ಯಾಂಡ್ ಕೊಟ್ಟೋಗ್ಲಿಲ್ಲ.
ಹಾಗೂ ಬರಲ್ಲ.
ಅರ್ಥ ಆಯ್ತೇನ?
ಹೌದು, ನಾವು ಅದನ್ನ ಬೇಕಂದ್ರೆ if you-
First of all, he is the violator.
yeah, violation of ಇದು. General. ಇವೊಂದು ಆಮೇಲೆ ಗ್ರೋಮರ್ ಫುಡ್ ಅಲ್ಲಿ ಫಾರ್ ದ 15 years ನಾವು ಕೊಟ್ಟದ್ದಷ್ಟೇ. ಅದು ಕನ್ಫರ್ಮೇಶನ್ ಆಗ್ಬೇಕು, ಕನ್ಫರ್ಮೇಶನ್ ಆಗಿಲ್ಲ.
ಇಲ್ರಿ ವಕೀಲ್ರ ಬೇರೆ ಏನೋ ಬರ್ದ್ಯಾರ ನೋಡಿ.
ಅಲ್ಲ, alienated the property of one M.K. Kumaraswamy, son of M. Krishnappa under a
ನಮ್
registered.
ಮುನಿರಾಮಯ್ಯನ್ ಗ್ರಾಂಟ್ ಆಗತ್ತೆ.
ಹೌದು. Munramaya alienated the same property to the one Kumaraswamy in the year 1988, my lord. The grant was made in the year 19.
See, his lands are different, Muniramaya's lands are different. It's not what you are told.
Yes,
Muniramayan grant agata, Muniramaya has sold the property in violation, so.
yes, ma'am.
But he can't make that prayer over here.
ಹೌದು, ಈಗ ಮಾಡಕ್ಕಾಗ. There is an
We'll dismiss your writ petition. Withdraw ಮಾಡ್ತೀರಾ dismiss ಮಾಡ್ಲಾ?
Withdraw ಮಾಡ್ತೀವಿ.
ಹಾ?
Withdraw.
Withdraw ಮಾಡ್ತೀರಾ? Memo ಕೊಡಿ. After arguing the matter for some time, the advocate for the petitioner submitted that
Some pass over ಮಾಡಿ.
pass over ಮಾಡಲ್ಲ. That the writ petition may be dismissed as withdrawn. Full stop. His submission is placed on record. Writ petition is hereby dismissed as withdrawn. Memo ಹಾಕ್ಬೇಕು.
29, Pratham N. H.N. Vasudevan.
Lord, may I speak for a date for tomorrow, Lord? He's there in 17. Morning also he was unable to come.
Lord,
Lord.
this is a case, a body proceedings were initiated without hearing me, my lord. There is a civil
Shall I
dispute.
call it on Wednesday, sir? Wednesday or Friday? What do you want?
Friday, my lord.
The request of respondent number 4, call on Friday.
13-12.
Sorry.
Serial number 40, pass over matter, serial number 40-40.
Sir, my lord, complete all the objections, my lord.
Objection comply with interest.
ಅದರಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇತ್ತು,
private parties ಗೆ 4 ಜನಕ್ಕೆ party ಮಾಡಿ ಅಂತ. I have made my lord. Office objections complied, my lord.
ಏನ್ ಮಾಡ್ರಪ್ಪ ಇದು?
My lord, kindly peruse to the annex, page 35 to 38, my lord. I am the owner of the property, my lord. Tahsildar, DDLR, surveyor, my lord, have illegally demolished my property, my lord, with JCB, my lord. The orders are passed on 24/9/2024. Demolition is made on before 4 days of the order, my lord. Complete illegal activities have taken place, my lord. Now I am residing in small shed, my lord. Shed ಹಾಕೊಂಡು tent ತರ ಕಟ್ಕೊಂಡಿದ್ದೀನಿ. ಅಲ್ಲೂ ಕೂಡ they are troubling me, my lord. I had already filed a civil suit even before filing this demolition, my lord. There was an injunction order not to dispose of ಇದು ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳಿ ಆದೇಶ ಆಯ್ತು ಸ್ವಾಮಿ. Now private respondent 12 and 13, my lord, they have big properties behind my property, my lord. ನಾನು ಅವ್ರ ಪ್ರಾಪರ್ಟಿಗೆ ಹೋಗಕ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿ ಅವ್ರ ರೆಪ್ರೆಸೆಂಟೇಷನ್ 16ನೇ ತಾರೀಕು ಕೊಟ್ರೆ ಅದೇ ದಿವಸ ಬಂದು ಆದೇಶ ಆಗಿದೆ. I have been no made parties in any of the proceedings. Civil suit to the temporary injunction order was made, my lord, even before the demolition, my lord. Injunction order is also produced, my lord, is at page number 122, my lord. Not to dispossess anta adesha ide. I have produced my sale deed, ಖಾತೆ ಇದೆ. My sale deed is at page 43, my lord.
This order ಯಾವತ್ತು ಅದು injunction order?
Injunction order is passed on 23/8, my lord. 23/8/2024, my lord. 123 ದಲ್ಲಿ the presiding officer signature is found, my lord. 23/8/2024.
See, the interim prayer you have prayed,
My lord, along
you
with
have
those,
to pray it in the suit.
my lord, another filing another application, lord, sir.
For what?
Stay the order A and A1 impugned order, my lord. A and A1 are DDLR and Tahsildars have passed 2 orders, my lord. Before passing out the order itself, they have demolished my property, my lord. I have been not made a party at all, my lord. Annexure A, page 31 is the impugned order, my lord.
ಯಾವಾಗ ಆಗಿದ್ದು ಹಳೆ ದುರಸ್ತಿ?
Order ಆಗಿದ್ದು 24/9/2024, my lord.
ಅಲ್ಲಪ್ಪ. What was the earlier order?
Earlier order, annexure A1 ಇದೆ, ಅದು 16/3/2024.
What does it set aside?
ಅಲ್ಲ set aside I have been not, ಎಲ್ಲೂ ನನಗೆ ಪಾರ್ಟಿನೇ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
That's okay. Show me what does it set aside? When was the earlier order passed?
Please.
It is set aside by annexure A.
ಅಲ್ಲ ಅವರು ಬಫರ್ ಝೋನ್ ಆಗತ್ತೆ ಅಂತ annexure F representation ಕೊಟ್ಟಿದ್ದಾರೆ.
ರೇ, ಆದೇಶಕ್ಕೆ ಬರ್ರೆ.
ಆದೇಶ is at page 31, my lord.
32.
Please, your lord, 32. ಅಲ್ಲಿ ಹೇಳೋದು ಬಂದು ಪೋಡಿ ದುರಸ್ತಿ ಕ್ರಮಗಳನ್ನು ರದ್ದುಪಡಿಸಲಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅಷ್ಟೇ.
ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 66ರಲ್ಲಿ
Please, your
1ರಿಂದ 8 ಎಂದು 3
Please, your
ಹಂತಗಳಲ್ಲಿ ಆಗಿರುವ ಪೋಡಿ ದುರಸ್ತಿ ಕ್ರಮಗಳನ್ನು ರದ್ದುಪಡಿಸಿ ಆದೇಶಿಸಿದೆ.
Please, your.
ನಾನು ಕೇಳ್ತಿರೋದು when was the earlier ಪೋಡಿ ದುರಸ್ತಿ done?
My lord, in 1986 itself, the property 1986 ಅಲ್ಲಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ಗೆ ಸೇರ್ಬಿಡುತ್ತೆ ಸ್ವಾಮಿ. ನನ್ನ ಖಾತೆ ಇದರಲ್ಲೇ ಎಂಟ್ರಿ ಇದೆ ಸ್ವಾಮಿ. I have produced page number 51, my lord. ಇದು ಗ್ರಾಮ ಪಂಚಾಯತ್ಗೆ
ಗವರ್ಮೆಂಟ್ ಯಾವಾಗಪ್ಪ earlier order ಆದದ್ದು?
1986, my lord. Page number 51, 52 ದಲ್ಲಿದೆ ಸ್ವಾಮಿ.
2017 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗುತ್ತೆ.
A1 says that 40 meters from the national highway, they want to construct. So they cannot construct within the 40-meter radius of the national highway.
ಅಲ್ಲ ಅದಕ್ಕೆ ನೋಟ್
Total stay ಇದೆಯಲ್ಲ, how can you go and down?
This order is of the dated 16/3/24. Later on, they have obtained the stay order.
ಅಲ್ಲ
And the annexure A.
I don't precipitate the matter till next date of hearing.
Annexure A is just a remand order to do the needful ಅಷ್ಟೇ. ಹೊಡೆದಾಕಿ ಏನು ಇಲ್ಲ.
ಅದನ್ನು ಹೇಳ್ತಿರೋ
16/3/24 ಅಲ್ಲೇನೆ ಆರ್ಡರ್ ಆಗೋಗಿದೆ. ಬಫರ್ ಝೋನ್ ಒಳಗೆ 40 ಮೀಟರ್ ಒಳಗೆ ಆಚೆ ಈಚೆ ಇದ್ರೆ ಎಲ್ಲ ತೆಗೆದಾಕಿ ಅನಧಿಕೃತ ಕಟ್ಟಡಗಳನ್ನ. ಆಮೇಲೆ ಅವ್ರು ತಗೊಂಡಿರೋದು 24 ಆಗಸ್ಟ್ ಅಲ್ಲಿ.
page 98 is no, 98 is the notification, my lord. Notification ali it is not 40 meters, your honor. Kindly peruse to the notification I have produced, my lord. Page number 100 is the notification, my lord. Page number 100, my lord.
Right, AJ access notice points 1 to 4, 1 to 11. Issue emergency notice to other respondents. What are other respondents?
ಅವರು ಬಂದು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಟ್ಟಿರೋದು ಸ್ವಾಮಿ ಅವರು.
ನೀವ್ಯಾಕೆ ಜಗಳ ಆಡಕುದ್ರಿ ಅವ್ರ ಹತ್ರ?
ಅವ್ರಿಗೆ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅಂತ ಅಬ್ಜೆಕ್ಷನ್ ಬಂತು, ಅದಕ್ಕೆ ಮೇಡ್ ಪಾರ್ಟಿ, ಮೈ ಲಾರ್ಡ್. I was not made party anywhere of the proceedings. ನಾನೀಗ ಲಾಸ್ಟ್ ಟೆಂಟ್ ಕಟ್ಕೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ in my property after demolition. Till date, no order on record for demolition, my lord.
Respondents 1 to 11 are directed not to precipitate the matter against the petitioner pursuant to the impugned orders at annexure
A and A1, my lord.
A and A1 to the writ petition till next date of hearing.
If it is already not been done, because A1 is after.
Not to precipitate the matter further anta ಮಾಡಿ. Not to precipitate the matter further.
ಈಗ ನನ್ಗಲ್ಲಿಂದ ಡಿಸ್ಪೋಸಸ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ನಾನು ಟೆಂಟ್ ಇದೆ ನನ್ಗೆ.
ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕು.
ಅಲ್ಲ, ಆಲ್ರೆಡಿ ಸಿವಿಲ್ ಕೋರ್ಟ್. ಪ್ಲೀಸ್ ಯುವರ್ ಆನರ್.
Pass over matter. 62, 62.
62 ಅಲ್ಲ?
62. ಕಿಸಾನ್ GS.
ಬೆಳಗಿನ ಬಂದಿಲ್ಲ ಅಲ್ಲ?
ಬೆಳಗ್ಗೆ
On the basis of the petitioner, even when the matter is called out the second time, it appears petitioner is not interested in prosecuting the writ petition. Petitioner dismissed for non-prosecution. Yes.
64, Shivraj N. Arali.
My lord, I appear for the petitioner in this case, my lords. My apologies. I'm not being there on physical, my lords, before this court. I am little
Yeah, tell me.
lacking. My lords, this petition is filed, my lords, challenging the annexure MNPQ, whereby, my lords, the learned Tahsil, the assistant commissioner, passed orders, my lords, directing to consider the earlier sale deeds and then pass suitable orders. Whereas Tahsildar, contrary to the registered sale deeds, my lords, which are produced along with this writ petition at annexure M, N, my lords, goes ahead to pass orders mutating the entire extent. My lords, the last date I gave some of the details, my lords. I would like to take your lordship's kind
Ready,
attention.
both of you? Please.
My lords,
Final arguments. Ready for final arguments, both of
please,
you?
my lords, please.
For a moment, your lordship may kindly look into the
Yes,
nature of
some-
the rares, what he has sought.
If it can be taken tomorrow, my lords, I will come and assist this honorable court physically, my lords, if it is not otherwise.
Friday, okay. Friday.
In this case, my lord, the land was sold long back.
ಅಲ್ಲ, Friday here
There is no, there.
Please,
there
your
is
lord.
increase in the revenue documents.
I will call it on Friday itself.
Please,
The request of petitioner call on Friday.
my lords, interim order is there, my lords, until then.
Further extend matter.
Then actually now there is an order not to disburse.
65,
On one
Saravana
count or the other, they are
Friday,
seeking
Friday.
adjournment. They have no right at all. Please.
M. Shivprakash. 65. M. Shivprakash. 65.
ಕೊಡಿ. What are your grounds, Ravishankar?
Lords, the private respondent
Hmm.
was a beneficiary of an earlier grant. That was in the year 1978.
Hmm.
His grant was cancelled in 1986, 14/7/1986.
Hmm.
That order has become final. There is no challenge to the cancellation of his grant.
Hmm.
Then the property was again mutated in the name of the government.
Hmm.
Lords, which your lordships will find as MR number 2 of 8990, page 36.
Hmm.
8990 itself, the land is shown as the property of the government on account of the cancellation in the year 1986.
Hmm.
Even that is not under challenge. Then, on an application filed by me for unauthorized cultivation,
Hmm.
the matter is placed before the committee. Committee passes a recommendation and then the Tahsildar issues a Sagoli chit on 2/7/1996.
Hmm.
Even this order is not in challenge. Now what happens? After lapse of 27 years, he challenges MR number 2 of 8990, where the mutation was changed in the name of the government without challenging the cancellation of the grant in his favor on 14/7/1986. Here I am not made as a party. So what the assistant commissioner does, he remands the matter back to the Tehsildar without noting the order dated 14/7/86, which is again passed by the assistant commissioner. Notice the Tehsildar makes the entry in the name of the present contesting respondent. So that is the reason why I went before the assistant commissioner. Assistant commissioner set aside the entry. Against that, the private respondent went before the deputy commissioner. Deputy commissioner confirms that the entry is to continue in my name, but further direction is issued saying that you will have to inquire as to whether or not there is a proper grant in my name. Under 136(3). 136(3) is purely with reference to validity or otherwise of the grant. If the validity or otherwise of regularization is to be challenged, there is a power vested under Rule 108K, which is exclusively another stream of power which is to be exercised. Nothing to do with the revenue proceedings, nothing to do with the RTC proceedings. Now, this is the view which is expressed, my lords, by the coordinate benches of this honorable court, which has taken a view.
No, but tell me, see, Rule 108K is fine. Okay. Now, the deputy commissioner finds everything is all right
Yes.
when he is looking into the proceedings and
There is no supervisory power of the deputy commissioner, my lords. Now, the regional commissioner, if your lords were to see the scheme of the act, I think section 36 or somewhere there is a power which is vested in an authority which is higher than the deputy commissioner who can exercise the supervisory powers. The regional commissioner is the Deputy Commissioner 136(3) is purely revisional jurisdiction, very restricted jurisdiction. He can only examine the correctness or otherwise of the entries which is made under 128 and 129. That's it.
it comes under 129(4) nodi.
129(4) ಏನಂದ್ರೆ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾಗ ಯಾರು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ರೆ ಆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಗೆ ಎನ್ಕ್ವೈರಿ ಮಾಡಬಹುದು ಅಷ್ಟೇನೆ. Kindly have a look at section 129(4). Lords, I'm sorry. Yeah. Objections entered in the register of disputed cases and such other objections as may be made during enquiry shall be inquired into sounds. ಅದರಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದ್ರೆ ಅಲ್ಲಿ ಕ್ಲಾಸ್ 3 ನೋಡಿದ್ರೆ ತಾವು
You'll have to address your argument.
129(3) ನಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ should any objection be to any entry made under
address your arguments on this.
Yes, ma'am.
ಅಲ್ಲ ಫುಲ್ ಬೆಂಚ್ ಡಿಸಿಷನ್ ಅಲ್ಲಿ ಕವರ್ ಆಗಿದೆ ಇದು ದಿಸ್ ಇಶ್ಯೂ.
136(3) only with regard to mutation entries. In the mutation entries inquiry, my lord, the deputy commissioner come to the conclusion that there is a discrepancy between the parties saying that which is the grant union or not. Therefore, my lord, the deputy commissioner has remanded back to the remanded back to the assistant commissioner saying that go through the documents, inquire about the genuinity of grant, who has genuinely get the grant. Therefore, my lord, 108K is applicable.
No, what he says is, he does not have supervisory jurisdiction.
No, my lord, 136(3)
ಇಲ್ಲಿದೆ.
kindly come. 136(3), my lord.
ಸೂಪರ್ವೈಸರಿ ಜುರಿಸ್ಡಿಕ್ಷನ್ ಬರಲ್ಲ. ರಿವಿಷನಲ್ ಜುರಿಸ್ಡಿಕ್ಷನ್ ಗೆಟ್ ಸೂಪರ್ವೈಸರಿ ಜುರಿಸ್ಡಿಕ್ಷನ್ ಬಹಳ ವ್ಯತ್ಯಾಸ ಇದೆ. ನಾನು ತೋರಿಸ್ತೀನಿ, ಆ ಪ್ರಾವಿಷನ್ ಇದೆ. ಸೂಪರ್ವೈಸರಿ ಜುರಿಸ್ಡಿಕ್ಷನ್ ಪ್ರಾವಿಷನ್ ಇದೆ.
And in own motion, suo motu proceedings can be taken by the deputy commissioner
ರೀಜನಲ್
for genuinity of grant. Whether it is genuine or not ಅಂತ ಅವರ suo motu proceedings ಅಲ್ಲಿ he can take a suo motu proceedings.
ಪ್ರೊಸೀಜರ್
ಅದು ಬಿಟ್ಟು ಇವ್ರೇನ್ ಮಾಡಿದ್ರು 136(3) ಅಲ್ಲಿ the petitioner herein has challenged the assistant commissioner's orders before the deputy commissioner for mutation entry which has been changed by the assistant commissioner. That in that order, my lord, in the said proceedings, the deputy commissioner has come to the conclusion that there is a discrepancy in the grant of both the parties, private parties.
No, that's not the
Therefore,
finding.
it has been remanded back to the assistant commissioner saying that, no, go through with the document and whether check the genuinity of the grant. Who is the genuinely get the grant ಅಂತ ಹೇಳಿ ಕಳಿಸಿದ್ದಾರೆ. Therefore, my lord, 108K under the 108K proceedings, Annexure J was issued to the petitioner hearing, saying that whatever document you have, please come before me and submit your documents. In the year 2020, the 136(3) order has been passed by the Deputy Commissioner, my lord. In the year 2023, 30th/9/2023, notice has been issued under rule 108K.
Give me your judgments, give me your judgments also.
Yes.
Yes, my lord.
Adalli now, this point which we had argued, my lords, then ultimately this honorable court, while dealing with the powers, the full bench in Lakshmama's case has taken the
Deputy
view.
Commissioner,
The power is very, very limited. They cannot go into the validity of the title. They cannot go into the validity of the grant. This is not something permissible. May I just?
Yeah.
In Jayama case, my lords, I think, ಅದ ಇವತ್ತೇನ ಅವರು ನಮ್ಗೆ ಹೇಳ್ದಲ್ಲೇ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಸ್ಕೊಳ್ದೆ ತಗೊಂಡೋಗಿದ್ರು, ಅದಕ್ಕೆ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ. I will argue all these points, absolutely no difficulty. Because this is the reason why the matter was referred to a larger bench as to what extent the revenue authorities under 136(3) can go, because subject matter of reference itself was the jurisdiction under 136(3).
List of citations.
My lord,
ಆಯ್ತು,
direct
list of
senior
citations
counsel-
ಕೊಡ್ತೀನಿ, ಕೊಟ್ಬಿಡಿ.
direct senior counsel is submitting. In 136(3) proceedings, Deputy Commissioner have not come to the conclusion that it is not a genuine anta. Therefore, my lord, 136(3) is purely on mutation register. Therefore, my lord, this Deputy Commissioner has remanded back. to
Yes,
the
he has got some
Assistant
citations
Commissioner
to the
saying that
contrary.
108K
Let him
proceedings
give
are
it.
ಮಾಡಿ ಅಂತ.
We'll call it on Friday.
Please, my lords.
Day after tomorrow.
Friday.
Friday. In the morning, my lord has clearly said 128, 129.
No, he says he has got citations to the contrary.
ಇಲ್ಲ, ನಮ್ದು ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಒಂದ್ಸಲ ಓದಿದ್ರೆ my lord, I will go through this. ನಾನು
That's
ಹೇಳ್ತೀನಿ.
okay, but
Please.
does he have the power under the case? He is telling he has got some citations.
Yes, my lord, 136 clear.
You also look into it.
ಪ್ಲೀಸ್ 136(3) ಮೇಲೆ ನಾವೇನು ಹೇಳ್ತಾ ಇಲ್ಲ. ಈ ಆರ್ಡರ್ ಚಾರ್ಜ್
ಐದು-
ಮಾಡಿದ್ದಾರೆ, ಅದ್ರ ಜೊತೆ ನೋಟಿಸ್ ಚಾರ್ಜ್
Let's-
ಮಾಡಿದ್ದಾರೆ.
If
136(3)
we go into the basics as to what is meant by revision, lords, it
That's
is,
going to basics.
yes, it is if we go into the basics, what is meant by a revision, it is dependent on the original jurisdiction scope. As and how we climb up the hierarchy, the limitation of exercise of jurisdiction gets shrunk. Revisional, which is the last resort which comes before an authority, my lords, under the scheme of the statute, will only have a jurisdiction as expressly conferred under the scheme of the statute. That's only to correct the errors.
Sure.
Beyond that, it cannot look into. Now, we will have to see what is the hierarchy through which the revision comes up, because 136(3) is not the sole repository power of revision to the Deputy Commissioner. We have the powers of revision under Section 56 also, which is a different stream of proceedings which takes place. There may be an order passed under any of the other provisions by the Assistant Commissioner, then the Assistant Commissioner. There are instances where there are second appeals provided, and there are instances where there are only revision petitions provided. This is one stream altogether, which is entirely different. This 128, 129 is completely a special procedure in this chapter, providing for a very limited power on the Deputy Commissioner. Because if we enlarge the scope, then it militates against the general powers of revision provided for under Section 56. We go on the basics. It is something like under 128, 129, whether it would be permissible for the Tehsildar to get into these questions would be the question. Because if Tehsildar himself can't exercise this, the Deputy Commissioner merely being a correcting authority cannot say, no, I will direct them to do all these things. It will not enlarge the scope. But anyway, my lords, as your lordship said, I will provide the judgments and argue this matter.
Here, my lord, we only 136(3) proceedings, 136(3), 127, 128, and 136(2)(3). This is the hierarchy. Here only with regard to mutation entry. Therefore, my lord, the Deputy Commissioner cannot go into the genuinity of grant in the 136 proceedings. Therefore, it has been remanded back to the Assistant Commissioner under
No,
Section
no,
1
what
under
he says
108K ನೀವು ಮಾಡಿ ಅಂತ.
Under Section 126 and 129,
Yes,
128 and 129.
128 and 129,
128 ಸಹ ಇದೆ. ಹೌದು.
128, 129 ಅಲ್ಲಿ the Tehsildar, the Assistant Commissioner, they cannot look into this particular aspect.
Yes,
So the question of excising revision under
136.
Correct the orders, you enlarge the jurisdiction.
does not rise on, that's his
Yes.
contention.
ಹೌದು. ಇಲ್ಲಿ ಜುನಾನಿಟಿ ಬಗ್ಗೆ ಬರ್ಲೇ ಇಲ್ಲ, ಅದು ಯಾವ್ದು 128, 129, 130
ಬರೋದು ಇಲ್ಲ.
ಜುನಾನಿಟಿ ಬಗ್ಗೆ ಇಲ್ವೇ ಇಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರನೇ ಡಿಸಿ ಜುನಾನಿಟಿ ನಾವ್ ಇಲ್ಲಿ ನೋಡಕ್ ಆಗಲ್ಲ ಅಂತೇಳಿ AC ಕಳ್ಸೋದು.
No, for that, you should have a supervisory power,
Power.
which he does not have.
I'll provide the judgment.
No company, purely
I will
legal
also look
aspect.
into that.
Purely legal aspect.
Yes.
ಆಯ್ತು.
Assistant Commissioner got exclusive
No,
jurisdiction. I
even
can
otherwise,
place.
see, otherwise, you can move the AC if required under.
That's
Under
what,
the- let's now-
that's what the Samal court has directed.
ಅದಕ್ಕೆ
Justice,
ಇದ್ರಲ್ಲಿ ನಾಟ್ ಓನ್ಲಿ
court and bench.
See, ಇದರಲ್ಲಿ ಒಂದು ಪಕ್ಷ ನಾವು ಅವರಿಗೆ ಪವರ್ ಇಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ರು, nothing prevents you from moving under 108K.
ಅದಕ್ಕೆ ಸ್ವಾಮಿ
Every-
ಅದ್ರೊಳಗೆ
every
ಏನ್ ಗೊತ್ತಾ, ನಾ ಹೇಳಿದ್ನಲ್ಲ, ಫಸ್ಟ್ ಥಿಂಗ್ಸ್ ಫಸ್ಟ್, ಮೊದಲನೇದು ಲೋಕಸ್ ನೋಡ್ಬೇಕು. ಈಗ ನಾನ್ 2 ಆರ್ಡರ್ ಹೇಳಿದೆ, ಆ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಯಾರುನು.
Other contention is that on
17/10/86,
14/7/1986, your grant was cancelled, which you are not challenged under, that he says.
Cancelled without notice. That's what all these things happened.
Correct, sir, but you are not
You are not
challenged
challenged.
it. Later on, you challenge only the MR 2 of 8990.
ಆಫ್ಟರ್ 27 years.
Okay, that gets set aside without notice to him. After lapse of more than
27
nearly
years.
yeah, whatever years. Okay, note money.
Please, Milots.
Because it has got a very checkered history. I can explain.
No, rather than on fact.
And the point also, on the point,
Legal
on the point also I can explain. man.
Yes, further hearing in the Hakola.
Further hearing it.
Right. At the request of parties for further hearing, call on Friday. Interim order ಏನಿದೆ extend ಮಾಡಿ.
Please, Milots.
8990 ತಗೊಳ್ಳಿ.
8990 ಅದು ಪಾಸ್ parted matters. 89 first. Number 89.
The urgent matter is there.
69 ದಯವಿಟ್ಟು ಒಂದೇ ಒಂದು 2 minutes ತಗೋತೀನಿ. 69 ಸೀರಿಯಲ್
Urgency ಏನ್ ಸರ್?
ಸರ್ ಸ್ಟೇ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟಕ್ಕೆ. ಏನಾಗಿದೆ, ಗ್ರಾಂಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ನಾನು ಪೊಸೆಷನ್ ಇದ್ದೀನಿ, ಎಲ್ಲ ಇದ್ದೀನಿ ನಾನು. ಇವ್ರು ಬಂದು ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ ನನ್ನ ಹತ್ರ.
ಅದಕ್ಕೆ ನೀವು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗ್ಬೇಕು ಸರ್. ನಾವು
ಅಲ್ಲಲ್ಲ, ಅಲ್ಲ, ನಾನೀಗ ತಹಸೀಲ್ದಾರು ಒಂದು NRC ಇಶ್ಯೂ ಮಾಡು, ಅದು ಅಸಿಸ್ಟೆಂಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೆ, ಆಮೇಲೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್, ಆಮೇಲೆ ಅಪಲೇಟ್ ಅಥಾರಿಟಿ. ಅದಕ್ಕೋಸ್ಕರ ನನಗೆ ನಾನು ಐ ಮೀನ್ ಪೊಸಿಷನ್.
who is disturbing your position?
ದಿ ತಹಸೀಲ್ದಾರ್. Till that date, your lordship kindly grant the stay of annexure A.
No, for that you need to approach the civil court. ನಾವು ಕೊಡ್ರಿ.
ಇಲ್ಲ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಬರಲ್ಲ ಸ್ವಾಮಿ. ಇದು KAT ಚಾಲೆಂಜ್ ಮಾಡಿ KAT ಮೇಲೆ ಬಂದಿರೋದು ನನಗೆ. ಇದು KAT ಇಂದ ಬಂದಿರೋದು ನಾನು. The lordship may kindly see the land grant committee granted the land on 27/4/1998 land grant committee, and pursuant to that I have paid that ಇದು ಏನು ಹಣ ಕಟ್ಟಬೇಕಾಗಿತ್ತು 2431, ಅದು ಕಟ್ಟಿದ್ದೀನಿ. ಅದು ಕಟ್ಟಿದ ಮೇಲೆ ಖಾತಾ ಆಗಿದೆ, ಪೊಸೆಷನ್ ಇದ್ದೀನಿ, ಐ ಆಮ್ ಕಲ್ಟಿವೇಟಿಂಗ್ ಇಟ್. Now the Tahsildar coming and disturbing. Idana the Tahsildar issued an endorsement saying that you have to vacate it. I have challenged before Assistant Commissioner, then DC, then Appellate Authority. Other male Bandira Swami. Nodi 108 ali Swami in the event. If the Tahsildar is not satisfied the order of the Land Grant Committee, under section 108 he has to challenge before the Assistant Commissioner. And to that extent there is a decision also of this honorable court. Kindly see the decision.
Did you have benefit of interim orders before the KAT, sir?
Sir,
Did you have benefit of the interim orders before KAT?
Allah, but possession lay idena continuous.
Sir, did you have the benefit of interim order before KAT? No.
Illa. But Allah, but your lordship kindly see the might.
You will finally dispose it off first.
Ade ಮಾಡಿ.
Get ready. ಯಾವಾಗ?
Allah, till that date, let them not.
16 I'll land.
At the request of AGA call on 16th.
Allah, till that date, your lordship.
No, sir. No interim order.
In the order, my lord. The
Will
authority as well as
No, sir,
KAT
no entry modes. Sir, can't grant, sir. 2011, you suffer an order.
my lord, on the
And
ground of,
after a lapse of 3 years, you approach KAT. Okay. And then onwards, till today, you never had a benefit of an interim order.
I'm in possession of the property.
ಅಲ್ಲ,
So what?
ಮತ್ತೆ ಇದು
Let the government say.
their farm number 50 has cancelled only on the ground of he is not in a position.
ಅಲ್ಲ ಪೊಸಿಷನ್ ಇದಿಲ್ಲ.
That's why I told you go before civil court. We disputed a question of facts, we can't look into. No interim orders. If you want, I'll take it up on 16th, that's all. Yes, Radhanandan.
Serial number 74, my lord.
1 second, sir. This 72 mention ಮಾಡಿದ್ದಾರೆ. ಕೊಡ್ರಿ ಏನಿದು?
I need to file statement of objections in this matter.
Really, this already that the finding of recorded with the sound of court.
ಆಯ್ತು, ಇದನ್ನು 16th ಆಗ್ತೀನಿ, ಅಷ್ಟೊಳಗಡೆ ಹಾಕಿ. Madam,
Yes, my lord.
I'll call it on 16th.
Yes, 16th ಕಾಗಲ್ಲ. ಎಲ್ಲ ಸೆಷನ್ಗೆ ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಬೆಳಗಾವಿ session. ಯಾರು ಸಿಗಲ್ಲ.
Order is not to declare that no Karaf land exists. In spite of that order, God is a party to the order. He passes another order saying that there is a Karaf land, no sanction.
That's right. Raja Kalave runs through it.
There is a finding recorded in the sound of court. That is disposed of. And the relevant appeal is present.
Yes, ma'am.
No appeal is recorded.
I'll have it after vacation, my lord.
The clearance is already gained. The annexure P is flashed, that at page 1 and 2. It is also made clear that E Karaf land Nagavara does not exist to the survey offered by and village man, reduce at annexure A. Then man was issued to correct the arbitrary instance. That also he complies. He rectifies the arbitrary instance. Now he passes the very same order of disposal of this order and will order greatly lose. Annexure 119, page number 119. Or matter was disposed of on 11th July. Then he passes the order on 26/8 after disposal of the petition, though is a party, he reiterates by disowning the order of this honorable.
He wants to file objection, sir. I can't.
Yes, ma'am.
What do you want, madam?
After vacation,
I'll-
because nobody is
My
available.
plan is stalled.
Because all the
It is a
DC.
huge extent of, I am
ಬೆಳಗಾವಿ
losing
session
crores.
ಇರೋದ್ರಿಂದ 2 weeks no.
Every month I am losing crores of rupees. Order, there is nothing that requires
Order
to
is
be
up
ಎಲ್ಲಿ ತನಕ
decided.
session?
because the order and the
ಎಲ್ಲಿ ತನಕ ಸೆಷನ್ ಇರೋದು?
2 ವಾರ ಇದೆ sir. ಇವತ್ತಿಂದ 2 ವಾರ.
What to do?
ಅಲ್ಲ ಈ ತಾವು annexure T ನೋಡಿದ್ರೆ ಇಟ್ಸ್ contemptuous. That's what I'm.
Same day, both the orders came to pass, may not be the aware of the
So,
passing
file
of
an
that
appeal,
order.
ah? You didn't prefer an appeal, ah?
ಅದೇ so,
They
I
complied
had
with
to
the order.
verify all those things. I
They
had to
complied with
verify
the
all.
order. They rectified the RTCs in pursuance of the order passed in the earlier. Then what else remains is
ಆಯ್ತು, immediately after reopening.
Vacation, 9th.
9/11/20.
ಏನ್ ಮಾಡಕ್?
place.
ಅಲ್ಲ ಒಂದು ಯಾಕಂದ್ರೆ ನನಗೆ every because the construction is on. The modified plan is to be issued by the BDA and he writes a letter in a contemptuous manner. That is a difficult.
The request of AGO finally call on 9th.
9/1/25. 89, Chandrasekhar TA.
ಜೈನ್ ಶಂಕರ್, ಶರತ್ ಅರ್ಜೆಂಟ್ ಇದೆಯಾ?
ಅರ್ಜೆಂಟ್ ಇಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇದು 70.
ಆಯ್ತು, ಅದನ್ನ ಮಾಡಿಸ್ ಡೇಟ್ ತಗೊಂಡ್ಬಿಡಿ ಆಮೇಲೆ.
ಸುಮನಾ ಬಾಳಿಗ ಮೇಡಮ್. ಅವ್ರದ್ದು
ಬ್ಯಾಚ್ ಮಾಡಿದ್ಯಾ? ಯಾವ್ದು?
ಸುಮನಾ ಮೇಡಮ್.
ಅದು ರಾಜೀವ್ ಗಾಂಧಿ ಕಾರ್ಪೊರೇಷನ್ ಗೆ genuinity of the grant we have to tell, my lord. In some of the records we have secured, in some of the records no genuinity. And in some cases FSL ಗೋಸ್ಕರ ಕಳಿಸಿದ್ದಾರೆ ಕೆಲವು ರೆಕಾರ್ಡ್ಸ್ ನೆಲ್ಲ. More or less,
All
grants are
76.
not at all genuine.
76 in the,
80,
76 is the for the respondent.
76 in the 80.
86.
Waiting for your thing, madam. See, I thought we could finish it off.
76 in 87.
Grants are not genuine.
And
Left
also,
it, okay.
We have secured all the records. In some cases, we have already filed a statement. We say that no grants have been made.
Specifically 76 case ಅಲ್ಲಿ ಗ್ರಾಂಟ್ ಕ್ವಶನ್ ಮಾಡಿಲ್ಲ ಈಗ ಗ್ರಾಂಟ್ ಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೆ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಮ್ಯಾಂಡಮಸ್ ಕೇಳ್ತಾರೆ.
Grant ಆಗಿಲ್ಲ sir.
76 ಅಲ್ಲಿ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ. 53. We have already filed.
ಸಕ್ರಮ ಮಾಡಿ ಅಂತ ಒಂದು receipt.
ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇಲ್ಲಿ ಸಕ್ರಮ
ಮೆಜಾರಿಟಿ ಕೇಸಸ್ ಅದೇ ತರ ಇದೆ.
ಸಕ್ರಮ.
In some cases,
ಸಕ್ರಮಕ್ಕೆ ಅರ್ಜಿ ಹಾಕಿದ್ದಾರೆ.
ಅದನ್ನ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾರೆ.
ನಮ್ಮ ಗ್ರಾಂಟ್ ಅನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
ರಾಜೀವ್ ಗಾಂಧಿ ಕೊಟ್ಟು.
ಆ
their
ರಾಜಸ್ಥಾನ್ ದೇವಸ್ಥಾನ
application
ಕಾರ್ಪೊರೇಷನ್ ಇಂದ
53 specifically 76 ಅಲ್ಲಿ 53 ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ.
76 ಅಲ್ಲಿ ಬೆನಿಫಿಷಿಯರ್ಸ್ ಎಲ್ಲ ಸೈಟ್ ಅಲಾಟ್ಮೆಂಟ್ ಆಗಿ ಫೈನಲೈಸ್ ಆಗಿ ಇನ್ನೊಂದು ಹಕ್ಕುಪತ್ರ ಎಲ್ಲ ಕೊಡ್ಬೇಕು. ಆ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ನಮಗೆ ಪ್ರಾಪರ್ಟಿ ಗ್ರಾಂಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಬಂದು ಕೋರ್ಟ್ ಕೊಟ್ಟು ರಿಟ್ ಹಾಕೊಂಡಿದ್ದಾರೆ. ಆ ರಿಟ್ ಅಲ್ಲಿ ಸ್ಟೇನು ಇಲ್ಲ ಏನೂ ಇಲ್ಲ, ಓನ್ಲಿ ಫಾರ್ ದಿ ಮ್ಯಾಂಡಮಸ್ ಕೇಳ್ಕೊಂಡಿದ್ದಾರೆ. ಸೊ ಅಲ್ಲಿ ನನಗೆ ಸೈಟ್ ಅನ್ನ ಕೊಡೋದಕ್ಕೆ ಕೂಡ
76 no grant,
No grant.
No grant and no
application,
No application filed.
we'll dismiss it then.
Yes.
Yes,
Petition
And
case
also,
76.
serial number 87 Raj.
Well, is the name grant?
76 sir.
Will you have done?
No adjournment, sir. Put it 76. Put it.
Will pass over my lord.
No passover also. Put it.
And see the prayer Raj, 76 sir.
Show me one document, show that you are in possession or something like that.
ಹೌದು ಇಲ್ಲ ಸರ್ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಅದ್ರ.
ಪೇಜ್ ನಂಬರ್ 34 ಇದೆ. 30 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣಕ್ಕೆ ಅಕ್ರಮ ಸಕ್ರಮ ಮಾಡಿ ಅಂತ ಹಾಕಿ. ಪೇಜ್ ನಂಬರ್ 34.
ಕ್ರಮ ಸಕ್ರಮ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. Kindly see the page number 41 Malash, 41.
What is your right, sir?
My lord, kindly pass over, my lord.
Passover, ashta.
Please.
Otherwise I'm dismissing it.
ಏನು ಇಲ್ಲ ಇದು ಸುಮ್ನೆ ಸುಮಾರು ಡೇಟ್ ಇಂದ ಇದೆ ಹೋಗ್ತಾ ಇದೆ. ಪಾಸ್ವರ್ಡ್ ಆಗುತ್ತೆ, ಅರ್ಜೆಂಟ್ ಆಗುತ್ತೆ. ನಮಗೆ ಬೆನಿಫಿಷಿಯರ್ಸ್ ಎಲ್ಲ ನನಗೆ ಗಲಾಟೆ ಮಾಡ್ತಾರೆ. ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್ಗೆ ನನಗೆ ಕೂಡ ಗಲಾಟೆ ಮಾಡ್ತಾ ಇದಾರೆ.
150 families are suffering because of this.
ಎಲ್ಲಿದ್ದಾರೆ ನಿಮ್ ಸೀನಿಯರ್?
Okay, ಬೇರೆ ಕೊಟ್ಟದಿದ್ರು ಸರ್.
ಹಾ?
ಬೇರೆ ಕೊಟ್ಟದಿದ್ರು ಸರ್.
5 ನಿಮಿಷದಲ್ಲಿ ಬರ್ಬೇಕು.
Please. Tomorrow, my lord.
No tomorrow, sir.
Pass over, my lord. Instruction.
ಅದೇ ಗೌರ್ಮೆಂಟ್ ಆಫೀಸರ್ ಬರ್ತಾರೆ.
ಎಲ್ಲಿದೆ ಯಾವ ದಾಖಲೆ ನಿಮ್ಮ ಹೆಸರಲ್ಲಿದೆ ತೋರಿಸಿ. ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಏನ್ ದಾಖಲೆ ಇದೆ ತೋರಿಸ್ರಿ. . Pleadings ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರಪ್ಪ ಇವರು?
ಯಾವ್ದೋ 31/3/1937 ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಇದೆ ಅಂತ. 1937 ಇನ್ನ ಇಟ್ಕೊಂಡಿದ್ದೀವಿ.
1937.
There is no such application there.
And also page number 41 ಅಲ್ಲಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ಸ್ ಇದೆ ಇವ್ರು ಹಾಕಿದ್ದಾರೆ ಈಗ ಆ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ 41 ಇರ್ತಕ್ಕಂಥ ಪೇಜ್ ನಂಬರ್.
99.
That application on 15/4/2011.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ ಇವರು.
ಹಾಕೇ ಇಲ್ಲ ಏನೂ ಇಲ್ಲ.
Form number.
Where have you said you have filed an application for regularization?
Mainly pass over madam.
ಬೇರೆ ಏನು ಹೇಳಕ್ ಬರಲ್ವಾ? ಇದು 76 ಅಲ್ಲಿ ಬನ್ನಿ. The petitioner has challenged the has filed the instant petition challenging the order passed by respondent number
DC
Is
annexure F Malash.
ಪಾರ್ಟಿನೇ ಮಾಡಿಲ್ಲ.
the jurisdiction of deputy commissioner wide annexure
F Malash.
F to the writ petition where
Page number 43 Malash. 43.
F to the writ petition dated 23/7/2018, comma, wherein the land has been reserved for
Ashe.
Australia's scheme. Full stop. The case of the petitioner is that the said land was the case of the petitioners has been that they have been in possession of the property concerned and they have requested the authorities to grant the said land to their favor. And the government, disregarding the same, has granted the same in favor of respondent number
6.
Favor of R4 number. Managing Director Rajiv Gandhi Rural Housing.
And R5 executive officer ತಾಲೂಕ್ ಪಂಚಾಯತ್.
number 4.
ಅಲ್ಲ 5 ಗೆ ಆಮೇಲೆ executive officer ತಾಲೂಕ್ ಪಂಚಾಯತಿಗೆ ಮಾಡಿ ಆಮೇಲೆ then
ಏನ್ ಮಾತಾಡಿ
R5.
ಸರಿ ಬಿಡ್ಲ ಸೆಂಟೆನ್ಸ್ ಏನ್ ಬಂತು
ತಾಲೂಕ್ ಪಂಚಾಯತ್. ನಾನು ಹೇಳ್ತೇನೆ.
ಯಾವುದು? ದೇವನಹಳ್ಳಿ.
ದೇವನಹಳ್ಳಿ.
and the government, disregarding the same, has reserved the said land for Ashraya scheme.
In
Full stop. Next para. Per contra, the learned AG upon instruction submits that the petitioners have not made any application for regularization of their unauthorized occupation and cultivation of the land. And that they have no right over the property concerned. Full stop. Next para. Admittedly, the petitioner has not produced any document to show that they have right over the property concerned. And they are also not in a position to dispute the averment of the learned AGA that they have not made any application for regularization of their unauthorized occupation and cultivation. Full stop. For the said reasons, the writ petition is hereby dismissed. Yes, what about
Ashok, serial number 80.
77.
77, you know.
I appear for the petitioner in this case, my lord.
77, my lord.
77, my lord, the land were granted in favor of 4 petitioners, my lord, in the year 82. Petition number 1 was granted with the land from in the year 1982. Petition number 2 was also, my lord, granted with the land by the order of the land tribunal in the year 82. Third petitioner, my lord, got the property under a Sagoli cheat, my lord, in the year 2005. And petition number 4, my lord, in the year 2016. I'm sorry, my lord, 2000,
Granted in through
2003.
One second, AJ submitted something.
petitioner's claim is their vendors has granted a land through Inam Abolition Act. Your lordship may kindly see annexure A, my lord. It has been granted by the land tribunal. It cannot be. Special deputy commissioner has to be granted. Inam Abolition. It's a grant itself is bogus and created.
No, that cannot be decided here, my lord.
Respect to 77.
ಯಾರಿಗೆ ರಿಮೈಂಡ್ ಮಾಡೋಣ ಇದು? ಯಾರಿಗೆ ರಿಮೈಂಡ್ ಮಾಡೋಣ?
Remanded back to the special deputy commissioner.
Under what provision?
ಅದೇ ಬರೋದಿಲ್ಲ, ಇದು ಬರೋದೇ ರಿಮಾಂಡ್ ಮಾಡಕ್ಕೆ ಬರಲ್ಲ ಬಿಕಾಸ್ ಬೋಗಸ್ ಡಾಕ್ಯುಮೆಂಟ್.
Allah, no, my lord, it is
Verify the
usually
genuineness of.
No, sir,
genuineness of the document, my lord. This
documents are
order is
not
genuine
available in
because,
document.
my lord, land tribunal was also interested with the power to, my lord, grant at that time, my lord, because
You mean to say the entire annexure A is bogus?
Yes, man. Entire annexure is bogus.
my
Because
lord, it is not. It is not one petitioner, my lord, who is the beneficiary under the. There are several petitioners, around 20-26 petitioners, my lord, there,
land tribunal
and
have no
everybody are enjoying
jurisdiction.
the property. It cannot be said, my lord, on that basis, on a oral basis, my lord, without any documentary proof, that it is not a genuine document. And it has been elaborately said, my lord, because the conditions, the
Our office, my lord,
averment in the
Xerox
order
are
may
not
kindly
available.
be seen.
Only Xerox copies in the file. And order of the land tribunal Xerox copies in our office.
That cannot be the ground, my lord, if the original is not available with them. No, it is not mistake of the petitioner.
Okay, listen.
Inam
The
Abolition.
annexure A was passed on 31/5/1982.
Yes, ma'am.
Yes, my lord.
After that, what happened? RTC, what happened?
Yes, everything is there, my lord. Annexure B, my lord, is the mutation entry which is carried out in the name of petitioner. Then annexure C, my lord, is the sale deed executed by the original grantee in favor
Yes,
of my lord.
government
first
annexure B ಇದೇನಪ್ಪ ಆಗ್ಲೇ?
My lord. Annexure D.
Annexure B ನಪ್ಪ, B for Bangalore. MR. MR of 8 of 96-97.
MR ಇದ್ರಲ್ಲಿ ಇಲ್ಲ, ಈ ಡಾಕ್ಯುಮೆಂಟ್. MR ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ. There is no document.
See the produced annexure B, you'll have to say with regard to annexure B. Then RTC ಎಲ್ಲ ಹಾಕಿದಿರಿ? RTC ಎಲ್ಲ ಹಾಕಿದಿರಿ?
I think, my lord, annexure.
Annexure E, my lord, subsequent to the sale deed, I have produced the RTC in the name of first petitioner. ಇವ್ರದ್ದು ಒರಿಜಿನಲ್ ಗ್ರಾಂಟಿದು RTC ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
That's
First
the
petitioner,
Get the records, entire records will be,
You have to get the entire records.
Yes.
See, if MR and RTCs are coming,
please,
can make an inquiry if you want, that's all.
yes, ma'am.
But the point is, you can't just brush it aside and allot it to somebody else. That is not permissible.
Go to, my lord, it may be remanded back to the special deputy commissioner for inquiry.
No, remind under what provision? Show me that.
Inam Abolition Act, under the Inam Abolition Act.
Lord, there are 4 petitioners and under different orders, my lord, the grant has been made.
Their claim is the property as granted under the Inam Abolition Act.
See, first you make on affidavit you say, ಏನ್ RTC ಇದೆಯಾ MR ಇದೆಯಾ ಏನಿದೆ?
Yes, ma'am. Short date entire records will be secure and
The request of AG call on ಯಾವಾಗ?
ಯಾವ- 13. 13.
13th.
13.
Serial number 74, my lord.
Sir, 74 ಅಲ್ಲ ಆಮೇಲೆ ಬರ್ಲಿ ಸರ್, ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ? ಔಟ್ ಆಫ್ ವೆಕೇಶನ್ ಬರ್ಲಿ ಬಿಡಿ.
Please.
78 madam.
78 series ಏನು?
78.
ಸುಮನ madam. 78.
79
No password, madam. Take a date and go. 78 to the 16th, 13th ಹಾಕಿ.
30th tax.
70 ರಾಜೀವ್ ಗಾಂಧಿ ಎಲ್ಲಿ ತನಕ ಇದಪ್ಪ?
Happy for
87.
happy for Rajiv Gandhi.
ಇಲ್ಲ ಸರ್ 76 ಇಂದ 87 ವರೆಗೂ ಫುಲ್
ರಾಜೀವ್ ಗಾಂಧಿ.
ರಾಜೀವ್ ಗಾಂಧಿ
87 ಮಲಾಶ್ 87 ಅಲ್ಲಿ
ಅಪ್ ಟು
I am for the executive of the 87 ಮಲಾಶ್ ಇದರಲ್ಲಿ they are not questioning the ಗ್ರಾಂಟ್ ಆರ್ಡರ್ ನ ಕ್ವಶನ್ ಮಾಡ್ಕೊಂಡು KT ಗೆ ಹೋಗ್ತಾರೆ, KT ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ. ದೇರ್ ಆಫ್ಟರ್ ಅವರು ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಕ್ವಶನ್ ಮಾಡೋದೇ ಇಲ್ಲ. ಅವರು ನನ್ನ ಆರ್ಡರ್ ಅಂದ್ರೆ ನನಗೆ ಆಶಯ ಯೋಜನೆ ಕೆಳಗಡೆ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಮಾತ್ರ ಕ್ವಶನ್ ಮಾಡ್ತಾರೆ. ಅವ್ರು ಗ್ರಾಂಟ್ ಆರ್ಡರ್ KT ನ ಡಿಸ್ಮಿಸ್ ಆಗಿರ್ತಕ್ಕಂಥ ಇಲ್ಲಿ ಕ್ವಶನ್ ಮಾಡಿದಿಲ್ಲ ಮಲಾಶ್.
ಯಾವುದು?
The
Yes, sir.
grant order is not challenged there. Revenue entries were challenged. The KT has passed an order, you have to approach the assistant commissioner. I have no jurisdiction. It is not that the dismissal of the grant, that you read the order of the assistant, the KT.
kindly see the
We'll have it on 13th, no? Today.
Please,
there are so many
please, my
matters
lord.
to
But
discuss.
we will address arguments on 30.
ಆಲ್ ಮ್ಯಾಟರ್ಸ್
All matters adjourned to 13th.
76 to 87.
Chip, even 79, they have just filed the application for regularization. No other documents are forward.
78 to
There's no grant also in their favor.
No grant, only application pending.
Yes, 79 ಯಾರಿದ್ದೀರಾ?
79.
79 ರಘುನಂದನ್ sir.
Petitioner advocate is not there. We'll take it up on 13th itself.
13 all matters were 13th. 78 ಇಂದ 87 ವರೆಗೂ.
ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ನೋಡ್ಬಿಟ್ಟು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ.
ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದೆ ನೋಡಿ.
ಏನ್ ಶಂಕರ್ ಯಾವ್ದು ನಿಮ್ದು?
89.
ಯಾವ್ದು which one? 89 ಆ?
It involves a very short question about the acquisition.
89 ready ಅಲ್ಲ?
Sorry, my lord, last 2 vacation I am not present before the court, my lord.
No problem. Now you are ready, no?
Please, please.
Yeah, that's sufficient.
So the acquisition proceedings which are taken up under the new Land Acquisition Act, which is aimed at being transparent, fair, and rehabilitation, resettlement. Particularly in the present case, my lord will see the page number 41, which is the preliminary notification, which came to be issued by the state government. My lord gets it at Annexure D, page number 41. I will refer to some dates which are relevant to appreciate the entire controversy.
19/6/2020 is the date of preliminary notification.
19?
June 2020.
Hmm.
As per section 19(7) of the new act,
Hmm.
the final notification is required to be issued within
ಹೊಸ
1
act
year.
ಕೊಟ್ರೆ?
I draw my lord's attention to 19, section 19, subclause 7.
ಇದು ನನ್ ಮುಂದೆ ಯಾಕೆ ಬರೋ? Can't it go before the regular bench?
My lord, this matter has been heard twice and it involves a very short question, and the honorable court also expressed upon my submission. The honorable court did express that it will go into the details, and maybe if the law is not laid down, it will lay down the law. So that's what has transpired.
6 month extension ಅದಾ?
Yes, my lord, yes.
In respect of my lord, my
It's covered by the judgment of the Telangana High Court, which I will cite it out, which is akin to what my lord has expressed on the last date, not before that, last date of hearing, wherein the landowner is required to be compensated as a result of delay in the acquisition proceeding. Landowner cannot be deprived of the compensation amount which is pegged as on the date of preliminary notification. My endeavor is to, having heard this, kindly
ಮೊನ್ನೆ ಒಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಬಂದಿದೆ ನೋಡಿ.
No, that is on the West Bengal Municipal Corporation. We have insofar as the expediency, exigency, and also what are the citizens' rights? They lay down 7 parameters. Those 7 parameters, in fact, it is an antithesis to eminent domain. If the state were to adhere to, may I pass on the case, Laman?
ಅಲ್ಲ, ಇರ್ಲಿ, just ask.
So
ಹೇಳಿ,
it is an
19 ಹೇಳಿ.
antithesis to eminent domain, wherein they say that while eminent domain power can be exercised, please take care of these 7 parameters. And the right to speedy acquisition is also one of them. I will come to that aspect. Now, before that, section 19(7) may kindly be seen, where no declaration is made under subsection 1. The subsection 1 provides that the collector shall review the section 19 subsection 1. When the appropriate government is satisfied after considering the report, if any made under subsection 2 of section 15, that any particular land is needed for a public purpose, a declaration shall be made to that effect, along with the declaration of an area identified as the resettlement area for the purpose of rehabilitation and resettlement of the affected families, under the hand and seal of the secretary to such government or of any such officer duly authorized to certify its orders, and different declarations may be made from time to time in respect of different parcels of any land covered by the same preliminary notification, irrespective of whether one report or different report has or have been made wherever required. Section 19(1) provides 19(7). 19(7) is the final declaration, where no declaration is made under subsection 1 within 12 months from the date of preliminary notification, then such notification shall be deemed to have been rescinded, is the rule. There is an exception to that, provided that in computing that may not be relevant, provided further that the appropriate government shall have the power to extend the period of 12 months if in its opinion circumstances exist justifying the same. Provided also that any such decision to extend the period shall be recorded in writing, and the same shall be notified and be uploaded on the website of the authority concerned. The lawmakers were very clear, understanding the position as it prevailed under the Land Acquisition Act 1894, which took decades for the acquisition proceedings to be finalized. Thereby, if we take the BD Act, section 27 comes into play, lapsing of the scheme. Lawmakers may, by way of fiction, introduce incorporated section 19(7). If you don't follow this 1-year deadline, your acquisition shall be deemed to have been lapsed. The only rider is that for reasons to be recorded in writing, extension can be granted. The lawmakers left it there.
ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಯಾವ್ದಾಗತ್ತ?
Final notification gets passed on after 6 extensions.
10/4/2023.
Hmm?
10/4/2023.
So the 3 years extensions have been summarized at page number 14 by me in the memorandum of writ petition.
Preliminary notification under what provision of law?
Under sections of the 17.
11.
11, I'm sorry.
11(1).
Section?
11 of the new act.
No problem.
11-1, madam.
11-1. Okay, final notification under section
19, which I read out just now.
19-1,
Yes, yes.
So 19-7 limit, time limit.
Please.
Yes.
Time limit and extension.
Please.
Yes.
At page number 14 of the memorandum of writ petition, 6 extensions have been granted by the state. They have been summarized, 6. F, annexures F, G, H, J, K.
They have done it within the extended period.
Please.
Yes,
Please,
yes, ma'am. The extended period, now the honorable court will go into the reasoning of that extensions, whether those extensions were bona fide and they stand the scrutiny as provided, because this test has been adopted by the Telangana High Court, which I will demonstrate later after I summarize the position I hear. The,
ಅವರ್ಡದಲ್ಲಿದೆ section.
pardon me, ma'am?
ಅವರ್ಡದಲ್ಲಿದೆ section.
Award,
Ward 25.
award to be passed.
25.
In the present case, no award is passed.
25, madam.
Okay, I'm asking you, show me the section.
Yes, ma'am.
25.
25.
ಅವಾರ್ಡ್ ಯಾವ ದಿನದ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ತೀರಾ?
Lord, in this case is concerned, my lord, there
ಈ
is.
ಕೇಸ್ ಅಲ್ಲ. Preliminary notification compensation.
Please.
Under which provision of law?
Please, my lord, I know.
See, award
Please.
pass ಮಾಡಬೇಕಾದ್ರೆ you look into the market value of the property as on the date of issuance of preliminary notification. Which provision of law?
26.
26, my lord.
Proviso to section
Proviso.
20. 11 notification.
11 ನಲ್ಲಿ ಇದೆ. Provided, my lord, that due date of determination market value shall be date of notification issued under section 11.
Okay, justification for
Delay is
extension.
regarding, my lord, this case is concerned, my lord, there are 3, my lord, objection to the preliminary stages is concerned. First is, my lord, writ petition is not maintainable because, my lord, they are not made a necessary party. Here, my lord, acquisition made by for the railway project to track is concerned. These are public interest, on the basis of the public interest, my lord, we acquisition made. Second point is, my lord, the petitioner has not given preliminary notification, objection to the preliminary notification. Apart from that, my lord, my first submission is, my lord, that in the year of 2020, my lord, there is a corona period. My lord, I have stated in the, my lord, my statement of objections. Para number 4, page number 4, my lord. The COVID-19, my lord, the first wave, my lord, as per notification 24/3 and 2022, my lord, and another, my lord, COVID waves are, my lord, 2 waves are there, my lord. 1 year of 2020 and 21, my lord. And that is the reason, my lord, we are not set. Further, my lord, what happened, my lord? The SLO is, my lord, death, my lord, is expired. On that regard, my lord, I have stated my statement of objection itself, my lord. And that is the main, my lord, objections of this petition. And kindly see, my lord, there is one judgment of this Honorable Supreme Court that when larger interest of the public is, my lord, is involved, then, my lord, even though, my lord, statutory compliance is not required, then, my lord, acquisition may be upheld. That is my. Para 4 of 14, my lord. May I read, my having the held that impugn notification regarding acquisition land is invalid because it fails to meet statutory requirements, also having found to taking possession of the land and petitioner is the present case in the pursuance of said notification was not accordance with the law, the question arises whether relief can be granted petitioner. The full stop. The High Court has rightly observed that acquisition land present case was
for the project of the great national importance, that is the constructions of the national highway. The construction of the national highways acquired the land already has been completed as per information during the course of the hearing. No useful purpose will be served the quashing the impugn notification in this stage. We can't unmindful the legal position of the acquisition authority can always issue the fresh notification. Acquisition in the land event of the impugn notification.
Okay, ಇವಾಗ
ಎಲ್ಲ ಆಗಿದೆ ಇವ್ರದೊಂದು ಆಗಿಲ್ಲ because my lord entry mod is passed.
ಆಯ್ತು, listen.
Please, madam.
You give them compensation 1 year prior to issuance of final notification. I think they will be happy with it.
Please, madam.
We will uphold the acquisition.
Please.
Pay the compensation 1 year prior to passing of final notification.
Please.
My lord may consider the date of this judgment, whatever
Oh,
the
my lord.
judgment, my lord may.
One submission, my lord. One
whatever
submission,
is-
other submission, my lord, regarding my lord, the necessary party, my lord, regarding the object.
It's okay, they have to be heard for enhancement, that we know.
Please, please. The respectful submission is, my lord, this court itself held that, my lord, the necessary parties, my lord, benefit.
ಆಯ್ತು ರೀ, railways ನು party ಮಾಡ್ರೆ. I'll give you permission to make railways a party to the proceedings. If he is taking that objection.
No, ultimately, my lord, the interest of the public, my lord.
See, that's why I'm
Please, please,
suggesting a via media formula.
please.
Law nu lay down ಮಾಡ್ದಂಗ ಆಗತ್ತೆ. Okay. Purpose of section 25 proviso is,
11.
I mean, purpose of what do you say, 19(1) is
Please, to 12 months extension.
12 months.
Extension.
So that petitioner is not, I mean, the land loser is not put to a loss. Okay. See, we are not questioning the power of eminent domain of the state here.
Please.
They are not put to a loss. That's all. That is the bottom line.
Please.
So there it says 1 year. So extension adaglu 1 year ಒಳಗಡೆ ನೀವು compensation ಕೊಡಿ.
Please.
If you are agreeable, I'll pass the judgment now. If you are not agreeable, if you insist that railways have to be heard, I will give them time to make railways a party to the proceedings.
My lord, in respect of my lord, section 25 is when we clearly say that, my lord, then my lord, we can't go against that. my lord.
Huh?
Section 25 is, my lord, very clearly say that, my lord, determination of the compensation is concerned. There is a parameter is there. There's only question is, my lord, we are not complying the statutory. That ground not even rise in the petition.
I'm not striking down the
Acquisition.
acquisition proceedings.
Please.
What I propose to do is give the compensation 1 year prior to passing of final notification. At that particular rate.
It could be 10/4/2022.
Final notification 10/4/23/22, yes.
Then, my lord, is the precedent to all other cases. as-
Yes, it will be a precedent. I intend to make it a precedent. So the spirit of the act is upheld.
Yes, my lord.
Okay.
My lord, we consider 30th June 2022, which is the last day of second extension. 30th June 2022, which is just 2 months. If my lord would.
No, no.
No, no.
Final notification is 10/4/2023. I will lay down 1 year before that. That market value you have to take into consideration.
That could be 10/4/2022.
That would be 9/4/2022.
Please.
So 9/4. I'm only trying to persuade my lord to keep it at 30th June.
No, I think this is better because I'm guided by the statute over here.
Please.
Okay, I'll pass my judgment. Come.
My lord, there's some technicality. If my lord would consider 30th June, that would be the reckoning date. Because 2 months, 2 months would be, that is my lord will uphold the extension.
Sir, the reason for it is, I'll tell you, is section 25 itself.
Please.
Yes, ma'am.
The logical reasoning is section 25.
Provided the government shall.
Yeah, it would be there. Section 25 already.
ಅಲ್ಲ 26. 26 proviso.
No.
Provided that the date for determination of market value shall be the date as on which the notification shall be issued under section 11. Okay.
Yes.
11 is preliminary notification.
Yes, ma'am.
Okay. Then you come to 19.
Yes, ma'am.
19 is the final notification.
Yes, ma'am. My lord is
It
shifting the,
says the same has to be done within a period of 1 year.
yes, ma'am.
Alva.
Howdo. My lord is not preponing the final declaration. My lord is postponing the preliminary notice.
Yes, exactly.
That would be a. That will
That's
say.
the reason.
I was only trying to persuade my lord to take it to 30th
No,
June
illa.
2022.
Because I need to justify. This itself goes against the statute on Rite. I'm reading into statute now by this particular
To
judgment.
iron out the creases without laying a new fabric. Well, 30th June has a significance for the reason that I'm just leaving it to my lords. 30th June 2022 brings in a situation that my lord will uphold the extension till that date. And thereafter, the extensions are not considered to be proper. And also, that brings in the reasoning that whatever COVID and all, when the statute provides for it, that, my lord, I shouldn't be losing what I've got now by arguing it further. I'm only emphasizing that the COVID situation, death of land acquisition officer, when the law mandates that reasons to be recorded in writing, there is no other
I
manner.
won't go into those minute details on facts over here.
Yes,
I'm interested in doing justice.
yes, my lord, if justice,
Okay,
if,
the justice would be done if we fix the, see, at the end of the day, you're interested in compensation. The land is being acquired for railways.
yes, yes,
Setting aside for whatever reasons,
yes, ma'am.
by going into certain facts and analyzing it under microscope,
Yes,
if it results in setting aside the acquisition, it will cause injustice to the general public.
yes, ma'am.
Okay. So I don't want to strike down the acquisition. At the same time, see, you should not be put to a loss.
It
Person
will,
similarly situated.
yes, ma'am.
The final notification date is, see, it's
11th.
not the question of award.
Yes, ma'am.
It's not about delay in award that you are questioned over here. Please. Then the judgment would have been different. What has been questioned over here is delay in issuance of final notification.
Yes, ma'am.
Okay.
Yes, ma'am.
Because there is a delay in issuance of final notification for XYZ reasons, though they are justified, it goes against the spirit of the new act, because new act envisages that it has to be done within a period of
1 year, 12 months rather. Yes, ma'am.
12 months thereafter. In the instant case, I will say that I will interpret section 19 in such a manner that when there is a delay, from that to 1 year,
1 year prior to the final date will be the date of preliminary notification. My lord will be
for
postponing
the
the preliminary
purposes of
computation of the market.
computation of the.
My lord, the Telangana High Court did while dealing with this situation, I'm only as a matter of academic purpose, whatever my lord has taken the view there, they pegged the PN date to the date of judgment. I will hand over the case law.
I'm interested in doing like this.
Yes, my lord.
I'll finish it.
I'll leave it to me.
Okay.
So that way, for just for my understanding, my lord, then the preliminary notification will be pegged as 11/4/2022. That is
Yes.
the 1 year prior to the date of final notification.
Yes.
Obliged.
Yes.
If my lord, in other, this notification is concerned, my lord, other have my lord, already award is passed, my lord, then this case, my lord, present to all other cases also regarding this is concerned. If my lord, we have made, my lord, because this case we have not made any award because my lord, there is a stay in this case proceedings. They are not approved this one.
Will qualify it.
If
But
that is
this will become a precedent
please, my lord, and my submission is, my lord,
unless the state challenges it. Okay, you also give me facts regarding that extension not being done properly.
Yes, I shall.
I'll write a few lines regarding that also.
My lord, we'll see annexure D,
Form F.
annexure F.
Hmm.
F states,
Hmm.
I will, in fact, there are 5-line extensions. It may be relevant for me to read the every extension because they come out with a reason and put a warning that there shall not be any further extension. Page number 52, annexure F.
Hmm.
ತುಮಕೂರು ಚಿತ್ರದುರ್ಗ ದಾವಣಗೆರೆ ಹೊಸ ರೈಲ್ವೆ ಮಾರ್ಗದ ಯೋಜನೆಗಾಗಿ ಹಿರಿಯೂರು ತಾಲೂಕಿನ ಹೋಬಳಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಐಮಂಗಲ ವಸತಿ ಪುನರ್ನಿರ್ಮಾಣ ಕಾಯ್ದೆಯ ಸರ್ಕಾರಕ್ಕೆ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಕಲಂ 19(1)(2) ಅಂತಿಮ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಲು 2/7/2021 31/2/2021 ಕಾಲಾವಧಿಯನ್ನು ವಿಸ್ತರಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ. ಸೊ ದಿಸ್ ಇಸ್ ದಿ ಫಸ್ಟ್ ಎಕ್ಸ್ಟೆನ್ಷನ್. ದೆನ್
Reasoning ಎಲ್ಲ ಕೊಟ್ಟಿದಾರ?
ಏನು ಇಲ್ಲ, ಇಷ್ಟೇ.
Reason is, my lord, it is not.
That is
required.
what
It
is
is
my
notific-
case.
It is not, it is notification, my lord. Reason in the, my lord, my lord, in noting sheets where there is there, my lord.
ಎಲ್ಲಿದು ತೋರ್ಸು.
Regarding, my lord, that file is, I am not secure, my lord, but have it on Friday, my lord, I will take it.
It's okay.
Please. To say that, my lord, on that regard, my lord, I have filed the objections regarding that is concerned. The COVID is
And
there.
then my lord will see annexure G, second extension, 17/3/2022. That is, after the expiry of 31/12/2021, annexure G comes in as if there is no, this provide, I mean, this will cut at the root of the matter for the government because they ought to have done the extension by 30, they ought to have issued the final declaration by 31/12/2021. My lord, may kindly note in this state. And what happens is on 17/3/2022, they come. Then there is a vacuum here. Generally, extensions are granted during the currency of the period. Here, there is no currency of the period. 17th, so to 31/12/2021, it got expired. And there is a vacuum till 17/3.
ಆಯ್ತು ನೋಡ್ದೆ, ಆಮೇಲೆ next.
ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಇನ್ನ ಫರ್ದರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಅನ್ನೆಕ್ಷರ್ ಎಚ್ ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಒಂದು ಲೈನ್ ನಾನು ಹೇಳ್ಬೇಕು. ಇದರಲ್ಲಿ ಒಂದು ಲೈನ್ ಹೇಳ್ಬೇಕು. ಅಂತಿಮ ಸೂಚಿಯನ್ನು ವಿಸ್ತರಿಸಿದ ಅವಧಿ ಒಳಗಾಗಿ ಅಧಿಸೂಚಿಸುವ ತಪ್ಪಿದಲ್ಲಿ ವಿಶೇಷ ಭೂಸ್ವಾಧೀನ ಅಧಿಕಾರ ನೇರ ಹೊಣೆಗಾರನಾಗಿ ಮಾಡಲಾಗುವುದು ಹಾಗೂ ಮತ್ತೊಮ್ಮೆ ಕಾಲಾವಧಿಯನ್ನು ವಿಸ್ತರಣೆ ಮಾಡಲಾಗುವುದಿಲ್ಲ. ದಿಸ್ ಇಸ್ ದ ಮ್ಯಾಂಡೇಟ್ ಆಫ್ ದ ಗವರ್ಮೆಂಟ್. ಅಂಡ್ ದೆನ್ ಕಮ್ಸ್ ಅನ್ನೆಕ್ಷರ್ ಎಚ್, similar words, 31/10/2022. Then annexure J, similar extension. Then annexure K, similar extension. Then
ತಪ್ಪು
L ನಲ್ಲೂ ಸೇಮ್ ರಿಪೀಟ್ ಆಗುತ್ತೆ. 10/4/2023 ಫೈನಲ್.
First, second extension.
ಆಯ್ತ್ರಿ, ನಮ್ಗುನು ಇದು
COVID ಇತ್ತು ಅಂತಾನೆ ಬರ್ತಿದ್ ನಾವು.
ಕೋವಿಡ್ ಅಲ್ಲಿ ಯಾವ್ದು
ಹೇಳಿಲ್ಲ, but there is a note sheet, my lord, there is.
ಆಯ್ತು. Well, pass the judgment. The lands of the petitioner have been sought to be acquired.
One submission, my lord, to regarding, my lord, that this case, my lord, to present to all other case when, my lord, extension is made by the government. Then only, my lord, applicable to this. Other cases not applicable to this.
ಅದ್ ನೋಡೋಣ, ಕೊನೆಯಲ್ಲಿ ಹೇಳಿ.
ಯಾಕಂದ್ರೆ ಅದು ಇಲ್ಲ ಅಂದ್ರೆ ತುಂಬಾ ತೊಂದರೆ ಆಗ್ಬಿಡ್ತೀನಿ. ಎಕ್ಸ್ಟೆನ್ಷನ್ ಇರೋ ಕೇಸಿಗೆ ಅಪ್ಲೈ ಆದ್ರೆ ತೊಂದರೆ ಆಗುತ್ತೆ. ಇಲ್ಲ ಅಂದ್ರೆ ಬೇರೆ ಕೇಸಿಗೆ ತುಂಬಾ ತೊಂದರೆ ಆಗುತ್ತೆ.
ಬೇರೆ ಕೇಸಲ್ಲಿ ಅಂದ್ರೆ ಯಾವ ರೀತಿ ಎಕ್ಸ್ಟೆನ್ಷನ್
ಅವಾರ್ಡ್ ಮಾಡದೆ ಕೆಲವೊಂದು ಕೇಸಲ್ಲಿ ಅವಾರ್ಡ್ ಮಾಡಿರಲ್ಲ. ಸಪ್ರೇಟ್ ಗ್ರೌಂಡ್ಸ್ ಇರುತ್ತೆ, ಐ ಮೀನ್ ಸಪ್ರೇಟ್ ರೀಸನ್ಸ್ ಇರುತ್ತೆ. ಇದ್ರಲ್ಲಿ ಹಂಗ ಆಗಿಲ್ಲ. ಇಸ್ ಎ ಪೆಕ್ಯುಲರ್ ಕೇಸ್ ರಿಗಾರ್ಡಿಂಗ್, my lord, ಕೋವಿಡ್ ಇರೋದ್ರಿಂದ ಹಿಂಗಾಗಿರೋದು. ಅಂಡ್ ಆಲ್ಸೋ
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಡನ್ ಬೈ ಗವರ್ಮೆಂಟ್ ಅಲ್ವಾ ನಾಯಕ್?
ಪ್ಲೀಸ್.
ಅದನ್ನ ಹೇಳ್ತೀನಿ ಅಷ್ಟೇ. When there is delay in publishing final notification, this will apply.
Please.
When a final notification is upheld. ಏನ್ ಬಂತು? The lands of the petitioner have been acquired and sought to be in both. Have been acquired by the respondents for the purposes of Indian Railways. Correct ಏನ್ರಿ? Indian Railways ಏನ್ರಿ?
Please, my lord.
Indian Railways ಗೋಸ್ಕರ acquire
Please.
ಮಾಡಿದ್ರು. For the purposes of Indian Railways. Full stop. On the ground that there has been delay in passing the final notification. contrary to the provisions of Right to Fair Compensation Act, ಪೂರ್ತಿ ಹಾಕೊಳ್ಳಿ, hereinafter referred to as the Act. The petitioner has challenged the petitioners ಅಷ್ಟೇನಾ? Petitioner has challenged the said accusation. Full stop. Next para. The preliminary notification under section 11(1) of the Act was passed on 19/6/2020. Full stop. Thereafter, the time for publishing the final notification was extended. Time for publishing was extended. As per section 19 clause 7 of the Act, by a notification dated 3/12/2021. Wherein the time stood extended from 2/7/2021 to TO2 31/12/2021. Full stop. Thereafter it was again extended by another notification dated 17/3/2022, wherein the period was extended from 1/1/2022 to TO2 36/2022. Full stop. Thereafter it was again extended by a notification dated 25/8/2022, wherein same ಮೇಲೆಳದ್ನಲ್ಲ, it was extended from 36/2022 to 38/2022. Full stop. Again it was extended by a notification dated 25/11/22 for the periods 1/11/22 TO2 31/12/22. Full stop. Again it was extended for the periods 1/1/23 to 31/3/2023 by a notification dated 6/3/2023. Full stop. Again it was extended for the period 31/3/23 to 10/4/2023 by a notification dated 10/4/2023. And the final notification has been published on 10/4/2023.
Published on 12/4, issued on 10/4.
Huh?
Published on 12/4, issued on 10/4.
10/4/2023. Full stop. The case of the petitioner is that no appropriate reasons have been given for the said extension, and even otherwise, extension of time as contemplated under section 19 clause 7 also was not properly done. And as it is reflected by the dates on which the notifications were published, it shows that by the time the notifications were issued, notifications for extension were issued, the time had already lapsed. And for the said reason, it is prayed that the preliminary notification and the final notification should be set aside. Next para. Per contra, the learned counsel appearing for respondents, submits that firstly, the petitioner has not implemented Indian Railways, who is the beneficiary of the acquisition as a party to the proceedings. Full stop. That the acquisition took place during the COVID period. And furthermore, that there was a death of the jurisdictional SLAO, which warranted extension of time. Full stop. He further submits the said reasons have been recorded in the.
One more reason, my lord, the general election has been held in the year of.
He further submits. He further submits on the purpose. He further submits that all general elections.
23, my lord.
State ಅಲ್ಲ
ಹೌದು ಎಲೆಕ್ಷನ್
ಅದು ಮೇನ್ ಅಲ್ಲ.
ಅಲ್ಲ 2020 ಅದನ್ನ ಹೇಳಿದ್ದೀನಿ.
That general elections were scheduled in the state of Karnataka. Assembly elections.
Please.
Assembly elections were scheduled in the state of Karnataka
Board of Conduct.
in the year 2023. Full stop. For the said, he submits that said reasons have been recorded, and for the same, there has been extension of
Issuing notice. Final.
issuance of time grant. There has been extension of
Time.
time
To issue final notification.
to issue final notification. Full stop.
One more reason, my lord, I have not given a objection to the preliminary notification.
He also contends that the petitioner had not objected to the acquisition process, and he had not filed his objections pursuant to issuance of preliminary notification.
Please.
Full stop. For the said reasons, he prays for dismissal of the writ petition. Full stop. Next one. The question that arises for consideration is that under the given facts and circumstances of the case, is it appropriate to set aside the acquisition or not? Full stop. Next, for developmental work, the state is always for developmental work for developmental work and and in the interest of general public, state is empowered to exercise its power of eminent domain and acquire the lands required. Full stop. However, the same has to be done in the manner known to law. Full stop. The Honorable Supreme Court in so-and-so case reported in 2005-13 SCC
477.
in paragraph 14, has held as under 14 extract. Full stop. Next for under the in the present circumstances, the property is sought to be acquired for the purposes of a railway project, which is of a national importance. And under the circumstances, I am of the opinion the court should be reluctant to set aside the acquisition being done. Full stop. However, care should be taken that petitioner is duly compensated for the loss of his land. Full stop. Next para. The right in full extend ಮಾಡಿ expand ಮಾಡಿ ಅಷ್ಟೇ. The act ಅಂತ ಹೇಳಕ್ ಹೋಗ್ಬಿಟ್ಟು ಈ ಒಂದ್ ಜಾಗದಲ್ಲಿ ಮಾತ್ರ. The right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act was passed in the interest of was passed with the following objective. Through the preamble ಇದೆಯಲ್ಲ ಅದನ್ನ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿ with the following objective. ಇಷ್ಟು. Single inverted comma ಹಾಕ್ಬಿಡಿ ಅದಕ್ಕೆ. ಅದನ್ನ inverted comma ಹಾಕ್ಬಿಡಿ with the following objective. With the following objective as reflected in the preamble to the statute. As reflected in the preamble to the statute. ಆಮೇಲೆ ಅದನ್ನ extract ಮಾಡಿ. Full stop. Next para. For the said reason, the statute contemplates that a final notification has to be done within a period of 1 year. Final notification has to be published within a period of 1 year.
12 months.
Within a period of 12 months from the date of publication of preliminary notification. From the date of publication of preliminary notification. Huh? Come on, keeping in mind that award to be passed shall take into consideration the value of the land as on the date of issuance of the preliminary notification. Section, full stop. Section 11 clause 1. Section 11 clause 1. A preliminary notification is issued as per the provisions of section 11 clause 1 of the Act. Full stop. Thereafter, persons are prohibited from making transaction in respect of the land concerned. Full stop. Section 11 clause 4 of the Act reads as under. Provisions also haki. Full stop. Section 19 clause 1 reads as under. Section 19 clause 7 reads as under, Purti, including provisos. Section 25. Of the Act pertains to making an award and it reads as under. Section 26, clause 1, proviso reads as under. ಇಷ್ಟು ಮಾತ್ರ ಹಾಕಿ ಅಷ್ಟೇ. ಇದು ಹೆಡ್ಡಿಂಗ್ ಹಾಕ್ಬಿಟ್ಟು ಡಿಟರ್ಮಿನೇಷನ್ ಆಫ್ ಸೋನ್ಸ್ ಆದ್ಮೇಲೆ ಇಲ್ಲಿ ಪ್ರಾವಿಸೋ, ಫಸ್ಟ್ ಪ್ರಾವಿಸೋ 2 ಲೈನ್ ಇದೆ ಅಲ್ಲ, ಅದು ಮಾತ್ರ ಹಾಕಿ. Reads as under. Full stop. Next para. Thus, perusal of the aforementioned provisions makes it clear that the Act contemplates completion of the acquisition proceedings within a time frame failing which the acquisition proceedings stands lapsed, so that undue hardship is not caused to the land loser. Full stop. However, lapsing of the land does not prohibit the state from again initiating acquisition proceedings by invoking its power of eminent domain. Full stop. In other words, the intention of the legislature is that final notification and the award has to be final notification and passing of the award has to be completed within a specified time frame, so that the petitioner is duly compensated and he will not feel cheated due to the acquisition proceedings, by the state. Full stop. That is the intent of the legislature. Full stop. Further, as reflected in the preamble to the statute, the Act intends to facilitate acquisition of the land for developmental purposes. Developmental purposes in public interest done by the state. Developmental purposes in public interest done by the state. Full stop. Next para. Keeping the above intent of the legislature under the given peculiar facts and circumstances of the case, ಅಲ್ಲ ಸರಿ ಬಿಡಲ್ಲ ಏನ್ ಬಂತೇಳಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ಹೆಂಗ್ ಶುರು ಆಯ್ತು ಅಲ್ಲ ಅದು ಹೊಡೆದಾಕೆ ನೆಕ್ಸ್ಟ್ ಬರೋದಲ್ಲಿ With regard to extension of time, the Act also contemplates a situation wherein it may not be possible for the state to complete issuance of a final notification within the specified period of 1 year from the date of issuance of the preliminary notification for various reasons. And for that reason, extension is provided for under section 19 clause 7 of the Act. Full stop. However, this exception of however, this provision has to be treated as an exception to the rule of issuance of final notification within 1 year from the date of issuance of preliminary notification. And the exception cannot eat away the rule. Full stop. It cannot be interpreted in a manner so as to defeat the just compensation that the land loser would be entitled to. Full stop. Next para. Further, as per the judgment of the Honorable Apex Court in 2013 SCC 477 stated above, the law should not be interpreted to thwart the development the developmental work taken up by the state in public interest, relying upon technicalities. Under the next para, under the given peculiar facts and circumstances of the case, wherein the land is sought to be acquired for a public purpose, that is for development of infrastructure for railways, wherein extension of time was warranted due to the extraordinary COVID situation and the death of the jurisdictional SLAO, albeit notifications issued for extension of time belatedly with retrospective effect and the petition having been filed without making the beneficiary railways, Indian Railways, a party to the proceedings. Comma, I am of the opinion interest of justice would be met if ಅಲ್ಲ ಏನ್ ಬಂತು ರೈಲ್ವೇಸ್ ಅಲ್ಲ ಇನ್ನೊಂದು ಸೇರಿಸ್ಬೇಕು ಅಲ್ಲ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ರೈಲ್ವೇಸ್ ಪಾರ್ಟಿ ಟು ದ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ and also taking into consideration the fact that the petitioner had not objected for acquisition of his land pursuant to issuance of after issuance of the preliminary notification, I am of the opinion that interest of justice would be met if the date of if the date for determination of market value of the land concerned for passing of an award in favor of the petitioner is fixed 1 year prior to issuance of final notification, that is on 9/4/2023 instead of 19/6/2020, which is the date of issuance of preliminary notification and upholding the acquisition.
The instructions are that the objections have been filed to the preliminary object. That aspect may be modified, or it may be that having regard to the stand of the state, because I have a copy of the objections filed
As
here.
per regard, my lord, my instructions, my lord, objection is.
No,
not-
no, I have a copy. I have a copy. If only you had taken this stand in the statement of objection, I would have filed a
No,
rejoinder.
I have taken this stand. I have taken that stand.
Let's not get into that, my lord. My lord, may,
Para six.
my lord,
Para six, I have taken stand.
See, that will only, that is only in respect of, ಹೇಳಿ ನಿಮ್ಗೆ ಏನ್ ಮಾಡೋಣ ಈಗ
ಅಲ್ಲ ಆ ಸ್ಟ್ಯಾಂಡ್ ಬೇಡ ಅದನ್ನ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದಂದ್ರೆ
Para six ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಪಲ್ ಹೇಳಿದ್ದೀನಿ.
the petition
Take that stand, that's the reason I'm.
not filed any objection to preliminary notification ಅಂತ, ಬಟ್ ನನ್ನ ಹತ್ರ ಕಾಪಿನೇ ಇದೆ ಅಬ್ಜೆಕ್ಷನ್ ಕಾಪಿ. ಅದಕ್ಕೋಸ್ಕರ ಆ ಕಾಂಟ್ರವರ್ಸಿಗೆ ಹೋಗುವುದೇ ಬೇಡ
Seriously,
ಅಂತ.
are you seriously going into it?
ಅಲ್ಲ ಅದಕ್ಕೆ ಆ ಕಾಂಟ್ರವರ್ಸಿಗೆ ಹೋಗುದೇ ಬೇಡ. ತಾವು ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರೆ ಐ ಹ್ಯಾವ್ ನಾಟ್ ಫೈಲ್ಡ್ ದಿ ಅಬ್ಜೆಕ್ಷನ್ ಅಂದ್ರೆ ಇನ್ ಮೈ ಪ್ರೆಸೆನ್ಸ್ to that extent, even though objection is now filed, it is taken as not filed because my lord's verdict says that it is not filed. Therefore, and I have a copy of it.
I am
Let
not
it
attached
lie.
with the petition itself.
No, maybe perhaps it is not produced, but then I have a copy of it. So my lord may consider not going into that aspect of the.
ಮೇಲ್ಗಡೆ ಚೇಂಜಸ್ ಮಾಡೋಣ ಒಂದ್ ಬ್ರಾಕೆಟ್ ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ because I can't revisit it now. After completion of the dictation, if you say it, how can I revisit it now? Anyway, I will include it before.
Yes, ma'am. Yes, ma'am.
ಒಂದ್ ಬ್ರಾಕೆಟ್ ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ ಅದನ್ನ ಮೇಲ್ಗಡೆ ಸೂಟಬಲ್ ಚೇಂಜಸ್ ಮಾಡೋಣ ಎಲ್ಲಾ ಕಡೆ ಅಷ್ಟೇ.
I'm sorry, my lord. This was a
Uh,
slip. I'm sorry. I'm greatly obliged.
Legal notice, my lord, it is not.
ಇಲ್ಲಿ ರೀ, ಅದು
ಇದು
objection ಕೊನೆ
state
paragraph.
contents that objections have not been filed. ನೋಡ್ರಿ ಇನ್ನೊಂದ್ಸಲ to the preliminary notification, whereas wherein however the same is disputed by the petitioner. Petitioner, full stop. However, the advocate for the petitioner submits that challenge to the acquisition is on the ground of delay in publishing the final notification
Invalidity of the extensions.
and not on the ground that he has raised in his objections to the preliminary
ಸುಮ್ನೆ
notification.
ಇರಿ, ಇವಾಗ ಏನ್ ಮಾತಾಡ್ಬೇಡಿ ನೀವು.
Before, my lord,
Okay, huh?
the objection is not given, my lord, before, my lord, 1 month before, my lord, final notification.
Till now
9/20 ನಲ್ಲೇ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಅವ್ರಿಗೆ. Statutory application ಇರೋದು ಒಂದ್ ತಿಂಗಳಲ್ಲಿ. They are given in the year of 2023.
We can't record it.
ಅಲ್ಲ 21 ನಲ್ಲಿ ಸಾರಿ
ಇಲ್ಲ ಇಲ್ಲ 23.
ನೋ 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 ಪ್ಲೀಸ್ 21 ನಲ್ಲಿ ನೋಡಿ ನೋಡಿ 21 ಪ್ಲೀಸ್ ರೀಡ್ ದ ಡೇಟ್ ಸರ್ ಪ್ಲೀಸ್ ಲೆಟ್ ದೇ ನಾಟ್ ಬಿ
21.
no
Okay, this I think now what I did.
yes my lord, absolutely right, because it puts the record straight, because when the subsequent developments are to take place,
ಯಾರು ಅಪೀಲ್ ಹೋಗ್ತಿರೋ ಯಾರಿಗೂ
ಗೊತ್ತಿಲ್ಲ, ನಾನು ಅದು ಹೇಳಲ್ಲ, but we will be into difficult situation.
understand.
I am greatly obliged.
Copy.
Put. I'm obliged.
ನಿಮ್ದೇನೇನ್ರಿ ಕೇಸು ರಾಜಣ್ಣ? ಇದು ನಿಮ್ದ ಕೇಸು? ಹಾ, ನಿಮ್ ಫ್ಯಾಮಿಲಿ ಇದೆನಾ? ಅಲ್ಲ, ನೇಮ್ ಸೌಂಡೆಡ್ ಸಿಮಿಲರ್, ಸೊ ಐ ಆಸ್ಕ್ಡ್. ಆಯ್ತು, ಏನ್ ಬಂತೇಳಿ? And upholding the acquisition. Huh? Hence the following order. The act of respondents in acquiring the lands belonging to the petitioner, the subject matter of the writ petition, is hereby upheld. Full stop. However, next para. However, respondent number 2 is directed to pass the necessary award in respect to the lands concerned by taking into consideration the market value of the land as on
9/4/22. 9/4/22.
9/4/2023. Full stop. Writ petition is disposed of accordingly. Report, man. We'll report it.
My lord, instead of saying the market value computation, the preliminary notification date be treated as a preliminary notification date. For the reason, my lord, is operative portion, the way I have understood is that my lord has directed the respondents to determine the compensation by keeping the market value as on the date which is 1 year prior to the final declaration. May I persuade my lord to, maybe if my lord gets convinced about my submissions, to reword it as to treat that date as a date of a preliminary notification. For the, no, let me complete, my friends. So the difference would be that computation of the market value as on the date prevailing, which is 1 year prior to the date of final notification, is one thing. Another thing is to say that the date of preliminary notification be reckoned as the date, the date shall be the 1 year prior to the, it amount to the same, but it will have some, what I would say that.
Because I'm limiting it to market value.
My lord, no difficulty on the market value, my lord, limiting it. There could be what I meant to submit is that treating it as my lord, ultimately it is shifting.
Treating it as preliminary notification, there will be other consequences.
Yes, my lord.
Which I don't want, I don't intend to alter over here.
Hmm.
Okay.
Hmm.
See, for example, transactions that have taken place. All those things will come into picture.
Hmm.
Which I don't want to, I'm not deciding about any of those things. See,
my
I
lord.
am upholding this acquisition and ordering payment of compensation 9/4/22. I have analyzed only that particular angle and no other angle over here. Because if I treat the preliminary notification date as 9/4/2022.
Yes, ma'am.
9/4/2022 ಅಂತ ಹಾಕೊಳ್ಳಿ. 9/4/2022. ಓಕೆ. ಎಲ್ಲ ಕಡೆ ಇದು ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ 10/4/2023. So 1 year back ಅಂದ್ರೆ 9/4/2022.
Yes, ma'am.
See, what happens? There is a bar on entering into transaction. So many things comes in. Okay. All those things will get upset. I'm not looking into those aspects at all. This is only limited to compensation that you are entitled.
No, Telangana, of course, I have not for a moment saying those.
Sir, I have passed my orders. You can.
No, I want to. No.
See, there are so many imperfectness you can point out. You can say that, the government can say that, when the statute says, say extension is provided for, who is this judge to interpret it otherwise?
No,
You can take up that contention.
No, the Honorable Court has balanced the equities.
You might have said, you can take up a contention saying that when there is, on the face of it, illegal extension done by the government, there is no question of any, ಇದನ್ನ ಕಾಜಿ ನ್ಯಾಯ ಮಾಡಕ್ ಕೂತಿದೀವ ನಾವಿಲ್ಲೇ ತಿಪ್ಪೆ ಸಾರಿಸಿದಾನೆ ಜಡ್ಜ್ ಅಂತಾನು ನೀವು ಬೈಕೋಬಹುದು.
No.
I'm telling you. See, I've just balanced out equity.
Yes, ma'am. Readjustment of equities.
That the project is not stalled, number one. Number two, you should get a just and fair compensation. That has been the aim of it.
Yes,
But ಯಾವನಾದ್ರೂ ಸೂಪರ್ ಟೆಕ್ನಿಕಾಲಿಟೀಸ್ ನೋಡೋ ಮನುಷ್ಯ ಸಿಕ್ಕಿದ್ರೆ he may completely disagree with whatever judgment that has been
That's
passed.
what the latest, the Supreme Court just says, that the lawyers are the actors and the judges are the directors of a movie. I'm just saying it.
Yeah. I have took shelter under the Supreme Court judgment. That's all. Okay, I passed my orders, sir.
I have done my acting job, my lord. I'm greatly obliged for the indulgence shown. I put on. I'm sorry, my lord, if I interrupted in between.
No,
it
no,
was-
not at all, not at all.
Obligement.
ಅದೊಂದು ಬೇಡ, ಅದೇ ಬೇಡ. ರಿಪೋರ್ಟ್ ಮಾಡಿ 90 ಅಲ್ಲ 90 ಕರೆದ್ಬಿಡಿ ಒಂಚೂರು. ವಿ ಆರ್ ಮೇಕಿಂಗ್ ಹಿಮ್ waiting. I am feeling bad for him.
Sir.
An advocate waiting is different. Party in person coming and waiting is different. Advocate will have so many cases.
Your Honor, if I had known that this matter would take 20 years, I would have taken a law degree and come in a court.
I think you would have performed very well given the way that you are arguing your own case. I have no hesitation saying it. ಇವಾಗ ಯಾವತ್ ಕಮ್ಮಿ ಇದೆ ನೋಡಿಯಪ್ಪ, ಅವತ್ತು will take his matter.
Can be taken after vacation.
Problem is this roster, I've been saddled with two main subjects. LR, KLR and tax. That's why it's happening this way.
Yes, ma'am.
Unable to
Your Honor, if it
No,
can be done
please.
before the vacation. Not possible.
come many times, madam. Yes,
The
come many
problem is
times.
this, my lord, because DCM has to take a call on this point. Your Honor, I DCM
Oh,
is is not submitting. available. I have already put forth the matter before the concerned authority. They are telling that because of the Belgaum session, they are unable to meet the higher authorities.
Madam, you can't say that because of Belgaum session, there will be paralysis of
Because
administration.
I have already brought to the notice of the higher authorities. Till today, they are unable to meet the. Your Honor, I will be submitting that this whole process of them trying to overturn the Keshanarayana Committee report is completely not allowed. I have got judgments to support that.
I don't want to carry it to, I have opted for outside, actually. I have opted for Kalburgi. ಸಿಗುತ್ತೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ ನಂಗೆ. January, February. I don't want to carry Bangalore cases over there.
Yes,
I want to finish it.
maybe 7th, my lord.
No, madam. It has to be before vacations.
9th.
You will pass my orders. ಯಾವತ್ತು ಕಮ್ಮಿ ಇದೆ ನೋಡಿ. ಈ ಸ್ಟ್ರಕ್ ಆಗ್ದಲ್ಲ ಇದ್ರೆ ಇವತ್ತು ಮುಗಿಸ್ಬೋದು. ಮಂಡೆಯಿಂದ ಯಾವಾಗ ಬೇಕಾದ್ರೂ.
19th, ma'am.
It can't be 19th, madam. Sorry.
20th.
16th we gave it some pattern. 17th ಕೊಟ್ಟಿದ್ದೀವಾ 16, 17th because I want to fix it at 3:30. 2:30 ಯಾವ್ದು ಇದೆ ನೋಡಿ. 16th ಯಾವ್ದು ಇವ್ರದಕ್ಕಿಂತ ಮುಂಚೆ ಏನಿದೆ ಅದು ಅಥವಾ ಇವ್ರದ್ದು ಆದ್ಮೇಲೆ ಬರುತ್ತೆ ಯಾವ್ದು 16th ಅಲ್ಲ 16th 2:30
16 to 30.
16 to 30. Yes, sir. 16. The request of parties call on 16th at 2:30. That's serial number 90. Put it into the list.
88, my lord.
Yes, madam.
88.
Government is.
I have
Comment.
moved the matter, my lord.
Lordship may kindly see the interim order. Committees are not functioning because of this.
Put
No,
it
there is no, your Lordship may kindly see the interim order here. No precipitate action.
Only in so far
Yes,
as the
serial number
applicant
88.
anta ಇದೆ, that has to be clarified, that's all. The interim order
Clarify
should be
ಮಾಡಿದ್ರೆ
clarified.
ಅಷ್ಟೇ ಸಾಕು. Order clarify ಆಗ್ಬಿಟ್ರೆ ಸಾಕು.
Put it.
ಇಬ್ರು ಲೆಟರ್ ಕೊಡ್ತಾರೆ ಕಂಟೆಂಪ್ಟ್ ಆಗ್ತೀನಿ ನಿಮ್ಮ ಮೇಲೆ ಅಂತ ಅದು ಯಾವ್ದು ಕಮಿಟಿ ಮಾಡ್ತಾ ಇಲ್ಲ.
But I want to argue the matter, but I want to argue if Lordship may post it any date, I want to argue. Either way, Lordship may take it. The reason is this, I'll explain to you Lordships in a minute. Lordships are rising, I'm aware of it. But the act contemplates constitution of a committee for regularization. For instance, in Belur, there are about 30,000 cases. Baindur, sorry. What they do is they appoint the member of the Legislative Assembly who is expected to be the chairman under the rule and gives him about 8,000 cases and creates an additional committee, appoints the defeated candidate as the chairman and gives him 22,000 cases. It's not about cases, numbers or anything else. The method and manner in which the state government has exercised its statutory powers, when the statute prescribes certain limitations on that, is called into question before your Lordships on the grounds of judicial.
Padarupu committee.
Acts is
Number
One nimsha, sir.
here, my lord, any person can be appointed.
No,
to
it's
second-
not, I'm not on that, but provided circumstances exist.
Sitting MLA should be appointed as chairman. In the second
Pro-
committee, any.
No, the
person can-
section is not preconditioned by saying circumstances must exist and the government must form a subjective satisfaction that there is a necessity of an additional committee. And that necessity should be preconditioned by circumstances. The government is bound to show before your Lordships to the satisfaction for judicial review as to what were the circumstances and how they arrived at that conclusion. This is all the narrow compass.
33,000 cases are.
One
pending.
ನಿಮಿಷ ಸರ್ ಕೇಳ್ಬಿಟ್ಟು I will hear you.
It's on that narrow compass, my lords, which the writ petition has been filed. And it is on that ground their Lordships were pleased to grant an interim order.
Okay, one second. That's all, no?
Yes.
Yes. ಒಂದ್ ನಿಮಿಷ ರೀ ನಾನು ಕೇಳೋದಕ್ಕೆ ಉತ್ತರ ಕೊಡಿ. ಈಗ ಕಮಿಟಿ ಯಾರು ಕೂತ್ಕೊಂತಾರಪ್ಪ?
Committee, first committee is the chairman, MLA, sitting MLA is the chairman, secretary, Tahsildar is the secretary. And
Tahsildar
other three
secretary.
members.
Plus 3 members.
Totally 5.
Totally 5 members.
Under rule 100.
Second committee, additional committee,
In additional committee also 5 members,
where who heads it?
but there is no particular person, any person can be appointed, made a chairman.
Okay.
That is.
What is his qualification?
No call.
He is MLA, he was ex-MLA, I think.
No, what is his qualification? You should prescribe some qualification, na? ನೋಡ್ರಿ
Ex-MLA,
ಇದ್ರಲ್ಲಿ-
ex-MLA is this qualification.
ಪ್ರಾಬ್ಲಮ್ ಏನ್ ಗೊತ್ತಾ? ನೀವು ನಿಜವಾದ ಲ್ಯಾಂಡ್ಲೆಸ್ ಅನ್ಆಥರೈಸ್ಡ್ ಆಕ್ಯುಪೆಂಟ್ಸ್ಗೆ ನೀವು ಜಮೀನ್ ಕೊಡಲ್ಲ. ಅದು ಸರ್ಕಾರಿ ಗೋಮಾಳನೇ ಇರುತ್ತೆ. ಏನೋ ಅದು ನಿಜವಾಗ್ಲೂ ಸರ್ಕಾರಿ ಗೋಮಾಳ ಇರುತ್ತೆ, ಬೀಳಿರುತ್ತೆ ಅಷ್ಟೇ. ಅಲ್ಲಿ ಏನೂ ಬೆಳೆದಿರಲ್ಲ. ಒಂಚೂರು ಪುರುಷಲು ಗಿಡ ಅದ್ರಷ್ಟೇ ಏನ್ ಬೆಳ್ಕೊಂಡಿರುತ್ತೆ, ಒಂಚೂರು ಗಿಡ ಮರ ಬೆಳ್ಕೊಂಡಿರುತ್ತೆ ಅಷ್ಟೇ. ಅದನ್ನ ಯಾರೂ ಉಳುಮೆ ಮಾಡ್ತಿರಲ್ಲ, ಗೊತ್ತಾಯ್ತಾ? ಅದರಲ್ಲಿ ಒಂದು 10% ಕೇಸಸ್ ನಿಮ್ಗೆ ಇಷ್ಟು ಸಾವಿರ ಬೀಳುತ್ತಲ್ಲ, ಒಂದು 10 to 20% ಕೇಸಸ್ ಜೆನ್ಯೂನ್ ಇರುತ್ತೆ. ಏನು ನಿಜವಾಗ್ಲೂ ಉಳುಮೆ ಮಾಡ್ತಿರ್ತಾರೆ, ಅವ್ರಿವ್ರ ಕಾಲಿಟ್ಕೊಂಡು ಅವನ್ನ ಅಲ್ದಾಡ್ಸಿ ಕೊನೆಗೆ ಏನೋ ಒಂದು ಆಗುತ್ತೆ ಅವ್ನು. ಮಿಕ್ಕಿದ 80% ಕೇಸಸ್ ಇದು ಹೋಗೋದು ಕಾರ್ಯಕರ್ತರಿಗೆ, ಸೋಕಾಲ್ಡ್ ಕಾರ್ಯಕರ್ತರು ಅಂದ್ರೆ ಚೇಲಾಗಳು. ಇದು ವಾಸ್ತವವಾಗಿ ನಡೀತಿರುವಂತದ್ದು. ಏನೋ ಇವಾಗ ಇಲ್ಲಿ ಏನಾಗಿದೆ, ಈ ಕ್ಷೇತ್ರದಲ್ಲಿ ಅಪೋಸಿಷನ್ MLA ಗೆದ್ದಿದ್ದಾನೆ. ಅವನ್ ಚಲ ಹೋದ್ರೆ ನೆಕ್ಸ್ಟ್ ಎಲೆಕ್ಷನ್ ಅವನೇ ಗೆಲ್ತಾನೆ. ಅದು ರೂಲಿಂಗ್ ಪಾರ್ಟಿ MLA ಹೋಗ್ಬೇಕು. Even he is not interested in the welfare of the landless agriculturists who are tilling the land over there. Nor you are interested. ನೀವೇನ್ ಮಾಡ್ತೀರಾ? ಅವನ್ MLA ಆಗಿದ್ದಾನೆ, ಅವನು ಕಮಿಟಿ ಚೇರ್ಮನ್ ಆಗ್ತಾನೆ, ಹಾಕೊಳ್ಳಿ ಒಂದ್ 8,000 ಕೇಸ್ ಅವ್ನ್ ಹೋಗ್ಲಿ, ಹಾಳಾಗೋಗ್ಲಿ. ನಿಮ್ ಡಿಫೀಟೆಡ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಹೇಳ್ತೀರಾ ಕಾನೂನು ಪ್ರಕಾರ ನಮ್ ಪ್ರಕಾರ ಅಷ್ಟೊಂದು ಪೆಂಡಿಂಗ್ ಇದೆ, ಇಷ್ಟೊಂದು ಪೆಂಡಿಂಗ್ ಇದೆ, ನಾವು ಹಾಕಿಸ್ತೀವಿ. ಎಷ್ಟು? 22,000 ಕೇಸ್ ಅವನಿಗೆ ಕೊಡು. ಅಲ್ಲಲ್ಲ, ಇದು ವಾಸ್ತವಾಂಶ. ಇದಕ್ಕೆ ಮಧ್ಯದಲ್ಲಿ ನಾವುಗಳು ನಮ್ಮನ್ನ ಇಟ್ಕೊಂಡು ನೀವು ಇಲ್ಲಿ ಗೋಳಾಡ್ಸೋದು. ಇದ್ರ ಮಧ್ಯೆ ನಿಜವಾಗ್ಲೂ ಸಾಯೋನು ಯಾರು? 20% ಏನಿದಾನೆ ಅವನ್ಗೆ ಇಲ್ಲಿ ವಾಯ್ಸ್ ಇಲ್ಲ. ಇವರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇಲ್ಲ, ಸೋಕಾಲ್ಡ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್. ನೀವು ಖಂಡಿತ ಅದ್ರ ಬಗ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ, ಏನ್ ಕುಣಿತಿದಿರಲ್ಲ, ಅದೇನು ಯಾರಿಗೂ ಗ್ರಾಂಟ್ ಮಾಡಕ್ ಆಗ್ತಿಲ್ಲ ಅಂತ ಅನ್ಬಿಟ್ಟು. ಆ 20% ಬಗ್ಗೆ ನಿಮಗ್ ಕಾಳಜಿ ಇಲ್ಲ, ಹೆಗ್ಡೆ ಅವ್ರಿಗೂ ಇಲ್ಲ.
ಅಲ್ಲ ನಮ್ಗೆ ಅವರು
4:50 ಐ ಥಿಂಕ್ ಐ ಬೆಟರ್ ರಿಟೈರ್ ಟು ಮೈ ಚೇಂಬರ್ಸ್. 5:15 ಫುಲ್ ಕೋರ್ಟ್ ಮೀಟಿಂಗ್ ಇದೆ. ಅರ್ಥ ಆಯ್ತೇನಾ? Come out with a solution which helps the
at
general
least ನೋಡ್ ಅವ್ರು ಈಕ್ವಲ್
ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್ ಮಾಡಿದ್ದಾರೆ, ಹೋಬಳಿ ವೈಸ್ ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್.
ದಯವಿಟ್ಟು ಆರ್ಬಿಟ್ರರಿ ಪವರ್ ಮಾಡಿ
come out with a solution
ಈಕ್ವಿಟಬಲ್ ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್ ಮಾಡ್ಲಿ. I'll also tell them.
where everybody will be happy. Will put the court seal and send.
ಬೇರೆ ತಾಲೂಕುಗಳಲ್ಲೂ ಇದಾವೆ ಕಮಿಟೀಸ್.
Listen, this is how it is functioning. ಕರೆಕ್ಟ್ ಹೆಗ್ಡೆ ಅವರ, ನೀವು ಅಟ್ಲೀಸ್ಟ್ 3ನೇವ್ರು ಇದಾರೆ, ಕೇಳ್ಬೋದು ನಿಮ್ಮನ್ನ. ಅವ್ರಿಬ್ರು ಕೇಳಕ್ಕಾಗಲ್ಲಪ್ಪ.
ಅಲ್ಲ ನಮ್ದೇನು ಅಂತಂದ್ರೆ ನಮ್ದು ಅಡಿಷನಲ್ ಕಮಿಟಿನಲ್ಲಿ ನಾವಿದ್ದೀವಿ ಈಗ. ಮೆಂಬರ್ ಆಗಿ ನಮ್ಮನ್ನ ನೇಮಕ ಮಾಡಿದ್ದಾರೆ. ನಮ್ಗೆ ಕೆಲಸ ಇಲ್ದೆ ನಾವು ಕೂತಿದೀವಿ ಈಗ.
ಅದನ್ನ ಹೇಳಕ್ಕಾಗಲ್ಲ, ವಿಡಿಯೋ ಬೇರೆ ರೆಕಾರ್ಡ್ ಆಗ್ತಾ ಇದೆ, ಇನ್ನೇನೋ ಇಂಟರ್ಪ್ರಿಟ್ ಆಗುತ್ತೆ.
ನಾವು ಕೆಲಸ ಇಲ್ಲದೆ ಕೂತಿದೀವಿ.
ಅವ್ರ ಬಗ್ಗೆ
ವಾಟ್ ಎವರ್ ಮೇ ಬಿ ದ
he is put to real loss. No, of all the three of you, he is put to real loss.
whatever may be the thing, my lords, in a democratic setup, in a democratic setup, any person, if he is have basic qualification, he is empowered to.
That's okay. Now you do.
Therefore, see, he cannot say that only defeated
identified
candidate
the
or
problem.
defeated MLA should not be made as a chairman. That
I
is.
have identified the problem. I'll call it day after tomorrow. You come up with an equitable solution. We'll record it and we'll close it. What do you say, Mr. Navadip?
ಆಯ್ತು, ಅವ್ರು ಮಾಡ್ಲಿ. If there is some, I'll also tell them not to precipitate. Ultimately, Lordships has observed, ಇದು public welfare is predominant ಇರಬೇಕು, but we will not compromise on that,
Yes,
irrespective of what happens.
Yes.
Only a question of law we had moved it.
With it. Additional committee ಯಾವಾಗಲೂ ಕಮ್ಮಿ ಇರಬೇಕು.
That is equally distributed now also.
ಮಾಡ್ಲಿ ಅವ್ರು,
Major portion is
ಮಾಡಿಲ್ಲ
allotted
ಅಂದ್ರೆ
to the first
ನೋಡ್ರಿ,
committee.
major cases to the first committee ಬೇಕಾದ್ರೆ ಅಬ್ಸರ್ವೇಷನ್
I
ಮಾಡಿ.
can.
Major portion ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಫಸ್ಟ್ ಕಮಿಟಿಗೆ
ನಮ್ ಕಡೆ
ಕೊಟ್ಟಿದ್ದಾರೆ.
figures
You
ಇದೆ.
do one thing, you file an affidavit to that effect straight up.
ಮಾಡ್ಲಿ, ಆತರ ಮಾಡಿದ್ರೆ
Special counsel ಆಯ್ತಾ?
Statement in our statement it is stated.
Additional advocate.
additional.
Sorry, additional advocate.
Oh, sorry, I didn't realize it. See, come out with an equitable solution which applies to all the constituencies in the state.
Notice, I
All
must,
the constituencies in the state, sir.
notice, I must, I don't know, without reference to Leonard Friend, Papa, over the, ಇದು ಹೊಸ device has happened now. In every constituency they have done it. Not it. Leonard Friend is, we have filed several petitions, but this is not something which is good. This is not expected of the government to do. Every constituency defeated MLA chairman, I mean, theoretically they may be right, but the exercise of the power.
That's the reason I told you, no.
In a democracy, they both opposition and they
Sir, ನೋಡಿ sir,
ruling.
at the-
They are equal. See, you can't say only in so far as the administration is concerned, ruling party administer. That doesn't mean that the opposition party don't have any say at all in a democracy.
Sir, it's all right. Now come up with a formula
cannot-
of equitable distribution with more preference to the sitting MLA. Give me the statistics, otherwise I will call for statistics of each constituency and I will compare the things headed by the sitting MLA of the ruling party and the committee is headed by
They defeated.
ಗೊತ್ತಾಯ್ತೇನೋ ಅದನ್ನ ಮಾಡಿದ್ರೆ ನೀವೇ ಸಿಕ್ಕಾಕಂತೀರಾ ಬೇಡ ಅದು
ಇನ್ಸ್ಟೆಡ್ ಗವರ್ಮೆಂಟ್ ಮಾಡಬಹುದು ಕೋರ್ಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಬೆಸ್ಟ್ ಸ್ವಾಮಿ ಅದನ್ನ
ಆ?
ಅವ್ರು ಕೇಳೋದಿಲ್ಲ ಹಿಡ್ಕೊಂಡು ಬರ್ತಾ ಇರ್ತಾರೆ ಅವರು ಅದನ್ನೇ ಮಾಡ್ತಾರೆ 4 ಸರ್ತಿ ಹಾಕ್ಬೇಕಾಗುತ್ತೆ
No, there are 3 petitions ಅಷ್ಟೇ ಈ ಪ್ರೆಸೆಂಟ್ ಇರೋದು.
ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್ ಮಾಡ್ಬಿಟ್ರೆ best.
Advocate General ಅವರೇ 3 petitions ಇವೆ ಅಷ್ಟೇ. We are nobody else. Only 3 petitions are there. In that, if
Like,
fair
applicable
distribution
in the-
happens, I don't want, even I don't want.
Did not even enlarge the scope now. It's only three
We should
additional committees are there. In so far as the 3 additional committees, see.
You do one thing,
See,
come up with a
a
formula.
proportional
To file
distribution.
an affidavit.
I don't
to
say
that
that
effect.
the majority should go to
To
one
file an
committee or
affidavit to
other
that
committee should be
effect,
deprived. At
So
least
that
some
their
basic-
interests are also taken care of.
Yes.
And my request to you, folded request to you, please take care of the real landless agriculturists who are tilling the land and who have genuinely made an application for grant of the land. That 10 to 20% voiceless persons who have not come before this court. Apart from you both sharing the whatever. Huh? Please take care of their interest also and devise a formula. You know, we'll approve it. ನಾನು ಹೇಳಿದ್ರಲ್ಲಿ ತಪ್ಪಿದ್ಯೇನ್ರಿ ಏನಾದ್ರು ಕರೆಕ್ಟ್ ಅನಾಲಿಸಿಸ್ ತಾನೆ ಹಾ ಅಷ್ಟೇ ಆಯ್ತು ಕರ್ರಿ ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಲ್ವಾ ಆ ಡೇಟ್ ಯಾವತ್ತು ಅಲ್ಲ ಇವ್ರದ್ದು ಡೇಟ್ ನಾಡದ್ದು ಹಾಕ್ಬೋದಾ
13.
Affidavit ಹಾಕ್ಬೇಕು.
ಅದು ಅಫಿಡವಿಟ್ ಹಾಕ್ಬೇಕು 13th ಹಾಕುವ ದ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ WAG:13th ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕಾ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಫೆನಿ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಅಪೀಲ್
ಅಲ್ಲ ತಾವು ಒಂದ್ಸತಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ನೋಡ್ಬಿಟ್ರೆ ಸ್ವಾಮಿ ತಾವು
Sir, can I call it day after tomorrow? There are office objections, please comply with it.
Can it not call it even tomorrow?
Sir,
Tomorrow, my lord.
tomorrow list close agide, sir. It's a fag end of the day, na? That's the reason.
Minor objections, so
And tomorrow also, I am told around 1890 matters are
only
listed.
thing is, property situated in a town municipality, Tahsildar gives a notice.
Day after tomorrow, I'll call, sir. We can dispose it off itself. Or we can dispose it off like that, only court fees and illala, deficit.
This notice came to be issued upon the directions of this honorable court only.
Your lordship will kindly say, directions cannot bind me because Tahsildar recommends this land can be converted. It is
I
on.
call it day after tomorrow, sir.
Very good.
Any harm, sir. I call on day after tomorrow, ಹಾಕ್ಬಿಟ್ಟು compliance of office objection by them. ಇನ್ನೊಂದು? Same.
Same.
Both
Same,
may be called
yes.
together.
Sir. Morning memo ಕೊಟ್ಟು. Sir, morning memo ಕೊಟ್ಟಿದೆ. Okay, sir. Matter 71 ಯಾಕೆ ಕರ್ತಿಲ್ಲ?
ಅದರ್ ಮ್ಯಾಟರ್ಸ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅವಾಗ್ಲೇ ಹೇಳ್ಬಿಟ್ಟು ಸರ್ ಮೂರ್ ಮ್ಯಾಟರ್
ಸರ್ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 81.
80 ಎಲ್ಲ ಅವೆಲ್ಲ ರಾಜೀವ್ ಗಾಂಧಿ ಇದೆಲ್ಲ 13
ಅಲ್ಲ 81 ಸರ್
81 13
ಯಾವಾಗ ಸರ್
13
ಈ ತಿಂಗಳು 13-12 ಅಲ್ವಾ?
ಹಾ
ತಗೊಂಡ್ಬಂದ್ಬಿಡಿ ನೋಡೋಣ. ತಗೊಂಡ್ಬನ್ನಿ.
ಅದ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಪ್ಪ ಅವರೇ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
ಇವತ್ತೊಂದು ಸರ್ ಇವತ್ತು ಹಾಕಿರೋದು ಒಟ್ಟು ಗೆಲ್ತು ಇಲ್ಲ. ಓಕೆ ಸೀನಿಯಾರಿಟಿ ವೈಸ್ ಮೆಮೊ ಎಲ್ಲ ಸೀನಿಯಾರಿಟಿ ವೈಸ್ ಹಾಕೋದು.
ಇಲ್ಲ ನೋಡಿ ಇದ್ರೊಳಗೆ ಇಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಲ್ ಇಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಲ್ ನೋಡಿ granted earlier is extended within the extended
ಮಾಡ್ತಾರೆ ಅದನ್ನ ಒನ್ ಟೈಮ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಇಂಟರೆನ್ಸ್ ಮಾಡ್ತಾರೆ. ನೋಡ್ತೀನಿ.
ಇದಕ್ಕೆ ಎಂಟ್ರಿ ಮಾಡಲ್ ಇಲ್ಲ. ಇದಕ್ಕೆ ಎಂಟ್ರಿ ಮಾಡಲ್
ಲಿಸ್ಟ್ ಆಫ್
ರೈಟ್ ಟು ಫೇರ್ ಕಾಂಪನ್ಸೇಷನ್ ಅಂತ
ಇದು
ಎಕ್ಸ್ಟ್ರಾ ಬುಕ್ ಇದೆಯಲ್ಲ
ಇದು
ನಿಮ್ಮ ಹತ್ರ?
ತುಂಬಾ ಇದೆ, ಇದು ನಾಳೆ ಕೊಟ್ಟು ಕಳಿಸಿ.
ಅಯ್ಯೋ ಆಗಲ್ಲ, ನಂಗೆ ಈ ಬುಕ್ ನನಗೆ ಬೇಕು. ಎರಡು ಮೂರು ದಿವಸ
ಮಾಡಿಕೊಳ್ಳಿ.
ಕೊಡ್ಲಾ ಕೊಡ್ಲಾ ಕಳ್ಸಲ್ಲ.
ಬೇಡ, ವೆಕೇಶನ್ ಜನವರಿ ಕೊಟ್ಬಿಡಿ, ಜನವರಿ. ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಕೊಡ್ತೀನಿ. ಇದೊಂದಿದೆ 74, ಇದು ಇದಿದೆ, ಇದು 74 ಕೊಡ್ತೀನಿ. ಎರಡೇ ಬರೆಯೋದು ಯಾರು ಏನು ಹೇಳು ಮೇಮನ, ಒಂದು ನಿಮಿಷ. adjourn, 71 adjourn. 70 after vacation, 71 after vacation, 73 after vacation. 74 list after vacation. ಎರಡೇ ನಾಟ್ ರೀಚ್ ಆಗಿರೋದು ಎರಡು, ಇನ್ನೇನು ಡೇಟ್ ಕೊಟ್ಟಿಯ ಆಗಿರೋದು ಎರಡು, ಎಲ್ಲ ರೀಚ್ ಆಯ್ತು. ಅಲ್ಲ ಅವ್ರು FR ನಂಬರ್ ಹಾಕ್ಬಿಟ್ಟು ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ನೋಡ್ಬಿಟ್ಟು